Yes. Original side mention.
Milad, may I minus kindly don't take me, Miss Milad. Milad, item number 16.
Of
My
the
lord, item number 16, my lord.
Yes, Milad. I'm led by Mr. Ray.
yes.
Milad,
What,
Milad, this is Milad. I am suffering Milad an ex parte Milad injunction passed by Milad the learned honorable single bench. Now Milad, this is the 1st August order. Milad, I have immediately ordered. So Milad, if Milad with some preference Milad or Milad kindly Milad, I am suffering Milad. It's an ex parte order. Milad, I immediately preferred the appeal. Milad, it was
none of the matters. There is no matter here which is not
the
urgent.
difficulty only Milad. If Milad have any other if Milad wait for 1 week, Milad the one extension already been done. Milad, we have informed the court.
Such an urgency. If you were
The urgency,
suffering without an interim order, that would be a great urgency.
no, I am suffering.
You are suffering an interim
I
order.
am suffering an intent that's past ex parte. Now Milad, they are also.
If you are without some interim order, then you could have understood. No, no, Mr. Lad.
Milad, may I?
My lord, it's an originating summons suit where, my lord, without any application
Without application.
for interim order. my lord.
Understood. Maybe very bad order. We shall set it aside also. But other matters are also urgent. If you are without an interim order, if you that would be a real urgency. We
And
would
the running of the trust is complete standstill
running.
of a trust.
Because interim order.
The trustees, my lord, have been directed. Please, have been
What is the injunction granted?
trustees. My lord, they are companies. The
What is
trustees
the injunction granted?
that they cannot or injunction on all their properties.
All.
The property
All properties.
should not be sold.
No, my lord, it is not that.
Every aspect.
Every company.
Every company. Four
I
companies.
can show the order, my lord.
What is that order? Let us see.
The-
That.
What is it?
16 নম্বরে ফাইলে
আমার এটা দাও না কোনো অর্ডারের কপি দানি
কিন্তু মেমোটা যেখানে অর্ডারটা চ্যালেঞ্জ আছে সিঙ্গেল জাজের অর্ডারটা যেখানে আছে মেমোটা ফটো
মে রিড ইট
জাস্ট চেক আপ ওই তো মেমো ঠিক আছে এটাই
মানে without any application on the day originating someone's suit is filed, my lord, says that
party with the assets of the
yes, well, this is a trust, my lord.
Oh, it-
Even originating someone's suit
including the amounts lying in the bank account.
in a
Bank account, the bank without the bank account it cannot be operated,
Assets which they have inherited.
no, my lord,
including the amounts lying in the bank account.
everything.
This will appear at the top next Friday week. It has to be
Whenever you're
Friday week at the top.
Wednesday, my lord, it's
Wednesday week at the top.
and if it is called, my lord, I'll be here. But if it's not called, my
Wednesday
lord,
week at the top.
I'm very grateful, my lord.
Even if it is called on, we shall not take up and will.
My lord, I'll keep it Wednesday, next Wednesday, my lord. Wednesday.
Oh, sorry, next Wednesday. We were on the premise of Friday. Next Wednesday at the top thagbe. Next. Yes.
Lordship,
Mentioning
Lordship,
No,
item
original
1,
side.
Lordship, I am
Appellate
for
side
the
mention
response.
at 2 when you take up their appellate. Yes.
Lordship, item 1, I am for the Lordship.
You are-
Item 1,
Yes, Mr. Kumar, you are mentioning some original side matter.
yes, Lordship. Item 1, Lordship.
Item 1, Acha,
Yes, sir.
not mentioned.
Yes, I have on behalf of the edit petitioner respondent. The matter has appeared before my lord at the instance of the appellant.
Let them speak. Yes. Yes, you are
Lordship,
excellent.
extension of time for filing paper book, Lordship. There are 900 pages at 10 volume, Lordship. Problem is, Lordship, 3 weeks time may be granted. Lordship.
Extension of time for filing paperwork.
Lordship.
The appellant seeks an extension of the time for filing paper books in view of the voluminous papers involved. Full stop. Upon hearing learned counsel for the parties, comma, the time for filing paper books is extended till
Well, I give a short time.
अरे आप vacation हो जाए
September 24, 2025. 3 weeks.
Kindly fix up a date of hearing, my lord. It is already delayed. They have
The matter shall be listed for hearing in the monthly list of November 2025.
I may want to file my opposition. Opposition to say application, they have filed their reply also.
You have given a copy. We'll take it when you take up the matter.
They have filed their reply. So I may file the opposition.
They have already filed their. They have given you a copy. How could they file?
Yes, I have some copies. They have filed.
When
their
the
reply.
matter is taken up, we'll take this. Next. নভেম্বর মান্থলি লিস্টে থাকবে এটা। হ্যাঁ 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 ইয়েস
Reply.
ইয়েস তুমি আমার নোটস গুলো দাও একটু, ওখানে রেখে দিলে কি হবে? এটাই। আর পেপারস গুলো কাছাকাছি দিও। এটা পেপার বুক আছে? হ্যাঁ পেপার বুক আছে, তাহলে যখন বলবে যেটা সেটা। Yes.
On the last occasion, I had told your lordship some 10 basic facts of the case. I had given my submissions on the interpretation of the relevant entries in the
You're too tall for the microphone. Please take the microphone a bit up. Yes.
Yes.
Thank you.
Yes, I'm grateful. So, I had the 10 basic facts I had provided. Then, I had given my interpretation on the relevant entry to the 7th schedule, and I was on the facts as they appeared regarding the 3 companies. Now, some facts I had placed, but since we are continuing after a week, may I just recapitulate those facts in a
nutshell, Mr. Devan, because every week this will happen otherwise.
Yes, in a nutshell, of course.
For us only you are doing it. We understand that.
No, this would take no more than 3 minutes. So I will just. First fact is, I had on the last occasion showed the affidavit of evidence of late Shri B.D. Bhaiya, where he had said that I had formed the company Chem Crown India Limited, which is the earlier name of SSS MIL. And in that sense, it was the flagship company which was first incorporated, and the company CNE came much later. That is fact number 1 of the incorporation of SSS MIL by him. Fact number 2 is that the registered office of SSS MIL and of CNE being a party to the arbitration, is the same. Plus fact number 3, that the initial subscribers of SSS MIL, as per the articles and memorandum of association, was inter alia late Mr. B.D. Bhaiya. That's fact number 3. Fact number 4 is that at the relevant point of time, Mr. B.D. Bhaiya's daughter and son-in-law were directors of SSS MIL. So his own close relatives were directors of SSS MIL. Fact number 5, there was one more director, namely one Mr. Rajiv Issar, who I will now presently today show, was an executive, namely employee of CNE. So you now have a company SSS MIL in which out of the board composition, 2 people.
Rajiv was the director of SSMIL?
Yes.
And employee of.
Yes. I will just show those page references. So you have now 3 directors who are connected to either Mr. B.D. Bhaiya, late Mr. B.D. Bhaiya, or are otherwise connected to CNE.
Employee means in what capacity? Employee of CNE?
The evidence on records uses the word executive. It says, I will just show those pages, but it says executive of CNE. Now, what exact designation he was holding, perhaps not come on record. And I had shown, lastly, the shareholding composition of SSS MIL, which was a listed company in which the promoter and promoter group together were the largest block of shareholders, holding approximately 36% shareholding in the company, of which almost 25% was owned by a company called BG Chemicals. Those are the facts that I had shown on the last occasion. Now, your lordship will now, just for my satisfaction, just have a look at the company master data of SSS MIL once again. That's at volume 6, page 718.
Yes.
Yes. So I had placed this on the, I'm sorry, your lordship has that, Manoj?
Yes.
So I had placed it. Now, Manoj, your lordship has the registered office address. Perhaps that would have been marked on the last occasion.
Everything marked, right.
The email address is also very important. Your lordship has marked it company secretary at cel.co.in, CEL being CNE. So to the MCA,
Hmm.
the address given is of the company secretary of another company, not your own company. You're saying that if there is any official correspondence, etc., to be received, company secretary of CE must be marked. That is what that's what the implication of this is. Now, on the list of directors on the same page, Lordship will see Rajiv is sir, first name, and
That
your
is
Lord,
the employee, and
that's the employee.
Mukund and Renu are the daughter. and son.
Absolutely. Mukund Bhattar is the son-in-law, Renu Bhattar is the daughter. Now, that's what I placed. Now, the shareholding pattern, once again, just the relevant pages, because that's at volume number 10. And the shareholding pattern becomes a little relevant because one of the arguments of the other side was that they are shareholders very well. They said, even I am a shareholder.
Hmm.
So it was said by Mr. Mukherjee.
Yes.
So I want to clarify that. That's a very important factual point. Now, so in volume 10, your Lordship will come to page 1353A. Perhaps I'm sorry.
13, I'm sorry.
But it's 1353A. The 1353A is a typed copy.
Yes.
Now, your Lordship has perhaps marked it.
Yes.
Promoter group 35.42. Public is 64.58. So
Right.
apart from the promoter group, the only other group is the public. Now, public in a big company, it will be my submission that where the promoter group is the largest and the rest of the shareholding is public, the promoter group is effectively having control over the company.
Public is not an organized body.
Absolutely. It's a diffused body. Now, 1355.
Yes.
In fact, 1355A is a typed copy.
That was also placed.
Yes,
Right.
that was also placed. So the individuals are holding 9.67. Your Lordship has that, which is all the Bhaiya group members. Then there is any other entities 25.75. Please make a note, my lords. This is BG Chemicals, the other company. Now, my lords, kindly turn to 1356A.
9.67 is the family of this.
Is the family of BD Bhaiya, late Shri BD Bhaiya. Now, please, my lords, BD Bhaiya himself is not a shareholder. His family members, his wife, other cousins, brothers, wife, etc. hold. Now, that the fact that BD Bhaiya is not a shareholder is also relevant, as I will now very shortly point out. 1356A was something that I had not shown on the last occasion, and your Lordship will see this is a in that column, in that row which says A1, individuals, shareholders holding nominal share capital of up to rupees 2 lakhs. We fall in this category.
You.
Yes, we. So the Bagri group falls in this category. So our shareholding at any point of time did not exceed rupees 2 lakhs in the company. So yes, we were shareholders in the public category holding less than 2 lakh rupees. Not a part of the promoter group. In the public category, persons who are holding less than 2 lakhs is where we fall. When I say we, I mean Gopal Das Bagri and the rest of his family members. Now, one other thing I had shown on the last occasion, I will not again show it today, is that your Lordship will perhaps recollect, there is an order of the Madras High Court in a writ petition filed by SSSMIL, where the authorized signatory was the son of late Mr. B.D. Bhaiya, that is Mr. M.K. Bhaiya. Manoj Kumar Bhaiya was the authorized signatory of SSSMIL. That I will just give the reference. I will come to this page in a different context. The page number is volume 6, page 720. So even the authorized signatory of a listed company happens to be late B.D. Bhaiya's son, Mr. Manoj Kumar Bhaiya. Now, my lords, since your lordships were last looking at volume 10, may I, my lords, now show where in this share capital BG Chemicals comes. That's at volume 11, page 1419. volume 11. Volume 11. देखिए.
Yeah.
Wait, no. 1419. Because this is a continuation. I'm sorry, 1419. This is a I'm sorry.
1419.
14. I'm so sorry, Malad. I should be a
No,
little
no.
slow.
When people come with either folded hands or folded papers, both are difficult for the court.
Yeah, well,
We deprecate folded hands, but folded papers have to be. 1419, yes.
yes. Now, this is the continuation of the shareholding structure
Yes.
of SSMIL, and Lordship will find the name of BG Chemicals, which itself holds 25.68% shares. And there is one more company called Chemcrown Exports Limited, which is holding 0.08. So we reach the figure of 25.75, which is the figure that I shown on the earlier page, as body corporates holding 25.75 together, of which BG Chemicals itself holds 25.68% share. So if one was to say loosely, who is the biggest shareholder of this company, or who was the biggest shareholder, it would be one shareholder, namely BG Chemicals. Even if we ignore all the individuals, one shareholder itself, BG Chemicals, is 25.68% shares. Now, Malaz, on Mr. Rajiv Issar, because that's the reference of him being an executive, comes from BD Bhaya's own affidavit, volume 12. Well, I must again apologize. There will be a little back and forth with the volumes.
Yes, no difficult. Page?
Malaz, this is page 1473.
This is Mr. Bhaya's affidavit.
This is Mr. Bhaya's affidavit. Just tell me, where does it start?
Affidavit in respect of in which matter?
In the arbitration.
Oh,
It starts at 1461. It starts at 1461. I am only looking at the relevant paragraph regarding Mr. Issar.
yes.
Plus, may I read paragraph number 45?
45.
Yes. Now, your lordship will perhaps recollect when I was in my opening, I had said that one of the disputes between the parties.
45 is in 1473.
1473, yes.
Right.
So, one of the disputes between the parties was that some of us, or the Bagri group, they claim were sent to China and we did some parallel business, etc., etc. So, 45 is in that context of the China visit. Now, may I read it slowly? In the second week of October 2011, I, which is late Mr. Bhaya, along with Mr. B.K. Bagri, an executive director of the company, visited China and held meetings with I.K. Bagri. I.K. Bagri is the son of G.D. Bagri, which is my side. On 13 October 2011, Rajiv Issar, an executive of the company, joined us at such meeting. So Rajiv Issar certainly has been an employee of CNE. Now this company here is to CNE. The reference of the word company here is CNE. So when the disputes between the parties started and there was a move to perhaps meet up and sort it out, 3 people traveled from India to China. Late Mr. Bhaya traveled, Mr. B.K. Bagri, an executive director of CNE, traveled. Yeah. So B.K. Bagri is not part of us. This B.K. Bagri is from their camp, not from our camp. Perhaps that's the confusion lordships are having.
No question, confusion. We are sure that he was your camp.
No.
It's good that you have mentioned.
No. So this Mr. B, this
You are now labeling, classifying Bagris and Bhayas.
No, I'm not.
Whichever Bhaya we find in Calcutta, we classify.
No. Because I was only pointing out that this Mr. B.K. Bagri had actually given evidence on behalf of the claimants, which is CNE, in the arbitration. So 3 people traveled, Mr. B.K. Bagri, late Mr. Bhaya, and Rajiv Issar, who was an executive of the company. I don't know from the record what designation he was holding, but he has been referred to as an executive of the company. Certainly an executive of the company from 2011, because that's when he traveled. Now, this person is reflected as a director of SSMIL in 2019. So, two possibilities are there. Those facts are not on record. Whether Rajiv Issar continued to be an employee from 11 to 19,
May or may not be.
may or may not
But
be.
at
I
least
can't.
2011 he was.
He was. So at least, at the very least, Rajiv Issar was a former employee. At least, even if I understand from that he's even still an employee. But let me assume against myself, I'm saying at least a former employee of CNE is a current director or was a director of SSMIL at the relevant point of time. Now comes one very interesting feature of this factual narration, which is about one Mr. Arindam Haldar. There are other references also, about Rajiv Issar. The same references. I'm not bothering your lordships with that. Now, Mr. Arindam Haldar. Now, Mr. Arindam Haldar is the legal counsel, the in-house legal counsel for CNE. That reference will come from the other appeal, APOT 343. Your lordship,
Legal counsel of
CNE. So the Mr. Arindam Haldar was and is in-house legal counsel of CNE, the appellant today, and a party to the arbitration.
You find that at which volume and page of and which number, APO number?
This is APOT 343, and this is which volume number is this? This is volume number 7.
343. The current number is probably 184.
In the other appeal, so your lordships are looking at 342. Please take up 343.
184. So, just give us the volume and page. We will multiply on a table right now.
Yes.
Unless you say
Only this is actually
take your word. Yes, for that.
It's APOT 343. This is volume 7.
Please ask your learned junior to just take a note of the current numbers, APO numbers from the list, so that the references will be.
I will give that relevant page number. Your lordship will take it. I have seen myself.
Right.
That page is the LinkedIn profile. So you have a LinkedIn. It's a LinkedIn profile of Mr. Haldar, where he shows that he's the in-house legal counsel of CNE from 2011 onwards.
Right.
Now, this Mr. Haldar, as I will show from the order sheet of the matter in which the learned arbitrator had appeared, had instructed the learned arbitrator for SSMIL. Now, that page number is
LinkedIn profile is of it's contemporaneous or current.
Well, it shows from 2011 till continuity. So it's
when was the web page that page taken from?
When was that LinkedIn page taken?
LinkedIn page.
It was taken when the section 34 was filed. So
around which year?
So this would have.
Oh, when the section 34 was filed.
When the section 34 was
continued through the.
There is no dispute. Also, he is even today appearing. I will show other references also. Mr. Haldar, as I understand, subject to correction, is even today, Malons, the in-house legal counsel. My friends can correct me if I'm wrong.
And you please repeat that he had a conference, or he
instructed the learned arbitrator on behalf of SSMIL in the matter where the learned arbitrator had appeared.
This is during the pendency of the arbitral process?
Yes. I will show those records. The LinkedIn profile says, I have it now, the relevant page. It's page 632 of the other appeal 343. Yes. Now the LinkedIn profile says, it's volume 5. Volume 5, page 632.
Right.
LinkedIn profile says Arindam Haldar, legal consultant as Sual Fisio. So, anyways, I'm just showing it says legal head CNE April 2011 for the next 9 years. So it says so and so. So this must have been taken sometime in the year 2020. Now, Malods, the page number where Malods he appears also for SSMIL, that's at volume 10 of the current appeal. Volume 10, page 1337. So your lordship has that, my lords?
Yes.
Now, my lords, your lordship will see this is the APD 252 of 2015, SM Chemicals versus Standard Sole and Mold, which is SSSMIL, heard on various dates for the respondent, and your lordship will find the name of the learned arbitrator, the late learned arbitrator on top, and the sixth name is Mr. Arindam Haldar. This judgment came out on 13th of February 2019 is the date of the judgment, which as per his LinkedIn profile shows that he was a legal counsel of CNE at this point of time. And simultaneously, the same Mr. Haldar was appearing as an in-house counsel before the learned arbitrator also, which will become clear from volume 5, page 627. Your lordship has 627, my lords. This is an order sheet in the arbitration. The date is 3rd January 19. Third name is Mr. Haldar, advocate for the claimant. Now, this is not what I wish to make clear is sometimes advocates do appear. So you may be doing an arbitration with someone.
In-house advocate, that
Exactly.
takes a different color.
Absolutely. Now, please now see this fact.
How did the LinkedIn profile, was it produced as evidence or
It was
standard in evidence?
This point has been taken. This is being taken, but this was not addressed in the trial court below.
No, the LinkedIn profile that web page was.
34 record.
It's a part of the 34 record.
It's part of 34.
You are disputing that it's a part of the 34 record.
I'll just check and then we'll confirm.
Check it out.
That's it.
Anyhow, so it doesn't matter. It's
Both of you check up, no difficulty.
My instructions are it is a part of section 34 record. It was placed before the learned single judge. So, yes, I'm told the whole section 34 record is also here. Volume 5 can be taken. My friend tells me that.
No,
So
very
it's
well,
part of
yes.
the record. Now, there are two important conclusions which come out of this. One, that you have one company's legal counsel instructing an advocate in another company's matter. So that shows interconnectedness, that shows intimacy of operations, that shows a group-like structure, that shows an affiliate-like sibling corporation structure. And this is apart from the other legal team. I'm not for a moment saying because the lawyers were also common in the APD 252, but forget the lawyers. Let's only focus on the in-house legal counsel. So conclusion number one, this shows how the companies are operating. But more importantly, what it shows to a reasonable mind who has the entire backdrop of facts, the test that the Supreme Court tells us in HRD, is that would a reasonable person in knowledge of all of those facts, would that person have a justified apprehension that there is a likelihood of the arbitrator not entirely going by merits? In my respectful submission, this fact alone shows that. Because you have a matter in which someone is an arbitrator and you are appearing for one of the parties, and in another matter, the same in-house legal counsel is instructing the learned senior advocate. Now, my lords, some of the pleadings in the section 34 petition. I want to in particular show the affidavit in opposition, which was filed to my section 34 petition. And my lords, that starts at volume number 7.
He was in-house counsel of
CNE. CNE is a claimant in the arbitration.
Yes, therefore he appeared for CNE before the arbitrator. That we can understand.
Correct.
But he had appeared for SSMIL along with the arbitrator.
Yes.
We can understand that if it was the other way around, we could have understood. Suppose he was the in-house counsel of SSMIL.
Yes.
Then, CNE is a party. Right. All right.
No, so which is why I said two different points. The first point is in which natural course of things would you have? So if your company has a matter, a listed company, let's assume a listed company has a matter Typically, you would have your own legal counsel, a legal team, which will be part of the matter. But Triple SMIL is a listed company, but who is instructing the advocate or who's appearing is counsel of another company.
But Mr. Devan, this is not such as, I mean, what I mean to say is that suppose some in-house counsel appear for Bhaiya and C and D, in-house counsel of say Bhaiya and C and D before the arbitrator, right?
Yes, correct.
So he's appearing.
Yes,
So arbitrator hears him.
correct.
And at the same time, simultaneously, he's not the in-house counsel of the SSMI.
Correct. But yet he chooses to instruct Triple SMIL in a matter. So how? Under
He
what
appeared
authority?
with so many people appear with counsel.
But in-house counsel. So it is
No,
an advocate.
he was in-house counsel of C and D, so he
C&D.
appeared before the arbitrator, we can
So
understand.
no problem. So
But if
of
he was
course
in-house of both, we could have understood.
no, he is not.
But Triple SMIL, he appeared as one of the counsel along with
So that's my question words in my
maybe a
respective submission.
good advocate
So-
in company matters or
Well,
whatever.
Can
this
an
is,
in-house
commercial.
counsel for one company appear for another company's matter? When would that happen? When the two companies are joined at the hip. In-house counsel of one company can appear for another company, but that can only happen if the two companies
But
have
for
a
that, we
comfortable.
require further details regarding, because he has advertised himself as an in-house counsel of a company.
Manoj, I will show
in
two more
LinkedIn.
references.
In-house counsel has various shades and connotations. In-house counsel may be a retainer also,
I
the
will
nature of a
show- I
retainer,
will show
or he's
from
an employee, we have to see.
Manoj, I will show two more references. I will come to that. Two more references of Mr. Haldar's name in the arbitration record. In a moment, I'll come
No,
to
in
that.
arbitration, he's appearing for C&D, no doubt on that.
As to what he is described as Mr. Haldar, how is he described in the pleadings in the arbitration? He has been called an in-house legal officer of CNE. So someone who is in
That would be relevant.
Yes, I will show. I will show in a moment.
Sir, he is also legal consultant to
Of
Chem
Chem Crown.
Expert, which is the other
Shareholder.
department.
So the LinkedIn page, my friend, is right. Also,
LinkedIn says officer,
LinkedIn says legal head. LinkedIn
in-house
uses
legal head.
yes. The LinkedIn shows legal head. It also says legal head CNE Limited. It's the same. It's page number 632. The other APD. Look at the other APD. So this is part of the other appeal, as I said. And at the same time, he's also the legal consultant for Chem Crown Exports on the same page. So there are two entries simultaneously. He's holding two positions. I'm quite all right with that.
SMIL and Chem Crown are.
So Chem Crown not Triple SMIL, Chem Crown Exports.
Oh, exports is different.
Exports is different.
Which is the
If this doesn't disclose being a legal head of Triple SMIL.
Understood.
If it would have disclosed, by the way, that still fact inures to my advantage because you have a same legal counsel for two companies. All that I'm trying to establish is an affiliate connection. Ultimately, at the end of the day, the burden of my argument is that these are affiliates. So, which is why I said there are
If he
two.
was not legal head, Mr. Devan, we would not be so,
No, legal head of CNE appearing in
yes, legal head of one would
exactly. That's the point. Legal head of one appearing for another company in another matter.
We have a point there. Yes.
That's the point I'm trying to now. But
Yes.
I'll show other references of Mr.
If
Haldar.
he was counsel of both companies, nothing happens.
No.
Obviously, legal head has a different connotation.
Yes.
Right.
Yeah. I will
Understood.
show
Understood,
other-
Mr.
I'll show other
The
relevant-
point is taken. We
Now,
understand.
volume number 7. Now it is volume 7, page 873 is where the affidavit of opposition to my 34 begins.
Yes.
The relevant paragraph is paragraph H at the bottom of 882. You have the submissions? Yeah, na? Your Lordship has bottom of the page 882, paragraph 8.
Yes. H.
Well, may I now read this? Just 2-3 paragraphs I wanted to show. It is stated herein that the learned arbitrator has appeared. This is what they are saying. for appear for a company, namely Standard Sole and Mold in APD 252. Respondent number 1 is a shareholder in the said company along with the petitioners numbers 1 to 4. Now, please stop here for a moment. Respondent number 1 is a reference to late Mr. Bhaiya. What they are saying in the affidavit is respondent number 1 is a shareholder. He's actually not a shareholder. I had, when I was placing that shareholding structure, BG Chemicals is a shareholder. Chemcrown Export is a shareholder. Other 106 individuals are shareholders. BD Bhaiya is not a shareholder. So I believe with a sense of being candid, they have said, because effectively he is the shareholder, commonsensically. I'm using the common sense doctrine now against the appellants here.
Yes.
So they say he is the shareholder, although by the way, he's not a shareholder, along with petitioner numbers 1 to 4, which is us here, which, as I said, we were holding shares less than 2 lakh rupees. It is stated herein, learned arbitrator did not appear for CNE Limited and or Bulakidas Bhaiya in any of the matters during pendency of the arbitral proceedings. Neither the said arbitrator had advised or had conducted any conferences for any matters relating to CNE Limited or Bulakidas Bhaiya personally. It is a matter of fact and records that Standard Sole and Mold is a company limited by shares, and along with Bulakidas Bhaiya, again it comes, along with Bulakidas Bhaiya, the petitioners are also shareholders. Now please mark this line. It is further stated the company is a public limited company and was not wholly controlled by Bulakidas Bhaiya. So what we have is a statement on affidavit saying that this SSSMIL was not wholly controlled. What I understand from the word wholly controlled is that, well, he had some control as per
No, we have to look at your statement, relevant state. Oh, this is not a denial statement.
This is their affidavit
of statement. No, on opposition, you might have made that statement. They might have denied that.
Yes.
But this is not a denial statement.
No. This is their affirmative statement. So what it actually shows is, as per them, SSSMIL was not wholly controlled. But well, there was some control perhaps, but as per them, not wholly controlled. So that begs the question. If Bulakidas Bhaiya was not in wholly control, then who had the control over the company? Is the suggestion that the public had control? It's not clear. There is no answer coming to that. Because as per them, not wholly under control, which means someone else must be exercising control. Who that someone else is not identified here in this paragraph. But they normally make a statement not wholly under control. Yeah. So there is, correct, as my friend says, there is some element of control which comes out from this pleading itself. Now, the next paragraph, denied the learned arbitrator had continued to appear for R2 or for companies owned, managed and controlled by him in other legal proceedings, even after commencement and continuation of arbitral proceedings. Denied that by any reason whatsoever attributing to the conduct of the arbitrator, the mandate of the said arbitrator stood terminated, etc., etc. I don't need to...
This is general, yes.
This is general. Now, and then in the next page, 884, there is a paragraph M which comes.
Yes.
No particulars of fraud have been pleaded nor exist. Significantly, the petitioners have suppressed the fact that the petitioners themselves are also shareholders in SSSMIL and were at all material times well aware, and deemed to be aware, that the learned arbitrator had appeared in such matters. That is the other statement they make. And plus, that's really what I wanted to show in this, except there is perhaps one other paragraph which comes. Plus, your Lordship will just give me 1 second. No, that's it. From the affidavit of opposition, that's the wholly control bit. And the fact that they themselves at 2 places at the very least have said that late Shri Bulakidas Bhaiya was a shareholder in the company, which as a matter of fact, he was not personally. Now, Maloj, the other company comes. So now we have, I am done with all the facts regarding SSSMIL. What did it say?
Only one thing, I just checked up the other 34. There is no ground per se of the appearance of in-house legal counsel in any of the 34. That was
of the appellants?
Of the appellants, the ground which is being urged Mr. Arindam Hasdar is an in-house legal counsel. That was not the ground in section 34 in both the matters. It's making for the first time here.
Now, Manoj, the answer to that straight away, the language of 34.2. I am not checked up whether there is a ground or not, but let's assume there is no ground. Let's just read 34.2a. 34(2) first. An arbitral award may be set aside by the court only if party making the application establishes on the basis of record of the arbitral tribunal that. So I have to show something, I can make out a ground on the basis of the record of the arbitral tribunal. Here, this fact could have only come to light much later, because this issue of bias was not there before the learned arbitrator. So therefore, on the basis of subsequent documents, for bias, I have to show other documents. I can't really do so on the basis of the arbitral record itself. So, and in any case, yes, my friend now tells me at page 16 of the section 34, second matters paper books, I'm reading a statement. It says, if there is written, the text is, one of the advocates of R1, Arindam Haldar, is also the legal head of R1. Screenshot of his LinkedIn profile is annexed here to and marked G. So it is anyways pleaded. But for a case of bias, in any case.
So Devan, please remind us why two appeals?
Sorry, which one?
Why are there two appeals?
There were two section 34s which came to be filed.
By two different people.
Two different people. One was filed by Mr. Bagri.
Yes.
The other one was filed by a company called Feather Touch. There was also an award against that company. So two section 34s, therefore two appeals now, but disposed of by a common judgment of the learned single judge. Now, let's BG Chemicals. That's it. Now, BG Chemicals. Now, BG Chemicals, the list of shareholders, which is BG Chemicals, I am reminding your lordship respectfully, was the largest shareholder. Your lordship remembers of SSSMI. Now, this comes at volume 11.
Yes.
Page 1429A. So 1429, my lords, is the original copy, but it's not very visible. So 1429 is the typed copy.
Yes.
Now, this is the list of shareholders as of 31st of March 19. There is no promoter group shareholding. Other shareholders are Bulaki Das Bhaiya, 80 shares, Gauri Shankar Baldevan, 20 shares, Ganga Devi Bhaiya, who's the wife of late Mr. Bulaki Das Bhaiya, 8,000 shares, Bulaki Das Bhaiya HUF, 1,900 shares, adding up to 10,000 shares. So, late Mr. Bhaiya, along with his wife and the HUF, virtually had 99% or 95% shareholding of the company, of BG Chemicals. Just exclude for a moment Gauri Shankar Baldevan's name. So your lordship will find that about 10,000 minus 20.
Was Bulai Das Bhaiya? One.
So that's Bulaid. So it's Bulaki only. Sorry, typographical error. Your lordship will perhaps just kindly come back to the original at page number 1429. So it's actually Bulaki Das Bhaiya. Maybe it's in the process of typing there is an error. So they are together almost holding over 95% shareholding of the company. Now, your lordship will now come to page number 1432. In fact, before that, 1431. This is an MCA form. And this is a form called form number Ben 2. I'm sorry. Yes. Form Ben 2. And underneath that is a notation which says pursuant to section 90 bracket 4 of the Companies Act 2013. Now, section 90 of the Companies Act was a later addition to the Companies Act, where a company has to disclose who are the significant beneficial owners. That's the provision of the Companies Act. Now, in this Ben 2 form, which is 1431, starts at 1431, kindly turn to 1432. Yes, may I just please, in fact, read section 90 of the Companies Act so that there is a context. I'm only reading it. It's
2013. Yes.
Yes, now section 90. Let me read one first. Every individual who acting alone or together or through one or more persons or trusts, including a trust and persons resident outside India, holds beneficial interest of not less than 25% or such other percentage as may be prescribed in shares of a company, or the right to exercise or the actual exercising of significant influence or control as defined in clause 27 of section 2 over the company, hereinafter referred to as significant beneficial owner, shall make a declaration to the company specifying the nature of his interest and other particulars in the manner and within such period of acquisition of the beneficial interest or rights and any changes thereof as may be prescribed. Now please come to 4. Every company shall file a return of significant beneficial owners of the company and changes therein with the registrar containing names, addresses, and other details as may be prescribed within such time in such form and manner as may be prescribed. So this, what your lordship sees at page 1431, it is this return referable to section 90 bracket 4.
Yes.
Now please kindly turn to page 1432. Come to that 1432, and in the middle of the page, your lordship will see serial number E, particulars of significant beneficial owner.
Yes.
Name Bolaki Das Bhaiya. So two things for BG Chemicals. One, I have shown the shareholding structure. So the shareholding structure shows he, with his wife and an HUF, have over 95% share, almost 99% shares of this company. And he is also disclosed as a significant beneficial owner of this company. And this return was, of course, filed under the signatures of the director of the company at 1433. So return has to be authenticated by some responsible officer. So that is 1433. And on the same page 1432, the email ID is bdbhaiya@cel.co.in. So, which is, everyone seems to be using the domain ID of CNE. That's perhaps the way it operates.
91 के context में,
No, it's just 1 second.
91 के context में ये जो form है 1.1, this is addressed to triple asset, single asset. There is Ganga Devi Bhaiya through BG. It's a triple asset. But then, yeah, but it's Ganga Devi Bhaiya, not him. I know. But the point is, after
Can I discuss with you when the judge raises it at 12? I'm sure. Let me discuss. Yes, now, my lords, the last company of this group.
Mr. Diwan, the CEL.co.in is not generic in any sense.
No, it's Component and Equipment Limited, CEL. The full name of CNE was Component and Equipment. So CEL is that. Yeah. So we have a website also of CNE. So it is that, the name of CNE. Yes. Now, my lords, comes CNE itself. So I've shown Triple SMIL, BG Chemicals. Yes. I've shown now CNE itself. Now in CNE, I may only show again the affidavit of late Mr. B.D. Bhaiya, because it is not in dispute. He was the executive chairman of CNE, and he, together with his family members, was holding 65.02% shares of CNE. That comes out from late Mr. B.D. Bhaiya's affidavit, which is at volume 12. Just kindly give volume 12. Achha hai. Okay.
Volume 12.
Yes. Now it starts at 1461.
Yes.
Your lordships perhaps would have marked some other paragraphs at 1461 where it started. But now, I'm showing two other paragraphs.
Yes.
1465. Paragraph number 15.
Right.
In the year 2005, I was appointed as the executive chairman by the board of directors of the company. So that is his own statement. And paragraph number 17. The company, may I read this? The company, in accordance with its business requirements from time to time, issued further shares which was subscribed by both the groups. Now, both the groups are the Bhaya group and the Bagri group. Presently, the paid up share capital of the company is so-and-so divided into so-and-so, out of which Bhaya group is holding 19 lakhs 21,000 odd equity shares, constituting about 65.02% of the paid up share capital. Bagri group is holding 10 lakhs 33,000 equity shares, holding 34.98% of the paid up share capital of the company. So his group, therefore, now it's very important, is his group. So even when it comes to CNE, I'm sure there are other people of the family who are holding, but he himself calls it a group. He says, my group is holding 65.02% shares of the company and we are holding 35. Now, this, of course, was a matter which was for consideration of the learned arbitrator as to whether they should get an order to buy me out of the company. And eventually he did pass that order. This is, we're talking about CNE here. Now, I've read it. I've read last time. I've read it last time. Now, my friend, your lordship, but I was marked it 1461 of the same.
146?
1461, where it starts.
Yes.
I had on the last occasion read paragraph number 3.
Yes.
In or about 73, I had formed a company known as Chem Crown India. I don't know if your lordship has marked it or not. I had read on the last occasion that this is a Chem Crown is SSSMIL. Yes, I'm great. Yes. So now, my lords, these are the facts regarding the three companies which I have placed. Now, I'll summarize the facts when I come to my submissions.
Yes.
But your lordship now has, my lords, I believe, a fair idea of the way or the basic facts regarding the three companies. Now, my lords, after the last hearing, we checked up the arbitral record again to see if we could find something more. Because your lordship today has a section 34 petition. There is the arbitral record, which is also, I am told, now in the court because we perhaps made an order for production. From the arbitral record, so documents before the learned arbitrator, some other interesting facts have also come to light. Those facts may not be part of the section 37 petition which your lordship has. Those perhaps may not be part of the 34 petition also in that sense as a part of the annexures. But filed as paper books in the 34. Okay, but my friend said, so these are some 77 volumes of the arbitral record, which were a part of the section 34 record. So not outside the record. We are now on the arbitration record, which as per 34.2, which I just read, the court can consider. Says court finds from the record of the arbitration.
34 court can consider, but you had to take that point in 34. For if the court did not consider in 37, our scope is a bit restricted.
So the grounds are taken. We are now only talking about the evidence.
Grounds, yes, we are saying that only.
So grounds are taken. Grounds is
in section 34.
In 34 about bias. I am not now.
That is what
I am now today only restricting on the argument of influence of these companies, operation of the. Yes. Now, my lords, we have made a small compilation of those documents, which your lordship, my lords, may consider. Just give a copy to them.
This is a compilation out of the 77
volumes. Only 7 documents, nothing more.
Commendable job.
I did not do it, because
No, whoever obviously did not.
So of course,
it meant to go through you.
Yes. Now, my lords, a couple of things. Yes, just open one more with me. Keep telling me the relevant. Now, my lords, first document is. Will come, your lordship will come to, this has no running pages. Oh, well, the running pages are the bottom right corner. So after this long index,
yes,
your lordship has the first document. The original number was 1139. In this is page number 1, bottom right. Now
we'll follow the bottom right.
Yes. Now, this is a document of 18th August 2011. CNE Limited, which is the claimant, addressed to Manoj Kumar Bhaya, son of late Shri B.D. Bhaya. And please see this. We are pleased to inform you that our board of directors has appointed you as the CEO of the company. So the son of late Shri B.D. Bhaya was a CEO of CNE, no problem, because CNE is their company. But when you link it to the fact that the CEO of CNE was the authorized signatory of SSSMIL, then there is a problem. Yes. I had shown that Madras High Court order. The Madras High Court order, I can place that again. That
did not. That's
correct. So So now you have CNE, you have the CEO of CNE.
No, but better place that.
Yes, let me place that.
Yes.
Yes, I have that. Your Lordship will find that volume 6, page 720.
As usual, the last. Yes.
Yes,
Page 720.
720. Moore's law. Let's see. What you're looking formulas for is will come right at the end of it, after maximum effort.
Yes.
So page
Moore's law, right? Absolutely Moore's law. I couldn't hear you actually.
So
Yes.
720 is an order of 26/8/2015. Lordship has that, my lords? High Court of Madras in a writ petition of 2006.
Yes.
And the authorized signatory is Manoj Kumar Bhaya. Now, I must, although candidly tell your lordships one thing. This appears to be the cause title of 2006. So in 2006, Mr. Manoj, I don't know whether there was a change or not, but in 2006, Manoj Kumar Bhaya was the authorized signatory. He becomes a CEO in 11. So I am not sure, my lords, if because the judgment is 15, this is 6. So, my lords, I do not wish to make any wrong statement. I want to be very, very candid and forthright before your lordships. But what does come to light is some connection. So let me assume against myself.
This has prejudicial value.
No, not prejudicial value. No, this shows connection at the very least. In 2006, there is an authorized signatory of SSSMIL.
Yes.
Is Mr. Manoj Kumar Bhaya, his son.
He's deemed to carry on as in that capacity till 2015 because on the date of the order his name appears.
Correct. And
so
in the
because not there it would be changed.
Correct.
That's a presumption. Yes.
In the middle, in 11, he becomes the CEO of CNE. So look at it this way: the authorized signatory of SSSMIL, who happens to be no other than the son of late Mr. B.D. Bhaya, then becomes the CEO of CNE. And all of these facts I'm only placing to show, to satisfy the test of affiliate at the end of the day. That's all. That's the only attempt that I wanted to make. It's not as if these are companies operating in a silo. Mr. Mukherjee said that we must only look at some strict de jure control, positive, negative. My attempt is not that. What I'm showing is that in their actual operations and business and shareholding structure and directorship and registered office and use of domain.
There was a synergy between their functions.
Absolutely. Because one of the tests of affiliate also admittedly is group companies. There is no dispute on group companies. The appellants may dispute my construction of the word affiliate, but what they can't really differ with me is that group companies at the very least are included. And group companies will borrow the definition from Cox and Kings. That's the only definition available. And Cox and Kings, of course, I will just read that definition again. Has a very interesting definition. It says, borrowing from the words of an Indian author, agglomeration of privately held and publicly traded firms operating in different lines of business, each of which is incorporated as a separate legal entity, but which are collectively under the entrepreneurial, financial, and strategic control of a common authority, typically a family, linked by trust-based relationships, forged around a similar persona, ethnicity, or community. So, that was document number 1 that I wanted to show. Now, this document carries on until page 4, and now, your lordship will come to page number 5. Page number 5 is the response. Correct? Is the response filed by late Shri B.D. Bhaya to my company petition. Lordship will remember, even the company petition went before the learned arbitrator in the referral consent terms. The operation, the company petition. And this is page number 5 is the cause title. The relevant extracts start from page number 9. Your Lordship will just give me 1 second, my lord. I'm just opening this on my system also. Wait. Yes. Now, my lord, on this, please, my lord,
Page 5 is missing.
my lord, this is not the. This is just that only the relevant page.
Internal page 5 of that document.
Yes, my lord, these are only the relevant pages.
Relevant pages.
The
What
whole
was
matter-
this? I mean, we don't
This
understand.
was, my lord, this is, I said, this was
This is the application itself on an affidavit in connection.
affidavit. The response filed by them, by BD Bhaiya.
You should have put in that page at least showing that it's an affidavit.
Yes, I'm
Otherwise,
sorry.
we don't know what this. Can you understand us? I mean,
Yes,
you see your bottom right hand page 8 and 9. Between them, there is a gap. So we don't know what this document is.
Page 17 is the page 17.
Yes.
Kindly come to, my lord, page 17.
Bottom right 17.
Bottom right 17.
All right.
That's so it's signed by late Bulakidas Bhaiya.
Yes.
Signed by him. It is his affidavit. And what this document is will.
So we want to see that caption.
Yes,
Just give
my lord,
that page
I will
later.
place that. I will place
Yes, just affidavit on behalf of something.
So that is also coming from the index itself. Page 1 of this compilation, the index, but I will nevertheless
No,
place
it's there.
that page. I will place that page.
Reply. Oh, very well. That will do.
Yeah. So the paper book also, my friend says, can be taken out. The whole document can also is also here.
Great. No difficulty.
Now, Malad, 15, sorry, page now
Bottom
10,
right.
bottom right 10.
10, yes.
Now, Malad, paragraph 1, late 60s, I commence business of trading in leather chemicals, selling and or marketing leather chemicals manufactured by a couple of multinational companies.
Same thing.
Same thing. 1973, formed a company known as Chem Crown India, etc. Paragraph number 3, petitioner number 1, which is us, late Mr. Gopal Das Bagri, joined Chem Crown India as an employee. He posted the petitioner at Madras to look after sales, marketing, etc. All this your lordships has perhaps now seen. Now let us kindly come to the next page. Page number 11, paragraph number 17. Bhaiya Group carried on business of manufacturing and marketing of leather chemicals through their various companies, such as Chem Crown India, which is SSSMIL, Chem Crown Exports, etc. In the year 99, Bhaiya Group transferred their entire business of manufacturing and marketing leather chemicals, including technical know-how, distributors, customers, brands, trademarks, some names of trademarks are written, to the company CNE. And the company became proprietor of such brands and or trademarks. Company, amongst others, is the proprietor of trademarks, etc., etc. The important thing of this paragraph 17 is the first line. There are various companies of Bhaiya Group, including SSSMIL. This is an affidavit in response shown by Mr. BD Bhaiya in the company petition. He calls some companies as Bhaiya Group companies. One of them is Chem Crown India. The second point to be noted is in the year 1999, they transferred a lot of business of Chem Crown India, now SSSMIL, to CNE. Now, the shareholding of this company, CNE, I understand, has never undergone a change. They were always holding this so-called 35% only. But the influence and control was such that they could manage to transfer the business of Chem Crown India to CNE. That was the level of influence with 35% shareholding, which as per the submission today made does not show control. The shareholding structure, I am advised, has not undergone any change in SSSMIL. Promoter group to begin with was 35%. It is even today 35%. At the relevant point of time was also 35%. But with so much of control, because public, as a lordship was rightly put to me, they have no control. Public is a diffused entity. They had the control to transfer the business from one group company to the other group company.
Still a listed company.
Yes, it was a listed company, of course, in 99 also. Now, Malos, there is now a paragraph number at bottom, page 14. And when a lordship is looking at all of this, kindly bear in mind that this is all the arbitral record. These names did come up before the arbitrator. So it's not that the arbitrator did know what Chem Crown export was or Chem Crown. These are matters heavily litigated before the learned arbitrator. These names came up again and again. Manifold pleadings. Now paragraph 18 at page number 14. Regarding paragraph 7.10 of the petition, I say that the registered office of the company, which is CNE, was at Calcutta inasmuch as I was the chief promoter and architect of CNE. No problem. It is incorrect to allege that I looked after merely the administrative functions of the company. As a matter of fact, I was the mentor of the company, and I, through my other group companies, viz. Chem Crown India, Chem Crown Export, provided technology, trademark, brands, etc. to the company. This is a candid admission of someone who believes he started off or was the grandfather of this entire group. So not only does he say that these are my group companies, he also says we are providing technology, trademark, brands. So Triple SMIL, apart from the admission of a group company, they were operating in a structure where trademark, branding, etc., was all being shared.
The name of Kim Crown was merely changed to Triple SMA.
Yes.
There was no other structural change or any change of whatever
No.
management.
So as per the corporate history,
Yes.
It's my understanding, subject to correction, is Chem Crown India got listed in 1991.
Yes.
The change of name, subject to correction, happened in 2001.
It was a change of name.
Change of name only. Change of name. But everything else remained the same, including registered office, even as I said, even the shareholding.
Yes, those things you showed.
Yes, including the shareholding structure also did not change. But the interesting thing is, despite the change in name in 2001, these are all affidavits of 2014, etc., which are now, they are always referred to by their old name. Which is how you would perhaps describe a company which you believe you had founded. So these are my companies. I was the mentor of the companies. We were all doing business collectively. We were transferring brands, technology, etc., etc. Now, my lords, page number 18. Page number 18 is a complaint in the Court of Learned CMM at Calcutta. Your Lordship will see the heading.
Yes, yes.
Filed by CNE against two persons, Bugul Islam Mullah and Amit Sharma. And page number 19, kindly see paragraph number 3. That the accused person number 1 was an employee under the complainant. So complainant is CNE since 1990, and he was appointed first as a technical assistant by Chem Crown India Limited, sister concern of the complainant. I'm sorry, my lord. Your lordship has paragraph 3 at page number 19.
That we have seen.
Yes.
You are looking at trying to look at the who affirmed.
Correct.
That is immaterial probably because this is filed on behalf of CNE
Now,
itself.
your lordship has put to me about, my lords, this Mr. Arindam Haldar. Now, my lords, this Mr. Haldar, your lordship will come to page number 23 for Mr. Haldar. That's 23 is, in fact,
yes.
Yeah, in fact, I'm sorry. I should have shown page 21 first. Page 21 is the arbitral, is a proceedings in the arbitration. 23 is an affidavit evidence of Mr. Vijay Kumar Bagri. Lordship remembers when there was a visit to China, late Mr. Bhaya and one Mr. B.K. Bagri.
Yes.
This is the affidavit of
the other Bagri.
The other Bagri.
Yes.
Now, so his affidavit, your lordship has. Now, my lords, this is page 23. Now, my lords, come to page number 24, paragraph number 3 and 4. Because this in my submission would, my lords, perhaps quell all the doubts. May I read paragraph 3? Company also filed a complaint with the officer in charge, Port Street, PS, Kolkata, which had been disclosed at so-and-so. Complaint has been signed by Mr. Arindam Haldar, whose signatures I know. Said, then please ignore the rest of the lines. Come to 4. Company, through its law officer, Mr. Arindam Haldar, also lodged a complaint with the cybercrime.
Yes.
Now, at page number 26 is the cross-examination of late Shri Bulakidas Bhaiya.
Yes.
And Manoj, may I show now this cross-examination? Just tell me the date of the cross-examination. What was the transcript date? Sorry? Date. Oh, that's now, yes, on page number 26, top, Manoj, kindly mark the date.
Yes.
15th of February, 2015. And now, Manoj, we'll see page number 28, question number 113 and 114. Because 113 says, do you have the registered office of any of your other companies at the same premises where the registered office of CNE is housed? Answer is yes. Which are the other companies? Chem Crown Exports, Chem Crown India, and other group companies. Because that's what some additional material that we could locate from the arbitration record. And I'll try and put all of these facts in a perspective when I now make my submissions. I need to also answer your Lordship's question, which your Lordship had put to me on the last occasion. And in the course of my submissions, I'll answer that question also. Your Lordship had put to me if there are A and B, and they are engaged in an arbitration. Yes, both of them have equal shares, say in a company C. Can the arbitrator appear for that company C? I'll answer it, but I'll answer it as a part of my submissions. I'm cognizant of that. Yes, yes, please. Because what I've done is, for my submissions, I've made a written note. Because I think it helps me when I'm perhaps reading from some place, and it also, Manoj, then all these things are at one place.
So that you don't miss out on anything, I mean.
Yes.
Any facet of your
So
argument.
some of these facts, your Lordships, I've already argued them, articulated them, but they're still in one place now, compositely. Yes. Now, let's paragraph 1. May I start with?
Yes.
The first heading is construction of the entries in the 5th and 7th schedule. Since the entries items contained in the schedules owe their origin to the IBA guidelines, the same should be construed considering the general principles contained therein, a point well understood. The court is required to take a broad commonsensical approach to the items stated in the schedules, which approach requires a fair construction of the words, neither tending to enlarge nor restrict them unduly. Paragraph 3, something new. It was my mistake not pointing this out. IBA guidelines itself provide that IBA Arbitration Committee trusts that the guidelines will be applied with robust common sense and without unduly formalistic interpretation. That was the expectation. This is introduction, paragraph 6. I had not, unfortunately,
You had
got
not
your
pointed out, but we had seen, we were having a glance.
So this is also sort of coming there, from there only. Now, we are concerned in this case, paragraph 4, with entry number 2, which reads as arbitrator currently represents or advises one of the parties or an affiliate of one of the parties. While the expression affiliate is not defined in the Arbitration Conciliation Act, or for that matter in any other parliamentary legislation, only source of guidance is provided in explanation 2, which reads as under: affiliate encompasses all companies in one group of companies, including the parent company. As is clear from explanation number 2, same does not define what an affiliate is, but only clarifies that affiliate will encompass certain entities. The use of the word encompasses, when seen in contrast with the term refers in explanation 1, makes it clear that explanation 2 only enlarges the ambit of the expression affiliate by including certain entities while preserving the otherwise ordinary, natural, and popular meaning of the word affiliate. Lordship will remember, I've shown explanation 1 says refers, this says encompasses. Expression affiliate is used 23 times in the 5th schedule and 9 times in the 7th schedule. So whatever be the interpretation of the word affiliate will perhaps cut across not only this entry, but across various entries. Now, the third heading, is my answer to the submission that any party to the arbitration can have an affiliate. It is not necessary that an affiliate should always be companies or corporate entities. So the argument is that only a company can have an affiliate, and if a company can have an affiliate, it must be only other company. So no other person. So there are two elements to it. One, only company can have an affiliate, and the only entity which can be affiliate itself is a company. Now, paragraph 8. While construing the expression affiliate, it would be important to note that the 5th and 7th schedules use the expression affiliate qua the parties to the arbitration. On the other hand, expression close family members is used qua the arbitrator personally. There is nothing in the IBA guidelines or the 246th Law Commission report which recommended amendments to Section 12 of the Act, which suggest that the IBA Arbitration Subcommittee and or the Law Commission only intended a company as a party to an arbitration to have another company as an affiliate. So submission 1 is paragraph 9. This submission is not coming forth from either the IBA guidelines or the Law Commission report.
So, Diwan, are you saying that there can be cross affiliations also between an individual and a company?
Yes.
A company can be my individual's affiliate.
Yes. Yes.
And vice versa.
Yes, I am saying so.
As well as between companies, obviously.
Yes.
And also between persons.
Yes. I am saying.
So across the board, there can be affiliation.
Correct. That is
no distinction between a party, a juristic person, and an individual in that regard.
Correct. So which will now come? That answer of my submission to your lordships will now come.
All right.
Yes. Correct. So we are not talking about
up and down, you said.
No, I'm saying now in the context of the Arbitration Act that under entry 2, affiliate is a neutral term.
Yes,
that's
only,
all.
Yes. What else?
No, that's my friend wanted to make that clear. That
we are speaking about the Arbitration Act.
Yes, correct.
Not affiliation in general.
Yes.
We are not interested in affiliation.
Now, paragraph 10.
Yes.
That this is also not the way in which the schedules understand the expression affiliate is clear from entry 26 of the 5th schedule, which reads as under. Arbitrator was within past 3 years a partner or otherwise affiliated with another arbitrator or any of the counsel in the same arbitration. So, internal right.
Yes.
Correct. I just pointed this out. It is self-evident that the use of the expression affiliated with in entry 26 is to denote close connection and association, which meaning is aligned with the dictionary meaning of the word affiliate. That said, if the interpretation canvassed by the appellants, i.e., that only a corporate entity as a party can have an affiliate is accepted, the same would mean that if a party to the arbitration is an individual and or a partnership firm, they will not have any affiliate. Such an interpretation is entirely undesirable in as much as the same severely constricts the nature of relationships which are otherwise sought to be made a matter of disclosure, ineligibility under schedules. Now, for example, 2 examples. For example, it would be perfectly acceptable for an arbitrator to represent or advise the immediate family members of an individual who happens to be a party to the dispute. If the interpretation is accepted, then it's because an individual cannot have an affiliate. So you can advise the wife, the children, the parents, etc.
To have a reference frame of an affiliate vis-a-vis an individual. So should you look at the definition of party or a person or something else? I mean, what should be a reference frame of what should be?
I've also tried to answer that subsequently in this.
Yes, because you referred to something, somewhere else. Anyway, let us continue.
Well, I will answer that, but I have tried to answer it in my note.
Yes.
Point number 14 is I'm pointing out the abnormality that if the court was to only construe affiliate in the way the appellants are construing it, then there is a problem. Likewise, in the context of entry 7 of 7th schedule, it would be perfectly all right for the arbitrator's law firm to have a significant commercial relationship with the close family members of an individual who happens to be a party to an arbitration. The same problem would arise with a large number of other entries in the schedules where the expression affiliate is used. The other problem which would arise if the appellant's interpretation only a company can have another company as an affiliate is accepted would be that even persons in control of such company, such as its key managerial personnel, majority shareholders, if individuals or partnership firms or LLPs, are also left out of the loop. Now, please pause here for a moment. I did not give this as an example on the last date of hearing. Now, the argument is that, well, a company will have its MD. A company will have its majority shareholder who could be an individual. A company could also have someone who has a great financial stake in the company, such as the person who has given large amount of debts to the company. Now, if you are only going to say that a company's affiliate can be another company, that means it will be perfectly all right for the arbitrator to take up the case of the MD. So take, for instance, one is appearing for Reliance Industries, or one is conducting an arbitration for Reliance Industries. If only company can only have another company as an affiliate, it's quite all right then to represent Mr. Ambani personally. There is no problem with that. Or someone who has given large amount of debts to the company, etc. So that again leads to an absurdity. If you only do a company-to-company relationship as an affiliate, because you're also leaving out individuals in management and control of that company as affiliate. This again raises completely unintended consequences, such as that it would be perfectly all right for the arbitrator, while adjudicating disputes between two corporate parties, to simultaneously advise the MD of either party, its KMPs or majority shareholders, if individuals. Likewise, in the context of entry 7 of the 7th schedule, it would be perfectly all right for the arbitrator's law firm to have a significant commercial relationship with the MD and KMPs of a company which is a party to an arbitration. Such construction of the expression affiliate, which dilutes the protection sought to be provided by the schedules, must be eschewed in favor of a construction which promotes and takes forward the purpose sought to be achieved by the schedules. Seen in this light, the expression affiliate used in the schedules must receive a contextual interpretation, and thus any party to an arbitration, whether a corporate entity, individual or partnership firm, can have an affiliate, and such affiliate need not be restricted to another corporate entity alone. In other words, the expression affiliate ought to be construed as neutral to the legal identity of the concerned party. Plus, can I just have a sip of water if your lordships don't mind?
Absolutely, please.
Now, the heading is company can have an affiliate even where the party to an arbitration does not have control over it. Now, a lot was said on the doctrine of control. That for another company to be an affiliate of a party to an arbitration, the party to an arbitration must have control over it. And control in what sense? Control in the sense that the Indian Act understands control to be. That was the argument made, and ArcelorMittal was cited. So paragraph 18 is, the appellants have argued that for a company to be classifiable as an affiliate, concerned party must have control over it. For this purpose, judgment of Supreme Court in ArcelorMittal, which refers to the definition of control, and certain other doctrines relating to positive, negative control under the Indian law were referred to. At the outset, importing the Indian test of control into the meaning of affiliate is counterintuitive. As is well accepted, entirety of schedules have been borrowed from the IBA guidelines. These guidelines were made in the context of international commercial arbitration by arbitration practitioners and users who came from several jurisdictions. And this is a quote I've taken from there, representing diverse legal cultures and a range of perspectives. Certainly, the Indian test of control over corporate entities was not a criteria while using the expression affiliate, because these are not some Indian guidelines. These guidelines were made by, and there's a long list of people who made it in international commercial arbitration context. So certainly, my argument is, those people, draftsmen of the guidelines, did not have the Indian set of control when they were making the guidelines, or they were using the word affiliate.
So what do you say is the Indian test? The family control?
Because
centered around family and all this.
My Indian test is 24 and 25 of this note. I'll come to it. The meaning that I wish to attribute to you.
Something centered around family must
Yes. Be. Something about close and intimate connection is my test.
All right.
But I am saying I fulfill their test also. So I wish to make it clear. This note is my understanding of the law for the assistance of the court. I am not detracting from the fact that let's assume control to be the test. According to me, SSSMIL was under the control of Mr. Bhaiya. I'm saying so. So that is my other argument. paragraph number 20. Secondly, wherever the draftsman wanted to bring in the element of control, it has been specifically stated so. Entries 5 and 9 of 7th schedule expressly use the word control or its cognate expressions. Now, so this argument is that wherever control wanted to be referred to, control is specifically referred in the IBA, the entries in the IBA guidelines. Para 21. Secondly, importing the test of control again renders entry 5 of the 7th schedule unworkable. Now, entry 5 is extracted at the bottom of page 5. May I read it? Arbitrator is a manager, director, part of management, or has a similar controlling influence in any affiliate of one of the parties if the affiliate is directly involved in the matters in dispute. So entry 5 conceives of a control of an arbitrator over an affiliate. That's what entry 5 conceives. Now, my argument at para 21 is that if you accept the definition that an affiliate can only be an entity under the control, then entry 5 becomes unworkable because an arbitrator cannot have a controlling influence over an entity which is already under control. So there is a wrong sort of understanding here. Para 21. Secondly, importing the test of control renders entry 5 of 7th schedule unworkable. This entry postulates the arbitrator having a controlling influence in an affiliate of the parties. If an affiliate can only be an entity under the control of a party, as contended by the appellants, then the arbitrator possibly cannot have a controlling influence over an already under control affiliate. Last but not the least, as already pointed out, insofar as the IBA guidelines are concerned, in a situation where there is upward control over an entity, General Standard 6B, or downward control by a party over another entity, General Standard 6C, then the IBA guidelines treat such entity to bear the identity of the party itself. On the other hand, an affiliate is not the party itself but a third person entity. This also shows affiliate need not be under the control of a party or vice versa. This again is something which comes out from the IBA guidelines itself, because the IBA guidelines, as I've shown, 2014 guidelines, upward control, 2024 guidelines, downward control. When there is existence of control, the IBA guideline says you become the party itself. You bear the identity of the party itself. So affiliate cannot possibly have the meaning of control. The way the IBA guidelines work is when you have control, you will bear the identity of the party.
So you say it may extend laterally also?
Yes.
Horizontal?
Correct.
So there may be a collaborative effort between different people for different reasons, close family ties or something.
Absolutely.
So that collaborative angle also has to be looked at.
Absolutely. I'm saying the burden of my submission is don't restrict affiliate to an entity under control.
Control can only be up and down in a sense.
Control can be up and down.
I mean, it may be broad-based, but it has to be vertical or lateral. Control takes away the meaning of the term control.
Correct. I am also...
Affiliation is wider in a sense.
Absolutely. I am saying that the attempt of the appellants is to narrow down the meaning of the term affiliate.
Obviously, and you will try to broaden.
Correct. So I'll try and broaden. Correct. But when your lordships are, of course, as a neutral third party, looking at
the law,
looking at the way this expression affiliate has to be correct. In that sense, a draftsman, etc. What your lordship will notice is that the term affiliate is a borrowed term from the IBA guidelines. Which IBA guidelines use the term control itself wherever they wanted to? Point number one.
Yes.
Second point is that if you interpret control, one of the entry becomes unworkable. Thirdly is that IBA guidelines do conceive of control by a party. It's not that IBA guidelines are silent over control by a party. They say that if a party is under upward control or downward control, then it's not an affiliate, it's a party itself. So that's how the IBA guidelines are structured. Affiliate cannot tantamount to control, or control cannot tantamount to affiliate alone. That's the point I'm trying to make. Now, Malaz 23. Therefore, control can never be said to be a decisive element while reckoning whether an entity person is an affiliate of a party. This is not to say that if a party exercises control, as understood under Indian law, over another person or vice versa, such person would not be an affiliate of a party. All that is sought to be conveyed is that control should not be a sole criteria for reckoning a party-affiliate relationship. And this, of course, is a without prejudice submission, because according to me, even if your lordships come to the conclusion of control, from the facts that I've demonstrated, there is sufficient control of late Mr. B.D. Bhaiya over the party in connection here. So I'm satisfying their test also, although I'm saying that that test itself is not the correct test. Now, paragraph 24. This is now, my submission as to what should then be an affiliate. Insofar as an individual party is concerned, affiliate of such party ought, at the very minimum, be the same persons who are regarded as close family members under explanation 1, i.e. spouse, sibling, child, parent, or life partner. Stop here for a moment. So I am now first for individuals saying that the test for close family members, which is co-an arbitrator, is these people. So I'm saying, please, at least those people should be an affiliate of individuals when it comes to natural persons and other juridical persons with which such individual has a close and intimate connection. Now, this is my formulation for your lordship's consideration. Association or relationship in terms of control, ownership, financial exposure, being a related party under Companies Act, etc. So when it comes to an individual, affiliate can be another individual, which I am saying can be the close family members under explanation 1. When it comes to juridical entities, then it has to be a close and intimate connection, association, or relationships, which can exist in several forms. One of them is control. See, one may have control, one may not have ownership, or someone which has ownership of shares may not necessarily have control. So these are different concepts in law. I may be holding 45%, 50% shareholding, but perhaps under some agreement that I have as a shareholder with someone, all directors will be appointed by him. I have virtually given up all my rights with respect to management. So I may have ownership, but I may not have control. Likewise, my lords, it often happens in the case of companies, is that someone else has given large amount of loans, something that I adverted to some time back. Exactly. So you have a large financial exposure in the company in the form of unsecured loans. Please take a situation which can happen. A company having an arbitration with B company. There is one individual C who has given large amounts of guarantee to secure the debt of A, and A is involved with B. So if A wins the arbitration, A will receive money. So who benefits? Who has an interest? C, because C has given guarantees to secure the debt of A. Would it be all right for the arbitrator to take up a matter for C? Those are the questions which will arise in real life. So just to confine affiliate, only to say that affiliate, please, only a company can have an affiliate, and that to another company, means we are actually letting go of a large number of real life practical situations which will arise in common scenarios. Now, 25. Insofar as a company which is a party to an arbitration is concerned, its affiliate ought at the very minimum include, apart from group companies and parent company which are already encompassed by virtue of explanation 1, persons in its management and control, its KMP and other corporate entities with whom such party has a close and intimate connection, association, or relationship. The same expression which comes in para 24. This close and intimate connection, association, or relationship could exist in several forms, such as being under common control, being under common management, being related party, associate party under the Companies Act, etc. So that's my respectful formulation, whatever I could best come up in terms of how should the expression affiliate be construed. Now, Malats, the next heading. The approach of the court while evaluating the facts in terms of entries and items in the schedule. Para 20 of HRD Gale lays down that doubts as to the impartiality and independence of the arbitrator are only justifiable if a reasonable third person having knowledge of the relevant facts and circumstances would reach the conclusion there is likelihood that the arbitrator may be influenced by factors other than merits of the case. This requires a broad commonsensical approach, etc. This is the same test as provided in General Standard 2C of the IBA guidelines, which reads as under: doubts are justifiable if a reasonable third person having knowledge of the relevant facts and circumstances would reach the conclusion, etc. So these are in line. I just made that point that the test under Indian law broadly mirrors the test of the IBA guidelines. Now, paragraph 28. The above test actually carries forward the old line of cases in India, both under the Arbitration Act and in administrative law, where it has been held that the standard to reckon bias is reasonable likelihood of bias. There must, so I have now said that the test actually is an extension of the old principles in a different words, perhaps. Lordship has some doubtfulness or some question.
Doubt, yes, because that does not come out from either HRD or the Act. That
Because,
reasonable apprehension of bias and bias.
Yes,
Although, yes, that's the standard for courts, suppose.
correct.
That justice must be seen to be done also, appear to be done. But that is not apparent from anywhere. The language of the statute does not put bias on a reasonable apprehension of bias also. Because it gives clear-cut tests under 5 and 7.
Yes,
So these are the situations where an arbitrator cannot.
correct. So 7 is an absolute sort of a bar.
Absolute sort of a 5 and 7, both absolute sort of a thing.
Correct.
Because it has been crystallized by way of certain parameters which have been given here.
Yes. Now,
And HRD also says at the same time, while borrowing the tests of general standards, IBA, but that was Justice Nariman was saying that that was the basis and that should be the standard of a prudent person and all these things. But at the same time, the language cannot be either expanded or narrowed down.
correct.
That was also,
Yes.
I'm paraphrasing.
Good.
So that was also there.
Correct.
So what could be the reason of this legislature using this this expression, which encompasses group companies, including the parent company? We were thinking in that line. Now, it's very obvious, isn't it, that an affiliate, if you give a broad definition, the first thing which comes to mind is a group company. Maybe including the parent is something which was intended,
Correct.
maybe one of the aspects. But why put in as example by saying that encompasses a group company, group companies? That is an obvious example. If a broad-based affiliate definition was intended, why not bring in something else regarding which there could be doubt? I mean, encompassing the outer rings of the margins.
Correct.
If I was to say if I was to say an affiliate means this, I would not state the obvious unless I intended to restrict it to the obvious.
I mean,
We are saying against you.
Correct.
So I won't say, an advocate encompasses a lawyer. I mean,
Yes,
that's quite obvious.
correct. So
I
you
would
try and-
say an advocate encompasses, suppose a Mukhtar of
Yes.
previous days.
Yes.
I would
correct.
say that,
Yes.
which is somewhere in the outer ring of the margin of the periphery. So why say encompasses group companies, including the parent company, if that was not the intention to give it a restricted meaning?
Malad, so your lordships have posed a very, very fair question to
Because
me.
that is what is at the practical level, at the
Correct.
ground level. Because sometimes we tend, what as advocates and judges we tend to do, we take off from the ground
Correct.
and go into an exercise, intellectual exercise, which may be diverse from the ground realities.
Correct.
So that is what we were thinking aloud.
No, your lordships have raised a very fair question. I must respectfully say that. I'm thinking when I'm speaking, and I'm
Yeah, no, you can answer that later. You can
Yes.
complete this thing and then
so yes, Manoj. Now paragraph
that
20,
will be easier.
yes, paragraph 28 was that the HRD formulation
Yes.
is in
yes.
line with the earlier law, which said that the standard to reckon bias is reasonable likelihood of bias. And the earlier formulation in Kripak, for example, was there must be reasonable likelihood of bias in deciding the question of bias. We have to take into consideration human probabilities and ordinary course of human conduct. And likewise, in KD Bali's case, there is a real likelihood of bias, not mere suspicion of bias, reasonableness and apprehension of an average honest man that must be taken note of. So according to me, it is just maybe different words, but the sentiment is the same. Reasonable likelihood by an ordinary person, but who understands the situation. Now, application of the test to the present facts. Now, all of the facts which I have pointed out to your lordship.
These are the points you are pointing out.
May not be everything, because the new documents,
In the paper.
references may not come. Perhaps I'll write them down also and give it of all the facts. But now please wear the hat of, as the Supreme Court says, reasonable third person having knowledge of relevant facts. Now, relevant facts are the ones enumerated in paragraph 29. Well, I am commending your lordships to wear the hat of a reasonable person and see if in these facts there is a reasonable likelihood of bias, or that the arbitrator may be influenced by factors other than the merits to decide the matter. Fact number 1, SSMIL happens to be a company admittedly incorporated by one of the parties to the arbitration, who was the founder of this company. Fact number 2, party to an arbitration through another of his companies, was the promoter and largest shareholder of this company. Fact number 3, that party to the arbitration, his daughter and son-in-law were directors at the relevant point of time. Fact number 4, an employee of a party to an arbitration was a director of SSSMIL.
At the relevant point of time means during the arbitration or at the inception?
Your lordship fellows are reading in
C.
C.
Yes, at the relevant point of time means
The relevant point of time is time of the appearance in the matter. The appearance for the SSSMIL APD matter.
Yes, because Mr. Mukherjee tried to divorce the inception from the
Correct. So
later
I'm
development.
only now saying that point of time when the appearances happened. This is 2018-19. So the appearances are 2018-19. We're concerned with that period.
So this was during the continuance of the arbitral process.
Yes.
Relevant point means when
Your
the
lordship
arbitration
will-
was
correct,
going on.
Correct.
Very
Your
good.
lordship will
That was the
remember
point.
there was a hiatus. The point I made in the first day. There was a hiatus in
is
the
included.
arbitration.
Hiatus is
Appearances happened during the hiatus.
During the
This is the facts regarding the hiatus.
very good. Very good.
Now, 5th fact, registered office of the company happens to be the same as the party to an arbitration. 6th fact, the email address of the concerned company happens to use the domain name of a party to an arbitration. Legal counsel of the party to an arbitration also instructs the learned arbitrator in APD
We'll
252.
put in law officer here.
I will say yes.
Yes,
I will
because
say
law
legal
officer.
head.
Yes.
Your lordship may just make
Legal
that
head also.
legal head.
Both these terms were used in separate
Yes,
places.
I'm sorry. It should be
legal
head.
counsel and
Law officer. So it says legal head.
law officer in one place and another place legal head in the probably that
The LinkedIn.
LinkedIn.
So it should be legal head stroke law officer.
Yes.
Last but not the least, BDB's son and CEO of CNE, Mr. Bhaiya, Manoj Kumar Bhaiya, authorized signatory for SSSMIL in the writ petition instituted by SSSMIL before the Honorable Madras High Court. So broadly, these are the facts which have now come to light.
Mr. Diwan, we can request you to submit the same thing
with page numbers. Yeah, of course.
Only
I will
that.
do it. Yes.
Otherwise,
So-
it's very comprehensive but precise.
Yes.
We must.
No, I must. In fact, that's my mistake. When I was working
not
on
mistake. I mean, just put in the page numbers in
what I will
smaller font.
So from para 29
Smaller
onwards,
fonts. Yes.
from 29
Yes,
onwards,
the facts.
this 2-3 pages I may replace, or I may give you a better one. The first few
We'll
pages
take
will remain
another.
the
We'll
same.
just put a cross in this.
Yes, very well. Now, Mullahs, broadly, these are the facts which have come to light. Now, Mullahs, let's now test it with entry number 2. Entry number 2, Mullahs, again, of the 7th schedule. Uses the words arbitrator currently represents or advises one of the parties or an affiliate of one of the parties. Several times, Mullahs, this entry has been read. So, 3 questions
You
arise.
say both tests.
Well, that
Parties
text-
upward and downward. That concept of
I'm not importing that for a moment.
not.
I had only relied upon that test to show the interpretation
All right.
and to show the dichotomy of what happens if you restrict affiliate to only control. The importance of that upward and downward is something else in my respectful submission.
All right.
Upward and downward shows that the committee had in mind to make upward and downward control to bear the identity of the party itself. So don't make affiliate only contingent on the existence of control.
No, you are saying that you would meet both the tests.
I will
that-
need 3 of the tests. Paragraph
Affiliate.
30.
So for item 2, only affiliate, not parties.
No, I am not saying party. I'm
Not
not
going
saying
to
party.
that extent.
I'm not going to that extent. I'm not going to that.
That's
I could have.
as per the IBA test.
Because see, the problem, my lords, there is going to be 2000. I must fairly tell your lordships. 2014 only had upward test, which means that
Yes.
party must be controlled by someone up. Now, it is not possible for me to say that BD Bhaiya was controlled by someone.
That would be going too far.
Exactly. So I want to make a reasonable pitch of an argument.
very.
I am therefore saying I fall within the entry as it stands. Now the entry has 3 elements to it. Paragraph 30 of my note. SSSMIL was an affiliate of late BD Bhaiya. That's one test. SSSMIL was an affiliate of CNE. Second test. SSSMIL and CNE were group companies. The third test. If I succeed in any one of them, then this matter is covered by entry number 2. Let's take the easiest first, according to me. Triple S MIL and CNE were group companies. Group companies is the Cox and Kings group companies. The facts which have come on record, according to me, establish that these are group companies at the very least. Now, this is the easiest test according to me. If your lordships may not want to decide the larger controversy of what an affiliate means, etc., and your lordships, the question, I am inspired by the question put to me by your lordships about the fact that obviously the obvious meaning is group company and the parent company.
We are thinking aloud in your presence.
your
We
lordships
don't
are
want
right.
to do that in our home.
I may have to
Yes.
think a lot more than your lordships to perhaps give an answer to that question.
Yes. So
but I'm
let us
saying let's keep it simple.
stick to this.
Let's keep it very simple. Certainly, group companies are included. Now, the facts which are articulated in paragraph 29. First question, do these show that CNE and Triple S MIL were group companies? Now, according to me, they satisfy the test of group companies for a number of reasons. Again, I'm going back to the same facts, nothing new. They are group companies because behind both of these companies, admittedly, is the same persona and the same family. Registered office is the same. The same persona or his family, his children are directors in the other company. As I have shown from the evidence, these companies were working together in tandem. There was exchange of trademarks. I've read that. Exchange of trademarks, business operations. In fact, business of one company was transferred to the other company. I've talked about registered office. Even the domain ID for MCA happens to be the other company. All these facts would show that these are group companies. Late Mr. B.D. Bagri says so himself. I mean, I don't need to perhaps apply my mind to it. In his affidavit, he says so these are group companies.
Yes.
Operating like group companies. Group companies could also perhaps partake the character of sibling corporation. On the last occasion, your lordship had asked me to take out the definition of the Black's Law Dictionary. One of the definitions of
no, we had not asked you. That was sarcastic. That's just peculiarly says
so
that everybody cites black. You are not citing.
Yes, no. So Black's Law Dictionary. So forget the affiliate. I'm not on the corporations alone. Black's Law Dictionary affiliate inter alia includes a sibling corporation.
Yes.
These are, in my respectful submission, sibling corporations, group companies, whichever definition one wants to employ, because the test is going to be the facts.
Gender bias. Black is not gender bias. We say sister concern, but
yes. So
sibling is a better term.
Yes, correct. Sibling. Because of the, your lordship has seen the explanation one has life partners. So we are now in a progressive.
Why only sister?
Yes. So we are in a progressive act, and progressive acts as life partner. So why have it a gender identity?
But we hope this doesn't go out on YouTube and be interpreted.
No. I hope
it does.
It sometimes does. Your lordships are right. There are clippings available of certain court proceedings, which is
selectively taken out of context and used like
correct.
Whatever.
So if your lordship was to, in a manner of speaking, lift the veil to find out the true owners, persons in decisive, strategic control the words use of group, your lordship will find late Mr. B.D. Bhaiya. So the easier test is these were group companies in my respectful submission. That's test number 3. Now comes test number 2. I'm in the reverse order. Triple S MIL was an affiliate of CNE. Now here I meet one criteria of the definition propounded by the appellants, which was that only a company can have an affiliate. So CNE is a company. So at least that bit I'm meeting. CNE can have one more company as a it can have one more affiliate. Company having one more corporation as an affiliate. Whether CNE and Triple S MIL are affiliates.
Now, by was an affiliate, we are using the term interchangeably. It means Triple S MIL was an affiliate of CNE means vice versa also.
It would be. But I am confining it to the most simple.
The language used here is that the arbitrator represents or advises one of the affiliates of one of the parties.
So yes, the natural could be if
so the other party has to be affiliate of this. So if it is that, then vice versa is also the reverse is also true. Always.
It should be true.
Proceed on that premise.
So yes, I'm saying if A is an affiliate of B, B should be an affiliate of A. That's the question, lordship.
Yes.
But I am now for a moment saying no. I am actually taking the most conservative definition. I am now saying
yes. All right. You are saying SSMIL. Yes. Right.
So I am taking the most conservative.
That
I'm not
party is an
expanding
affiliate of this. Right.
Well,
Understood. Yes. So yes, you are right. You are right. We have understood.
Because this confusion happens under the Companies Act. where A
Yes.
could be a related party of B, but B
Yes,
may not be a
we may
related
not be
party.
related.
So
No, you're taking that test only. We read it in reverse, actually.
no, I am taking the most conservative interpretation.
Yes, yes, you are doing that.
I am saying
Because 2 says arbitrator represents affiliate of one of the parties. One of the parties is BDB and CNE.
correct.
And that SSMI, he represented Triple S,
Correct.
which is an affiliate.
So-
So,
so-
you're
So therefore,
yes.
CNE is a party. Click. CNE now is first question, is Triple SMIL affiliate of CNE? I'm not saying whether CNE is an affiliate of Triple SMIL. Triple SMIL has to be an affiliate of, because he has to appear for a affiliate of the party. So Triple SMIL is an affiliate of CNE. Triple SMIL and CNE are group companies. Those go together, group companies. So second test in paragraph 30 was whether Triple SMIL was an affiliate of CNE. Same facts which I've said, according to me, make them an affiliate only. Only because there is nothing to show a lack of control of CNE over Triple SMIL, according to me, does not mean they are not affiliates. This is where the test of control comes. As per the appellant's argument, for Triple SMIL to be an affiliate of CNE, CNE by itself must control Triple SMIL.
If you take a broad-based view of affiliate,
Correct.
then tests of B and C will be the same.
Absolutely.
Yes.
It is
But A will be different because it's personally between.
correct. So A therefore, as I said, is in that sense the hardest test. That requires a
Yes.
little bit of perhaps
From your
construction.
perspective,
My perspective.
Yes.
The test is that BD Bhaiya as an individual. So for me to succeed in A,
So cross.
yes, I must be able to show to your lordships or persuade
Individual
your
with
correct.
company. Yes.
So individuals can have an affiliate. If your lordships agrees with me on the construction, then I will satisfy A, because that on facts is not difficult. On facts, I am meeting A. The question is of the construction of the schedule,
Right.
whether your lordships are inclined to hold that individuals can have an affiliate or not. In my submission, yes, it should be. So, in my submission on a broad-based basis, C certainly group companies is made out in my submission. B is certainly made out. A will only be made out if your lordships agrees to extend affiliate concept to an individual party, because facts again remain the same. Now, 31 is something which follows from 30. Above would attract the applicability of entry item number 2 of 7 schedule, making the learned arbitrator de jure ineligible to have continued further after his representation for Triple SMIL. Apart from the above, a cumulative reading of the aforesaid facts would, from the standpoint of a reasonable third person, establish the existence of a reasonable likelihood that the arbitrator, in rendering the award, may have been influenced by factors other than the merits of the case. Now, may I pause here for a moment? The way I understand it to be, if you are falling under 7 schedule, it's an absolute ineligibility. You fall within 7 schedule and you become de jure ineligible. There is nothing more to be seen, because that's an objective fact. Paragraph 32, which is the other part of HRD, reasonable facts, etc., are, in my view, the judge's amplification of how should those facts be seen. Because ultimately we are concerned with getting the facts and putting them into a pigeonhole. Now you have those many entries in the 7th and 5th schedule, which I'll refer to as pigeonholes. So you will try and label some facts or pigeonhole those facts there. That is, which standpoint do you take? So that is a reasonable person's test. And according to me, if these facts are seen by a reasonable person, perhaps the test is made out. 33. Such representation for Triple SMIL also falls foul of the initial disclosure provided by the learned arbitrator to the parties on 10th of August 14, where his appearance for BDB or companies managed or controlled by him was regarded as giving rise to justifiable doubts as to his independence and impartiality, which is what I showed on the earlier occasion. This was his own test. The arbitrator's own test was that if earlier I had appeared in one of the earlier proceedings, if that was the
He referred to Chem Crown or
no, he didn't refer to any company's name.
Oh.
No companies were referred to.
Oh, some companies controlled by.
Yes, it's actually not. The words were managed or controlled.
All right.
So in the mind of the learned arbitrator, to be fair to the learned arbitrator, he said that my long time ago earlier appearance for BDB or companies owned or managed by me may constitute a justifiable doubt, which is why I'm disclosing it to the parties. If one was to take the same test I'm ignoring 7th schedule for a moment. Please take the same test. I'm sorry. On the facts, this perhaps violates his own disclosure made there. And your lordships are aware of section 12.2, which says continual disclosure. As in when you become aware of, you have to disclose. Now, 34, Manoj, is
Continual disclosure was put in later.
No, it came in 15.
15.
No, I'm sorry. It was there. Sorry. It was there. 12, it was there. I stand corrected. 12.2 was always there. The obligation under 12.2 was always there.
Yes.
Thank you.
No.
Now, Manoj, 34, I'm sorry.
No, was it? 12.2.
Your lordship will, Manoj, see 12.
Yes, the previous one, prior to substitution.
So 12,
continuance, he shall disclose in writing any circumstances likely to give rise to his asset as to his independence. When a person is approached, he is likely to give.
I'm on 12, 2, subsection 2. It says an arbitrator from the time of his appointment.
Was there anything akin to that previously? That is what we, because we have it was substituted the previous one.
No, this 12.2 remained as it is. 12.1 underwent.
Oh, yes, right.
12.1 underwent.
I'm sorry. Yes, you're right. True.
Now, Manoj, 34 is in my submission. Manoj, another very, very important argument, which is the failure of the arbitrator to give a disclosure. Entry 2 of 7th schedule is also entry 2 of the 5th schedule. Now, may I read this first? Fact that the learned arbitrator did not even give a disclosure under entry 2 of the 5th schedule is a circumstance which should weigh against the award. General Standard 3D of the IBA guidelines provides that in case of any doubt on whether certain facts or circumstances should be disclosed, such doubt should be resolved in favor of disclosure. General Standard 7D ought also to be taken into account, which provides that an arbitrator is under a duty to perform reasonable inquiries to identify any potential conflicts of interest. The facts on record disclose that the name Chem Crown India Private Limited, old name of SSSMIL, came up several times in the pleadings and evidence of the parties. I have shown some instances today, but it came around many, many times. Indeed, paragraph 3.4 of the award at page 194 refers to the fact that BDB had formed Chem Crown. The award itself says so also. These facts should have put the learned arbitrator to notice, and the learned arbitrator ought to have conducted reasonable inquiries before deciding to represent SSSMIL. Failure to do so is a circumstance which leans against the validity of the award. A legally trained mind, such as that of the learned arbitrator, ought not to have placed himself in a situation which, apart from acting in dissonance with entry 2 of 7th schedule read with section 12.5, also gave rise to a reasonable apprehension of bias against him. The last line of paragraph 35 actually sums up my argument. I am not, personally speaking, I am not attacking the arbitrator. No one is infallible. Anyone can make a mistake. Anyone perhaps may end up putting itself or himself or herself in a situation. But you have a legally trained mind here. The question is, did the arbitrator err in placing himself in a situation where his appearance to a justifiable third person's mind in knowledge of relevant facts and circumstances would regard this as maybe appearing to be something which shakes his impartiality. So there is perhaps, it is at that stage where the error lies on the arbitrator. And I'll go a step further from that. Our act is arbitration centric, the 5th and 7th schedule. I had shown the IBA guidelines. Those also put duties on the parties. Our act has not progressed so much as to say that even a party should so. But here, if at all, the fault also lies with the party. You have an arbitration which is going on from 2014, a contentious matter. But for some reason, the learned arbitrator, I don't want to comment, whatever could be the reason, the learned arbitrator is engaged to do a matter where the same legal counsel for a party who's actually appearing in the arbitration decides to instruct the learned arbitrator. So the fault here also lies with the party, in my respectful submission. And if there was any doubt in the mind of the arbitrator, a disclosure would have made. A disclosure ought to have been made. That this is so-and-so, whichever way, sort of there is a matter, etc. Actually, a lot of it can be avoided by way of a disclosure. Because transparency, as they say, is the best, or sunlight is the best disinfectant. There's an old saying.
Yes.
Now, 36 is the last paragraph. The
Section
aforesaid
34 tests.
Yes,
Section
correct,
34
correct.
tests.
I will not read it. Yes, your lordship knows that after the amendment in section 34,
Yes.
we have a constricted public policy, only fundamental policy of Indian law, most basic notions of justice. The attempt is only to tell your lordships that objectivity in the decision-making process, impartiality of the arbitrator are the cornerstones. And if those are lacking, then that actually makes the award susceptible to one which is against the basic fundamental policy of Indian law, as also against the most basic notions of justice. So
And
in that
we
sense,
should not proceed on the premise that only trained legal minds will be arbitrators, appointed as arbitrators.
yes, correct.
Other people may come in also who are not legally trained or screened like judges.
Yes.
So when you are putting adjudication in the hands of a person, I mean, a more liberal view in favor of the bars, ineligibility should be probably taken.
Correct. The point from my perspective,
Curtail,
why I wrote a legally trained mind is because the error gets
Understood. yes.
accentuated.
Yes.
Perhaps
yes,
someone
yes.
else, maybe there was an engineer, retired engineer as the arbitrator. Let's sort of give a benefit of doubt. The person perhaps didn't have the full
And
understanding.
even then the
Yes, even
clauses
then.
would have.
So the construction of the schedule remains the same. The construction of the schedule does not change at all. That remains the same. The question is when it comes to your lordships appreciating the facts.
This might relate to your previous argument also, that even in the perception of the arbitrator himself, going by the first disclosure, that he had this perception that previous appearances.
Correct. Correct. Absolutely.
So even going by his standard.
Yes, that's the test.
That is your last argument.
Correct. Now, my lords,
Last
now what remains to be, my lords, shown to your lordships are only 4 or 5 judgments that I wanted to place on the application of the schedules. That is what remains.
Yes.
I have to also, my lords, answer to your lordship's question. Now there are 2 questions to be answered.
We have
One is
forgotten the
previous
questions.
question.
I have forgotten the questions.
No, that was a very interesting question. I thought about your lordship's question.
What was the question? We'll write
Yes.
down the question and then.
Your lordship, if I remember, my lords, I am able
No,
to
no,
articulate
we'll
as
come
well
back.
as your lordships did. The question was that you can have a situation
Both
in
parties.
which both parties have
Yes.
equal stake in another company. Can the arbitrator take up that company's case? So you have A and B. A and B have, say, equal 25, 25, 50, 50 in C.
Roughly speaking, they cancel out each other's
Exactly.
bias.
That's the phrase. That's the phrase your lordships have used.
Yes.
Because my answer to that is that there are two points here as answer. One is, if that case comes up first, has the arbitrator made a disclosure?
Disclosure is essential, but does it become ineligible? Because
According
it's
to me, yes, it does.
tied. All right.
Because the spirit of, so if your lordship was to construe the schedule 7 as an absolute bar, it doesn't matter whether anything is cancelling out or not. It's an absolute bar.
But the premise that the logic behind it goes then.
Fellows may not go.
Bias is you are favoring someone.
Well, so let me put it the other way. Why should, if you are already in a dispute scenario resolving as an adjudicator, A versus B, and A and B both happen to be connected to an entity C, maybe equally so. You used
to say about some people that they either appeared for one of the parties in that particular court, this counsel, eminent counsel, either appeared for one side or the other or for both. So,
yes.
So that would take out so many people.
Yes. Perhaps in that sense, your lordships are loosely saying cancelling out the.
Yes. But you say still the rigors apply.
Yes, I would say that's a schedule. If you're falling within the schedule, then I mean either you are in it or you are out of it. That's the way I look at it.
Right.
So if you are in it, then you are ineligible. Now, 4 or 5 case laws, which if your lordship permit me half an hour on the next day, I will place them.
Today you're in difficulty.
Today, some difficulties. I've run out of steam. May I say that with respect?
No, the only difficulty is we have 15 minutes left.
Yes.
But the person who is on the queue, the next matter, none of them may be ready. So who is in the next matter? Is anybody there in the next? You are appearing. You are ready to do the matter.
I have been led by Mr. Ford, my lord, when he is engaged in courtroom number 37, my lord.
The matter after that? So this is our apprehension.
I am unfortunately not.
Did not waste the 15 minutes of your time for this. I mean,
No, I'm saying I'm not carrying all copies also of
Need
the
not,
case.
need not, just give the citations if you.
I would like to
Do you
place
have-
them. There is something important. Some cases in which, so one of
No,
the
no,
case, for
if
example,
it's SCC online, we can,
no,
one of us have.
no, I'll tell your lordships. One of them happens to be a case of the Bombay High Court, where strictly speaking, the test of affiliate as they are
It's an
propounded.
unreported judgment.
It's a reported judgment. I do not have copies. I may not have my marked copy, unfortunately. I was, in fact, I perhaps ended up sooner than I thought I would. That's because I carried a written note, which I thought it would make it sort of more convenient. Only Mullahs give me half an hour on the next date and I'll finish it. And then Mr. On the other side can start their reply.
Yes, that's the understanding that he'll finish it. So,
I'm told my lord has already fixed a matter 10:30 next Wednesday. Mr. Anirban Ray mentioned.
oh, yes. This will be after that, it will generally be in the list as parted. So if you're, so we'll not put it at the top then.
Second top.
পার্ট ম্যাটারস গুলো কি আগে দিয়ে আমরা লিস্টে অ্যাসাইনমেন্টের মধ্যে না যদি পাঠার হয় ওটা আগে আসে তো এর আগে পরের দিন কি এর আগে কোনটা আছে একটা অনির্বাণের আজকে ফিক্স করলাম 10:30টায় ওটা তো টপে আসবে তারপরে কি এটা আসছে অটোমেটিক পাঠারের মধ্যে এই সিরিয়ালি এটাই আসছে
दिल्ली जाने में लेट हो जाता है
সেগুলোর পরে আসবে
What about can you do? I mean, if you're not, sir is available on 10th.
Sir is available.
Or we can do 17th.
10:30.
17th कर ले.
ও টপ ছিল বলে
He's not there from 11:30 because he has a fixed matter.
এটা তো টপে আসবে নেক্সট ম্যাচ
Anyways, it's okay. You have to argue more on that day. You take. I'll agree. So if you want to keep it 2.
Mr. Diwan, you come from outside.
I come from Delhi.
Or can it be, my lord, subject to, my lord, I was asking my learned friend on the other
The
side.
week after that.
No. Week after that, my lord, I inquired from Mr. Mukherjee, my lord, he has a fixed matter at 11:30.
Then
So
difficult.
I think he will take some time and then at that point in time, my lord, Mr. Mukherjee has to start. So I was, my lord, just
You
subject
take
to
15 minutes. He said 15.
Correct. Maximum of
Maximum
20,
half
25
an hour.
minutes.
Yes,
Maximum half an hour. Just only the judgments have to be
So
placed.
would it be my lord's pleasure to keep it at 2 o'clock in that case, my lord? Because 10:30 matter may continue.
2 o'clock we cut into the appellate side matters. Two heavier lists there. That's the main brunt of the list is there. All these are assigned. We originally intended to take up our contempt matters and part-heard matters. We finished those, but every day a new matter is being assigned to us.
Because lordship is finishing the other.
Yes, that is it. Is becoming counterproductive.
Yes.
So that's the difficulty. Now we are taking up only assigned matters. Just see our list.
Whichever way you take your day. I'm okay.
Next day. Next
So we'll
Wednesday
keep it-
we'll come.
Let it
next
be next week in the list. But if he comes and goes back, if that 10:30 matter goes on, we are apprehending that.
May I just inquire from Mr. Ray and my lord indicate to the bench?
Mr.
can
Ray
just-
will take time. He was ominously, panting when he came in.
Next Wednesday we
है
will.
नहीं ना वो 17.
There's some stake in that.
अच्छा okay.
Yes, he is there, my lord. Mr. Dashgupta is there. He says it will go
Oh,
on.
he's there. No, it would go on throughout the day.
Then
The combination is
then
deadly.
avoid-
Him and Mr. Dashgupta and Mr.
So then
Rai.
17th I can finish for whatever half an hour, 45 minutes, and then they can
My lord
continue.
keeps it for them to finish on 17th.
17th.
I am told Mr. Mukherjee may be in difficulty. So in that case, lordship may have to, if my lord is very kind to give us some time on 24th to reply so that we end it this side of the vacation.
Mr. Dashgupta, what is the matter about your matter? I'll just take half a minute.
The trust millard and expertise order has been passed. Now, millard the entire millard the companies who are millard the part millard
Who is
trustees.
in the other side?
Mr. Rupak Ghosh.
Mr. Rupa Ghosh is in the other side, and
Other
you
side
are
led by
Mr.
Mr. Suman Datta.
Yes, and led by
No more, let's end.
Mr. Datta. Mr. Datta will finish within a limited time.
Control
And
downwards.
I am led by Mr. Ray and Mr. Ratnanko Banerjee.
Malad, there is nothing much in it, Malad, only Malad.
Mr. Ray is there. We can request him to, my lord, start
Online,
at 12 instead, my lord, if required.
It would not take more than
Mr.
10
Banerjee
minutes,
is
Malad.
above you, both of you.
Mr. Ray, yes.
Mr. Banerjee is above me, Malad, but Malad,
Mr. Banerjee will be there in town next Wednesday.
Malad, if Mr. Banerjee is not there, I will move it. Malad, it's
My lord, I have
very
inquired
important,
from
Malad.
Mr. Mukherjee. In the meanwhile, 17th, he says, my lord, 17th, no?
Not
17th.
difficult. So I will keep it on 17.
17.
So this will appear at the top on 17.
Yes, I'm so deeply obliged, and I'm
Great.
sorry, Malaj, for
And
could have
Otherwise,
perhaps
Mr. Diwan can indicate those 5 judgments, the citations at least, my lord. We can also, my lord, come prepared.
Correct. I'll give it.
Yes,
to you
yes,
in
yes,
advance.
yes.
I will do it. No problem.
Definitely. Heard in part, let the matter be listed on September 17, 2025 at the top of the list for further hearing.
Grateful.
No, no, common.
His matter was the best
Matters
example of
select.
control upwards,
Right.
Mr. Diwan.
এটা একটুখানি ঢুকে।
Control upwards. Grateful.
Thank আরে আগে রিটেন নোটস ওই যেটা আমার নোটস ওর সঙ্গে এগুলো সবই তাই।
আমাকে না বিশ্বাস
ওহো রাইট এটাতে এগুলো এইটাও ঢুকে।
You forget you have to run to Delhi.
ওরা যে রিটেন নোটস সেগুলো আমার নোটসের সঙ্গে। Mr. Dotto is on queue. Next matter.
Yes, I'm good.
Thank you.
কত নম্বর?
Call.
হবে আমাকে
কি করছে?
I am appearing for the institute, my lord.
I am for the
appellant. Matter of
My lord, I am for the complainant, my lord. The both
In which matter?
next 4 and 5, my lord.
5 টা বোর্ডে দেখান, কল করুন। আপনি ওদিকে ডিরেকশন দিন।
My lord, both.
But I have completed my submission. Mr. Joydeep Kaur was supposed to make submission.
My lord,
but
I have been led by Mr. Kaur. We are for the complainant, my lord. And Mr. Kaur is already engaged. But if it can be next week, subject to my lord's convenience, my lord.
Yes, very well.
And my lord, we will take some time also. It would not have been completed within 10 minutes, my lord.
So, you are for the respondent.
Yes, my lord. Respondent come.
Very well. On the prayer of the respondent, let the matter stand adjourned till September 10, 2025.
Grateful, lordship.
very grateful, my lord. Very
4 and 5, my lord. Both 4 and 5.
4 and 5, both.
Lordship.
একসঙ্গে যদি লিস্টে অ্যাপিয়ার করে তাহলে একসঙ্গে একটা অর্ডার করবে, কমন করে দিই ম্যাটার্স গুলো।
Lord, I appear on behalf of the appellant.
Yes.
My lord, this is that matter, my lord, where the Thicker Tenancy Act, my lord, is involved.
Yes, yes.
My lord,
Remember.
Lord,
So,
I
is there.
recall that that is my that Mr. Shah had taken a point that this 2001 Act is no more applicable to him because
Yes.
by virtue of the repeal, the savings clause came into operation. So therefore, the suit was filed much prior to that. Therefore, it is not applicable.
No.
That was patent substance is the
Yes.
submission of Mr. Shah, if you not remember.
Thicker tenancy act যদি বুঝবেন thicker tenancy.
Now, my lord kindly sees this suit was filed in 1995. In 1995, 81 Act was prevailing.
There, yes.
So let us see whether 81 Act might also contains the same provision as that of the 2001 Act.
It did not. Did it?
Yes,
আচ্ছা।
yes. Now, my lord, kindly, may I just start from here? Now,
Yes.
2001 Act.
2001 টা তো এই যে
ক্যালকাটা thicker tenancy.
Yes,
এটা 2001 টা
2001, আমাদের
পরেরটা তো
1981.
হ্যাঁ, এই যে
81 Act
এই যে
is
অমূল্য হোক
23,
Facebook.
23
section 23,
23.
bar to jurisdiction. No civil court shall have jurisdiction,
No, this is
81 Act.
81
oh sorry. 23 years.
The language of both the acts are same. So the
To
outskirts,
determine any manner which the controller is empowered, but the controller in the first place was not empowered to decide these questions.
no,
This is the bar.
no, this is, my lord kindly says the section 23. Bar to jurisdiction. No civil court shall have jurisdiction to decide or deal with any question or to determine any matter which is by or under this act required to be or has been decided or dealt with or to be determined or has been determined by the controller or the appellate or other authority specified in the provisions of this act, and no order of judgment passed or proceeding including execution proceeding commenced under the provisions of this act shall be called in question in any civil court. So therefore, specifically, my lord, this act has ousted the jurisdiction of civil court, and this has to be decided by the controller,
In respect of powers which are given to the controller.
given to the controller.
Show us from the powers of the controller in this 1981 Act that he had power to decide question of ticket
But
tenancy
I
and
am coming to that. But this clause of this jurisdiction clause which has been given in 23, unless the commissioner did not have the power to
he had other powers, so those could not be exercised by the
determine. Also, my lord, kindly see the word determine. Determine of any dispute in the civil nature.
of civil nature. Where do you get?
My lord, kindly, no civil court.
Civil court cannot decide.
Civil court, my lord, section 9, all matters come under section 9, comes under the civil court jurisdiction. So therefore, this suit is a suit for eviction. That also comes under section 9 of the civil procedural
Under
code.
which provision of the 1981 Act did the ticket controller have power to decide questions of ticket tenancy or Bharatiya?
No, this is only in the section 23.
Ah,
Section in 23.
what sort of argument is this?
My lord, this is the
Don't say whatever Mr. Dasgupta is asking you.
My lord, 23, if this jurisdiction was not ousted, my lord, there is no meaning of this particular section.
Absolutely, there are so many things the controller could do, the civil court could not. Like in Premises Tenancy Act also, 97 Act also, and 56 Act, the court does not have the power to do what the controller can.
My lord,
Now this repair and all these things, urgent emergency repairs, those powers are vested with the controller, and still LRTT is approached against those orders.
2001 Act only difference is there is element of incident of the
Incidents of ticket tenancy.
tenancy. Incident of tenancy has been defined, which is, my lord, not available in this. That particular section 5 is not here in this act. And 5 is there, 3 is not there. 5.3 has been inserted in 2001 Act. But that is only with regard to the incident of tenancies. Nothing else. There also, my lord, also not specifically mentioned anything about the power of the controller. The power of the controller has been given in this act only with regard to decide and determine any matter. If you also kindly see the language.
Where is the section giving the controller the
23.
power to do that? 23 is a bar. 23
23
is
is
very specific. What does 23 say?
If the bar,
No civil court shall have jurisdiction to
specific.
decide or
Yes.
deal with any question or to determine any matter. Which matter? Which is by or under this act required to be or has been decided or dealt with or to be determined or has been determined by the controller or the appellate authority. So in the first place, the controller or the appellate
that is missing here. That is missing here.
that is the
But
vital thing.
Otherwise, my lord, this section would become odious.
Why?
Well,
There
but
are so
kindly
many
see,
things the controller
Not so
could
many
do.
things, my lord. Kindly see the language in section 23. It is become a general section. It has not specified in respect of a.
It's a very specific section. Only things which the controller can do or has done cannot be done by a civil court.
That's right, my lord. The evidence, the eviction suit, my lord, comes under the civil action. And if the civil action only can be entertained by the civil court, and the civil court is barred under section 23, then, my lord, this according to this provision, my lord,
If you come to suppose, for example, section 11 of 81 Act.
section 11.
11.
Tendency of Bharatiya to
Now,
continue.
there subsection 3 gives power on an application made by the Bharatiya under subsection 2. Controller shall, after giving hearing, direct the ticket tenant to reconstruct similar accommodation and restore possession to the Bharatiya within such time as the controller may decide.
Yes.
And if the ticket tenant fails to comply, entitled to reconstruct. Now, this, for example, the civil court could not be approached by a civil suit for asking for this relief. Please pass this direction that that a reconstruction has to be made. So these are the powers which the
But
civil
here
court could not do.
already the parties have gone before the controller. Controller has entertained that.
Yes.
Controller is in session over that matter. Controller has heard the matter and given time.
In your case.
In my case.
Yes, exactly.
In my case.
That is all the more a reason why it should not be interfered with by the
No,
TPC.
controller is hearing the matter during that stage whether civil court can entertain dispute. And that was the issue raised by them. The first issue.
Controller cannot decide whether civil court can decide that. Controller has to decide the question of Bhartiya and ticket tenancy.
Right.
Whether it's a ticket tenancy,
Whether
and
it comes under the ticket tenancy or
ticket tenancy or not, and also under section 8 to decide eviction suits between ticket
So
tenancy and
therefore, my representation before the Tika controller is that I am a Tika tenant
that has to be decided by the controller.
by the controller. That is my case also. That would be done by the controller.
That dispute is arisen in this suit also.
Yes, that is also an issue before the suit. Now, my lord, kindly see one issue. Kindly see one issue. My lord, issue is at page.
The paper book.
63. 63.
Well, this question has already been decided by the courts, my lord. I had cited before your lordship the single bench judgment where, my lord, several, my lord, other judgments with regard to whether, my lord, there's a power vested in the controller in the 81 Act has been decided. I cited the judgment.
Yes, that is Justice Pratap Roy's judgment, my lord.
Yes.
That judgment has not considered this particular issue.
Section 23 of the 81 Act. We will consider.
And my lord, kindly come to page 63 once. Kindly. I have read your lord.
You know the answer, Mr. Dutt.
My lord, I know that.
You know the answer to the question which you are raising.
I'm trying to get a different answer, my lord. My lord, page 63, my lord, can you see?
Yes.
Whether the defendant is a Tika tenant in respect of the suit property.
This is where the statutory shoe pinches.
Absolutely.
He could not do that.
My contention is
He could not do that.
according to the ouster clause in the section 21 Act, that would be decided by the controller. This issue has to be determined first.
By the controller.
This issue, who will decide? With my respectful subject.
So if your argument is taken to its logical conclusion, even under the 1981 Act, this bar was there.
Bar was there.
Then also the court could not do this.
Court did not do it. And my lord,
court could not do this then.
There is no difference between 21 Act, 81 Act and 2001 Act. The only difference is that section 5, subsection 3.
If you say that, then under the 1981 Act also the court could not frame this issue. If your argument is taken to its logical.
But when it has been issued, issue has been framed.
Then it has to be set aside.
Trial that ought to have been held that I do not have any jurisdiction in view of section 20. And I am asking for this setting aside.
No.
Well, consider that, my lord, kindly. Otherwise,
yeah, we'll definitely.
This section 23 will have no meaning, my lord.
We'll answer that question in our judgment.
And kindly see Justice Pratap Roy's judgment.
Yes, that was cited by Mr. Shah.
I am also going to show your lordship the Justice Ray's judgment. My lord, Justice Ray has not considered this particular issue.
Section 23 of 81 Act?
81 Act.
No, that is not considered. That we have seen.
That has not been
probably that was never argued before any court. It's a novel idea.
So that point was not.
It's a novel idea which no counsel ever thought of. You have thought of.
I am saying, my lord, this ought to have been also considered by that bench. That has not been done. So therefore, Majalia really does not come into the way. And lastly, my lord, the money squares judgment. That do not come under the consideration in this matter at all. That was not the issue.
Tenure was the issue.
There was a tenure.
More than 12 years.
12 years and 20 years. That was the point of consideration.
So on facts, it is distinguishable.
As well as the pakka structure, my lord.
Pakka structure. That was not the point.
We'll look into that.
But may I just take only one order passed by the revision.
No further.
Preventing them from proceeding with the Tika controller.
No further.
As well.
Hearing is concluded. The matter is reserved for judgment.
Grateful.
Thank you.
Shortest reply, my lord, as much as possible.
As much as possible is a keyword. Yes.
Sorry to disturb you. Item number 44 of the day's list. It's an application, and we are really suffering, the nature of the order.
Application.
It is an application. It is not a hearing matter.
So you want the application to be taken
To be listed under the heading so that it can be heard, on a
right? We will do that. Tell application.
It's an application.
44.
44. 44. 44. It is an application. The application
is for the other side.
I have served notice. I am for the respondent. Fox and Mandal is in the other side. We have served.
No, it was mentioned for hearing.
It was wrongly mentioned
by them probably.
It was taken up for consideration by your lordship on a particular day. Looking at the nature of the order, your lordship indicated the matter to appear under the heading application on a particular day. Without, of course, I do not recall whether the order has gone into as an application or not, but it is an application. They have come up against the Honorable Single Judge's order, whereby they were directed to give us a particular document.
You just write on a slip of paper or give the handover that
entirely.
It 44 টা কালকে ইয়েতে দিয়ে দিন, application heading দিন.
Great.
Lord,
Yes.
May I respectfully Lordship mention these three matters with a prayer for extension of time for filing affidavit in opposition.
Yes, it will appear as to be mentioned. Not in the list.
Not in the list. Already direction was there. We have jumped that time in one matter.
To be mentioned there. Yes.
Lordship, presently determination in your court. Previously, Lordship, court number 6, Honorable Court number 16 has ordered on 6th August 2025 will be listed after 3 weeks.
What is the matter relating to?
To be mentioned.
What does the matter relate to? The subject?
Dissolution and decree of divorce, matrimony also.
To be mentioned. Why?
To be mentioned.
What will you do?
After coming, it is hearing.
We are not adding hearing matters. So why put it as to be mentioned? When we permit hearing inclusions, we will
previously order paper book filing.
Paper book, file the paper book. We are not adding hearing matters right now. It will not appear right now.
After the to be mentioned.
No.
To be mentioned.
Why to be mentioned unnecessarily?
Unnecessary to previously order.
No.
Previously order.
No.
Paper book.
Not right now. Will paper books have been prepared?
No. 2 weeks. I am filing the paper book.
File it in the department.
Department, please to be mentioned this.
Why?
Matter. After that, it is hearing for.
You have already filed the paper books.
No, sir.
File the paper books. Then mention for hearing.
Previous court submitted that. Secondly, you service of summons. But I summons the service among
you prepare the paper books, and then when the paper books are prepared, office will give us stamp ready for hearing, and then when it is ready for hearing, mention before us.
3 weeks after 3 weeks, Lordship.
No, file the paper book, then mention after the vacation. Yes.
Permitted to mention on application for inclusion.
Yes. Next, call on the list.
Well, I appear on behalf of the appellant.
Don't want to proceed?
Well, grievance of the petitioner has been redressed, and he has handed over.
What has been?
He has handed over me the written instructions to my senior.
Since the appellant does not want to proceed with the appeal and the connected application, FAT 185 of 2024, along with Can 1 of 2024 and Can 2 of 2024 are dismissed for non-prosecution without any orders to cost. The written notes of the written instructions filed by learned counsel for the appellant in that regard today be kept on record. Interim orders, if any, stands vacated.
First time before admission.
First.
Because the pendency of the appeal, this is.
Yes.
My written note on behalf.
Oh, yes.
Maybe file a written note.
Written notes of arguments filed by the parties be kept on record. Hearing is concluded and the matter is reserved for judgment. Thank you very much.
Grateful, my lord.
Next. Yes, Mr.
For
Ghosh.
the petitioner.
Yes. You are for? And state.
Lordship, Mr. Siddiqui was engaged in this matter before, but he left the panel. So along with him, Mr. Dhor was assisting him, but since he's a senior gown, he cannot appear alone in
yes.
this matter. So kindly keep it next week any day.
Yes, Mr. Ghosh. That's a real difficulty. On the prayer of the state, let the matter stand adjourned till when? Tell us.
Next week, any date.
Till September 28, September 8, 2025. Next Monday. Give your names, please, appearance, all of you. You give your name at least for the state and private respondent also, whoever. Is yes. Sorry. Your state, who is for the petitioner?
Mr. Naik is for the petitioner, but he's not well today.
So you have been interested with asking for adjournments today? Yes, we are adjourning it then. On the prayer of the petitioner, let the matter stand adjourned. For the day only?
For the day, Lordship.
Adjourn for the day. Thank you. Yes. Unfortunately, only the state is there.
Unfortunately. Right also. Five, same junior, same advocate under Dhananjay Nayak.
Same Lordship.
Must be same.
Five same matter.
On the prayer of the petitioner, the matter is adjourned for the day. Right. 6 seconds. Yes, sir.
The private respondent.
Your advocate on record is related to you. Related to you. Advocate on record.
Yes, my lord.
Your advocate on record is related to you.
Yes, my lord.
Who is?
My son.
He's your son. Oh.
Your lordship knows, my lord.
I did not.
What is
I know him separately.
Independent. Your lordship want to. No, I don't want to say all.
Anyway,
anything.
My memory. Sorry. Yes, Mr. Bhattacharya, what is the matter?
My lord.
Any private respondent in this?
Yes.
You are for the
I'm for the private.
Right.
My lord.
Mr. Bhattacharya, yes.
My lord, both the.
Let your junior argue the matter. Start. Let him start. Let him start.
Yes, on first appeal, when I was absent, then you also asked him, you are competent, you do it. He argued the matter, people also, when you lost in the court now.
Let him start. Let him start. You pick up.
Oh, he's not dead. That is
yes, what is it?
But one Piaru, he was the original owner of the subject plot. Total area of the land was 8 decimal. And the Piaru, he died.
Who?
Piaru, one Piaru.
Piaru.
Yes. He died.
Right.
And living man, Akbari wife and Mukha Akhtari.
Do you have any your genealogical table or list of date? Very well. Let us continue. Yes.
I can prepare also.
No. Your list of date is there. The writ petition itself. Yes.
The years of the Piaru, the total area of the subject land was 8 decimal. That was sold in favor of the petitioner, private respondent, and one Samsul. Oh. In the year 1997 and 1995 also, 1997. They were not. My client, my lord, before losses, my lord, who purchased the land also, he did not apply for recording his name.
You purchased from heirs of Piaru.
Yes, of Piaru. As the private owners also purchased, admitted, they also purchased from Piaru.
Demarcated portions or?
All demarcated. We are in position all demarcated. Now, what happened? Both the 3 purchasers, they applied for mutuating therein before the Bhatpara municipality.
Right.
And Bhatpara municipality initiated proceeding. Mutation proceeding. And that mutation proceeding, that Samsul, the private respondent, that Sarapat, disclosed, his name has been recorded with regard to enter 8 decimal of land in the record of right. That is for the knowledge. The moment we came to know from his application, we applied before the Bureau of Concern to correct the record of right. Then we made an application also under RTR Right to Information Act by how his name has been recorded with regard to entire 8 decimal line. Did not give a
8 decimal was the entire area of all three of PRU.
PRU. Then my lord, we filed an application before the tribunal.
Now RTI, what happened there?
RTI was under by how the entire 8 decimal.
What was the reply?
No reply.
Well, then tribunal?
Tribunal disposed of the matter, affidavits are exchanged. In the affidavit, you also can see page 103. The BLO
order you are challenging.
I am challenging. No, 103, the state had submitted the report. Very vital. Page 103.
Yes.
You also keep over page 104. Brief history.
Right.
Then one with the Sagar, such and such.
This supports your contention, this report?
Yes. My contention.
All right.
Vidyasagar saw purchase measuring such and such record, such and such from Akbari, Begum, wife of Muhammad Piaru and Makula Akhtari, such and such by deed number.
You are Vidyasagar.
Then my lord, yes, Vidyasagar. Then my lord, one verification of the record, such and such. So, then Rasnum Bibi transferred her land to Muhammad Piaru and Muhammad A to register this such and such. Muhammad Piaru and Muhammad Isai got equal share. The part of Munirud Bibi was obtained by sold to such and such.
Applicant has peaceful possession means you.
Yes.
Last sentence of that.
But it's the last for 3 lines. The plaintiff with the Sagar. Plaintiff is got it.
No, that you have seen. Up to the next page you have seen.
Purchase such and such.
We have seen up to the next page.
Yes.
The last line says plaintiff applicant is in peaceful possession means you.
Yes.
Okay, anyway.
Then when a plaintiff
purchase details are given, everything.
And Muhammad Sarafat. Last 3 paragraph.
Seen.
Yes, let's go. Then next page, 105.
Next page also seen.
Seen. Then when it is admitted, it is admitted, both of the 8 decimal of the line.
3 chairs, yes.
The one and record of right, you also can see the record of right. Record of right, page 57. Page 57. Takraba 2126. Sachan Muhammad Sarafat, 4 decimal.
This is according to his share.
According, not his share.
More.
Yes, there was no basis of this record of right. No basis.
So you challenged this. You challenged this.
Challenge. Next also, my lord, 4 decimal. Entered 8 decimal was recorded in the name of the private respondent. But the PLO concern submitted report before the tribunal. It is wrong. Admittedly, both 3 persons.
So let us understand this, Mr. Bhattacharya. What was the first occasion to go before the tribunal? Like you challenged what? Before
challenging because non-action on the part of the bearer of concern.
Considering your representation. So tribunal directed that to be considered.
Considered. Then we have 2 parts. That is why I have come. Considered.
After taking that report, then it was sent down for consideration. That
yes,
report
yes,
as page 1.
Yes. After sending.
All right. Then
a report admitted. This is record of rights is wrong. They were admitted. Now, my lord.
Then what happened?
Then tribunal.
Tribunal.
Tribunal order.
The first order of the tribunal.
First order.
Previous order.
Impugn order. Only 1 order.
No, tribunal previously directed the matter to go down.
No.
Oh, achha, that matter was disposed of.
Yes.
Achha, let us see.
What is your loss? Can you see, my lord? Right, see, what is this? Page 3, your loss, can you see?
3, yes.
In this matter, first, the private respondent number 4, that is the private, submitted opposition claiming his title to the property by inheritance from his predecessor. It was disclosed in the affidavit of omission that since Piadu sold his exchange share to subjectual land to Manurun and alias such and such by exchanging registered shareholder, Muhammad Piadu subsequently ceased to be the owner of subject land as to the alienate for their having no transferable interest left in the subjectual land to the applicant. As the predecessor respondent number 4 failed to get his name recorded in the corresponding record, the private respondent has his name mutated in the record right. In the aid of affidavit in opposition, Mr. Dale, an advocate, repeated the private respondent number 4 submitted that unless the order of mutation was challenged before the appellate forum, the record rights could not be automatically corrected in the aid of representation submitted for the purpose. Then, my lord, my submission, BLO has already admitted in the record of right. It is no basis, record of right, entire years of the PRO sold the entire land to this 3 persons.
Mutation was done by the municipality.
Municipality's mutation, I challenged that order. I came to this honorable court. The division bench also passed an identity order. This matter is pending before the tribunal.
Mutation has been challenged independently.
Mutation, yes.
Mutation was challenged. Authority refused.
No, mutation.
Challenged before where? Which authority?
Mutation. Bhatpara municipality. Muted the name of the private.
You challenged that in a writ petition.
The writ petition.
Writ petition is pending.
No, disposed of.
Dismissed.
Disposed of. But that will be decided when the record of right will be corrected. Then that will be decided.
That is also very relevant because tribunal proceeds on the they proceed on the basis
that order I have annexed. That I have.
First that order, then will come.
Yes.
Because the premise of the private respondent is that unless
Page
that
65.
mutation is corrected.
Page 65. Is that a challenge this order before the appeal court also, my lord? Page 65. The private did not appear also.
No, mutation happened during pendency of what matter before the
mutation by the municipality.
Municipality mutated the name prior to the records of right correction.
No, after his name was recorded, the municipality.
First records of right.
Record of right.
That you challenged before the tribunal ultimately.
Yes.
So during pendency of that challenge, this mutation was effected.
No.
Achha,
back to that. Mutation order have I also annexed before this in this.
First mutation happened.
First mutation by
challenge that by UEFA writ petition. That writ petition was disposed of.
Disposed of.
This is that disposal.
Yes, that I challenged that single judge order before the appeal also. MAT.
So what did the single judge do? Learned single judge?
Single judge, my lord.
We affirm the page 67 kindly says, my lord.
Page 66.
We affirm the order.
Okay.
No, 67 is the division bench. We want the single judge's order.
Court, that has been quoted.
It is not in act.
In view of the submission being made on behalf of the respective party, it appears that the mutation name of the petition connects with the land in question during pendency of the original application before the tribunal as paid for by the petitioner cannot be decided. No order need be passed on this writ petition, excepting granting leave to the petitioner to approach the concerned authority of Bhatpara municipality for mutuity the name of the municipality after disposal of
yes, this also says that mutation during pendency of the original application. What original application was pending before the tribunal?
That order I have challenged. But there are two orders. I'm subject to correction. I have challenged the order of the correction of the record by the PLRO.
That challenge was taken out first.
No.
Then why is it said in this order?
Sorry. That challenge was taken up first.
That is what we are repeatedly asking you. Otherwise, how could that be pending when the mutation took place? So the mutation took place during pendency of that application, tribunal application. Learned single judge says in view of such submission, it appears that mutation of name of petitioner in connection with the land during pendency of the original application before the tribunal.
Yes.
With the municipality.
Give us the chronology. First mutation happened.
What mutation happened?
You challenged in a writ petition.
Yes.
That writ petition, this order was passed.
That order is page 61. Municipality.
Was the mutation.
Mutation by the municipality.
So mutation was dated 2nd of May 2014.
14.
Mutation.
Very
well. Record of right, when was it recorded? Their name recorded?
The record of right 2014.
2014.
That was challenged in a way.
That is challenged
but
in a way.
page 61 says the mutation also happened in 2/5/2014. Page 61.
Land record.
Similar time, after recorded by the BLO concern, they sold the recorded by the BLO concern before
this is the municipal councillor Bhatpara municipal.
What was the municipality?
It was against that.
So mutation was based on record of right.
Yes.
First record of right happened.
Yes.
All right. Very well. The single judge said that by then you had challenged the records of rights also.
Yes.
Yeah, that's why OA is of 2014. Kindly see, that is a OA is of 2014.
That is 2014.
Kindly see, OA is of 2014.
OA, in the OA, what was challenged? The
ROR.
Very well.
Not ROR, but
with not ROR, I will show not only inaction of the respondent.
Representation regarding ROR? Inaction,
That
tribunal.
is page 59 application.
Original application not annexed to the writ petition.
So division bench said what?
Division bench says, my lord, affirm the order, my lord. Division bench, my lord.
Original application requires the tribunal to dispose of.
The basic given, page 2, the basic given the appellate petition is that his land has been wrongly mutilated the name of the private respondent. He wants some to be unknown. It is not in dispute that he has challenged the insertion of the name of the private respondent in the recorder as owner of the concerned land.
So basically, it was left to the tribunal. First, the adjudication was left to regarding the record of right. First, that had to happen. Then, consequentially, mutation.
Yeah, mutation.
Apparently, that was retainer.
Yes.
But the tribunal also dismissed, saying that let us see the tribunal's order.
Yes, let us see. Page 3. Can you see the page 3? I have read, my lord. The learned government deputy submitted status report. Page 3, last portion.
No, observation. Internal page 4
Page 3 of the impugned order, tribunal's order.
Yes, yes. Furnishing some inputs therein. We have considered the submission of both sides. The order of mutation, if any, granted in favor of the private respondent number 4 for the subject schedule entirely measuring 8 decimal line could be easily challenged before an appropriate appellate authority. What was not under challenge in this way, after exhausting the appellate forum, in contest with the prior mentioned at the beginning of this matter, the disclosure made in the affidavit official reveals a series of change of transfer prior to gathering interest by the applicant in the subject schedule land. When a simplicity representation has been.
So what is the wrong in this? The BLO has been directed to decide.
Then, my lord, they are directed to BLO concern. This is the appellate. Then, my lord, what I have filed this application. Why?
Why?
Page 5.
Page 5, yes.
Private respondent would be at liberty to put his defense as available under the law, more particularly described in the affidavit office at the time of making considered representation. And if such points are raised, they may be resolved. My submission before lordship, what is the The BLO has admitted in the report submitted by the government representative, it's wrongly.
No, but that will be a piece of evidence. This, he has to be, because the record stands in his name. He has to be given a hearing.
No, BLO has stated in the report.
It is not automatic that your representation, you have filed a representation. That representation will be considered, but only upon giving the present recorded owner an opportunity of hearing.
But that recorded owner says it is appellable order. Now, if any order has been passed by the BLO concern, that is appellable under section 54. Then what I am, that is disturbing my lord. That they will say before the BLO concern is appellable, you did not prefer an appeal, I am rejecting, my lord. But BLO has admitted.
So actually, why didn't you prefer an appeal? It's an appellable order. You are right.
I know.
So I know. Therefore, to bypass that, you are doing
No,
this.
I do not know. I did not get anything, my lord. I filed an application for reconsideration because it's admittedly I have purchased the land.
You yourself sought for a direction on the BLR to be. You approached the tribunal saying that this was of my representation. That has been granted.
No, what I am submitting, part of the order, the report submitted before the BLO, tribunal by the BLO, that also should be considered. But
whatever material is there should be considered.
But that has not been, only that has been given to the private respondent report. But that report, I can raise that report also.
You are the private respondent. What is the difficulty if we grant him liberty to rely on that report also before the tribunal, before the BLR?
I should
you will be given an opportunity. Definitely, you have to be. But a report was filed by the BLR in his favor. He is also entitled to rely on that. So that's a part of the tribunal's records.
My lord, one thing I should mention, during the pendency of the way application before the learned tribunal, this land was transferred in favor of the wife of the private respondent. He knows it. Kindly come to page number 65, order of the Honorable High Court. Paragraph number 3.
She will also be given a hearing.
His wife.
You go with your wife.
Wife.
It will be a family picnic sort of thing.
My lord, I do not have any land left with me at present.
And this transfer is to bypass this procedure of law. You have transferred to your wife. Are you separated? Are you separated from your wife?
Her name has been recorded in the.
She will also be given a hearing. We will clarify that.
She will also be given a hearing.
Yes, give hearing to all.
Yeah, and
If
because
you go, then Mr. Kali, we will also be given a hearing.
tribunal,
Whoever goes will be given a hearing.
tribunal has used the phrase interested parties.
Yes, rightly so.
Yes.
We don't find any wrong in the order.
More to submit.
They
We
submitted.
still don't understand what is your grievance, Mr.
But that gives me a report, but I
That report.
there, yes, that will
You
be,
have not been precluded from relying on that report.
that should be considered because it did not say anything. But report is not a support of
But opportunity of hearing to the other side does not mean no opportunity of hearing will be given to the.
But only for the report. Report has
It's an open-ended direction.
specifically said it. That
Favor of
report
mine.
is based on no.
In favor of my learned friend, I don't know why is he.
We are discussing this.
The report is that is my submission, madam.
The judgment form হবে.
That is I have filed.
Main application, the writ petition itself is taken up for hearing. Upon hearing learned counsel for the parties, it transpires that the petitioner's primary grievance is that despite the original owner Sheikh Pearu, Pearu, having transferred separate demarcated portions of the property belonging to the said Sheikh Pearu in respect of the petitioner as well as the private respondent and a third purchaser, erroneously the name of the private respondent was recorded in the records of rights against the entire property. Also, the property was mutated in the name of the private respondent. The petitioner challenged the mutation before a learned single judge of this court by way of a writ petition, which was disposed of, which order was subsequently affirmed by the division bench in the light of the observations that since an original application was pending before the Land Reforms and Tenancy Tribunal in respect of the recording of the name of private respondent in the records of rights, the matter might be canvassed before the tribunal. Next para. By the impugned order, the learned tribunal, while deciding the plea of inaction on the part of the BLLRO raised by the petitioner on a representation of the petitioner in respect of the records of rights, upon taking into consideration the affidavit of the private respondent, directed the BL and LRO to decide the representation of the petitioner by giving an opportunity of hearing to the private respondent, if necessary in the light of the affidavit in opposition filed by the private respondent before the tribunal. Next para. Learned senior counsel appearing for the petitioner contends that although opportunity was given to the private respondent to canvass his case, the tribunal did not specifically grant an opportunity to the petitioner to rely on the report filed by the BLLRO himself before the tribunal, from which it transpires that the version of the petitioner as regards the respective transfers of the property in the name of different persons, including the petitioner, was vindicated. Next para. Learned counsel appearing for the private respondent submits, by placing reliance on the relevant observations in the order of the division bench, that in the meantime, the property which was transferred to the private respondent has been retransferred by the private respondent in favor of his wife. Next para. Upon hearing learned counsel for the contesting parties as well as learned senior government advocate, we are of the opinion that there is no error in the order of the learned tribunal, inasmuch as the learned tribunal directed the BL and LRO to dispose of the representation of the writ petitioner subject to his suitability, convenience and authority vested to him under the law, after extending opportunity of hearing to interested persons, more particularly the private respondent. Next para. Although, while doing so, the tribunal specifically observed that the private respondent would be at liberty to put up his defense as available under the law, more particularly described in the affidavit in opposition, nowhere within the four corners of the impugned order has the tribunal restricted any of the parties to rely on all relevant documents, including the report filed by the BLLRO before the tribunal. Full stop. As such, comma, by the impugned order, comma, the representation of the petitioner was directed to be disposed of upon giving opportunity of hearing to all parties, comma, including the petitioner and the private respondent, and it should be read into the order that such opportunity includes the opportunity to all the interested parties to produce all necessary relevant documents, comma, including the affidavit in opposition of the private respondent used before the tribunal, as well as the report filed by the BL and LRO before the tribunal. Full stop. We further observe that the expression within double inverted interested persons also includes subsequent transferees, comma, if any, comma, and in the event a transfer has been effected by the private respondent in favor of his wife in respect of his share of the property, comma, the wife of the private respondent shall also be given an opportunity of hearing. Full stop. Next para. Accordingly, WP LRT 143 of 2025 is disposed of in the light of the above observations without any orders to cause.
That period has already been expired. Applicant to make communication to the concerned BLRO within 6 weeks from date. That should be extended.
It shall be construed that the 6 weeks time given to the BLLRO to consider the representation of the petition.
No. Communicate this
Communication duty on the applicant was within that.
Achha.
BLRO time frame is December.
It is deemed that the time for communicating the order of the tribunal to the BL and LRO stands extended for a further period of 6 weeks from this date.
Yes, Lord.
Yes, I am for the appellant.
Yes.
But I am for the respondent husband.
Wakalatnama?
My lord, Wakalatnama has been filed.
Entry number, filing date.
My lord, yesterday it has been filed, my lord.
Oh, then it was not filed previous.
Oh, my lord.
Then
I apologize, my lord.
should have been careful.
My lord. In the bottom of the page.
The case status and the details of the Wakalatnama filed on behalf of the respondent handed over in court today, comma, be kept on record. Full stop. It transpires that the Wakalatnama has been filed only yesterday.
Yes, my lord.
Only yesterday. Full stop. Be that as it may, comma, since the learned counsel, since the learned advocates appearing for the respondent now have the power to appear for the respondent, full stop, the matter is taken up for hearing. Yes.
Yes. Sir, I am for the Milord wife. Decree of divorce granted to the husband, Milord, the respondent husband. The husband challenged the marriage basically on 3 grounds. One, that is cruelty. Second is adultery. And third is, Milord, desertion. Now, Milord, at the outset, Milord, my submission is the decree granted upon the husband for desertion, that is illegal.
Cruelty and adultery were accepted.
Adultery, he did not get. He obtained the decree upon cruelty and desertion. Now,
so desertion is not maintainable.
Not maintainable.
Within time, within that period.
Yes, because there is a specific bar of continuous complete 2 years.
Yes.
From the date of
it was filed within that.
Yes.
As per the plain pleadings.
Yes, from the order, upon the submission of the husband, the wife left in 2019 and the suit was filed in 2020. So the decree of desertion
does not stand.
Yes.
Cruelty?
Yes. Now I am coming to Milord, adultery.
Adultery was not accepted.
At first instant, it may seem that it was in my favor, but this is not, Milord.
Oh.
Because kindly consider what was the situation when trial was conducted. My client, Milord, filed written statement, but he did not appear to adduce evidence in the witness box. Why he did not, that I am coming to that. So on the basis of the evidence adduced by the husband and written statement submitted by me and my advocate appearing before the learned court below cross-examined the husband, this decree was passed. Judgment and decree was passed. Now, while adjudicating the matter...
You did not adduce evidence?
No. Why, Milord, I am coming to that. Now, Milord, husband raised 3 allegations. Adultery, cruelty...
You said those, yes. Adultery, cruelty, desertion.
Desertion. Learned trial court believed cruelty and desertion. Learned court below disbelieved adultery. Learned court below either ought to have believed all the allegations.
Why?
Because there is
Adultery is linked with cruelty.
no, there is no iota of reasoning why trial court did not believe this, my lord, allegation of adultery. This is, my lord, a showdown of arbitrariness. The learned trial court pick and choose.
You are aggrieved because the trial court did not accept adultery.
No, I am aggrieved because this, while passing this judgment and degree, the learned court did not apply mind. The trial court did not apply the mind.
There was finding regarding cruelty.
Finding regarding, there was no finding regarding cruelty. Only one, that is preponderance of probabilities, that I did not appear before the witness box. So there may be some truthfulness in his case. That is, my lord, the trial court's finding.
But Carapiet's case is there. You should have confronted him with the counter sessions.
Yes, I am.
You cross-examined him.
My advocate cross-examined him. Yes.
Anyway, so now you are wanting stay.
My lord.
Now,
this application is for stay.
This is for
he says he has remarried.
Yes. In January.
May I be permitted to submit the marriage certificate?
No, you remarried when? After getting notice of the appeal?
No, my lord. I have
After
received
waiting for the appeal period?
Yes, my lord. I have married on 5th January 2025. After
5th January?
Yes, my lord. After expiry of the appeal period.
Yes, what can be done now?
Yes,
We'll
my
expedite the hearing of the appeal.
And I have received received the notice of stay application on 21st of August 2025.
After my lord tendering this appeal, the Tolovana.
7 months after he received the notice.
No, the Tolovana and the notice of appeal that was already filed with
yes,
the
but
department.
it's not your fault, but neither his fault.
Yes, section 15 is in my favor.
What is in your favor? Section 15 says what?
Kindly say section 15.
Read section 15. There is no penalty, no sanction for section 15.
Yes, now section 15 says divorced persons when may marry again. When a marriage has been dissolved by a decree of divorce and either there is no right to appeal against the decree, I had the right to appeal to decree. If there is such a right of appeal, the time for appeal has expired. In my case,
He has done that.
No, it was not. Within time, my lord, I have filed appeal.
When was the decree passed?
Decree passed on 18th July 2024.
18th July 24.
And immediately thereafter, my memo of appeal, because there is no section.
Your memo of appeal is not the concern. The certified copy, time taken for certified copy, that's a concern for whether your appeal is in time.
Yes,
but the statute, section 15 says the time for expiry of the limitation period, the appeal period,
yes,
that is counted from the date of the decree. And he has to wait for only that number of days, the limitation period. He has waited, then married. In any event, he is not barred by that provision. And even if he was barred by that provision, this second marriage is not a nullity, not a ground of nullity in any of the provisions, either this statute or the Special Marriage Act. So therefore, now we cannot grant stay.
So
you can expedite the hearing of the appeal.
Yes, yes.
We direct you to be, he is appearing, no postal cost.
Yes.
Prepare paper books and records will come. We'll keep something on record. Give that.
Marriage certificate.
Give a copy to him also.
Yes.
The present challenge arises out of a divorce decree obtained by the respondent husband. Push up, the appellant wife contends that the learned trial judge failed to apply his judicial mind to the facts of the case and merely proceeded to grant a decree of divorce on the ground of cruelty and desertion without adverting to the material evidence, primarily on the premise that the appellant wife did not adduce evidence. For the next para, it is also submitted that the suit was not maintainable on the ground of desertion, which was also accepted by the learned trial judge, since it was filed within the statutory period of 2 years from the incident of desertion as alleged. For the next para, however, at this juncture, learned counsel for the respondent hands over a photocopy of a certificate of marriage indicating that the respondent husband has remarried after waiting for the appeal period from the divorce decree. Full stop. Next para, as such, it is contended that there is no scope of grant of stay of operation of the impugned decree. Full stop. Learned counsel for the appellant places reliance on section 15 of the Hindu Marriage Act and submits that since The appeal was filed within time, comma, taking into consideration the period taken for issuance of certified copy, comma, it should be construed that the second marriage was contracted by the respondent husband within the appeal period. Full stop. Next para. However, comma, such contention of the appellant is not acceptable for two reasons. Full stop. First, comma, the consideration in section 15 is that the statutory period of appeal has to be awaited by the spouse obtaining the divorce decree for contracting a second marriage. Full stop. For such calculation, comma, the date of the impugned judgment and decree of divorce is what is relevant, and not the time available by application of the provisions of the Limitation Act to the appellant for preferring the appeal. Full stop. Next para. Going by such by such calculation, comma, the respondent husband indeed waited for the appeal period, comma, since the impugned decree was passed on July 18, 2024, and the remarriage was contracted on January 5, 2025. Full stop. Secondly, comma, even if section 15 was contravened, comma, there is no sanction in law to declare the second marriage a nullity. Full stop. As such, comma, in any event, comma, there is no scope for passing any order of stay.
My lord,
of the
order of stay has already been passed on 13th of August.
It is complete. Any order of stay of the impugned decree. Full stop. Next para. It may be noted here that when the ad interim order of stay was passed, comma, the fact of the second marriage of the husband was not before the court, comma, since at that juncture no notice had been given to the respondent husband. Full stop. Next para. However, comma, keeping into consideration the above circumstances, comma, we are of the opinion that the application for stay cannot be allowed. Full stop. Accordingly, can 1 of 2025 is dismissed on contest without any order as to costs. Full stop. That's a ad interim consideration. Now we are at the final step. In order to expedite the appeal, comma, the trial court record shall be brought by special messenger, comma, costs of which shall be put in by the appellant within a week from date. Full stop. In view of the appearance of the respondent through his learned advocate, comma, service of notice of the appeal on the respondent is dispensed with. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of the arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for inclusion in the list for hearing as and when the same is ready for hearing. The photocopy of the certificate of marriage filed today be kept on record.
Great.
No rest to cost. Thank you.
And I am for the appellant, my lord. This is the wife's appeal against an ex parte decree of divorce.
Appearing for the first time?
Appearing for the first time. There are two applications. One is a section 5. My lord,
to serve copy and come back. The appellant shall serve copies of Can 1 of 2025 and Can 2 of 2025 on the respondent, indicating that the application shall be listed for hearing on September 15, 2025, when an affidavit of service to that effect shall be filed by the appellant.
Can it be, my lord, taken up, my lord, on the last week before vacation, because the opposite party is in Dubai?
Dubai? 15 na kore thale 22 kore.
This is a classic case, my lord. When it comes up, I will demonstrate your lordship. Both the parties, my lord, are jointly residing together. Baby is born on a one fine morning when the wife came back to wife came back to India. My lord, their in-laws told you are not entitled to get into our house. Divorce decree has been passed ex parte.
No, the husband was with her.
With her, baby was born. In the birth certificate of the baby, husband's name is there. Process server, my lord, under Order 5, Rule 19 was examined. He said that Lotkaya Jarikola. On that day, I have annexed the, my lord, the passport of the wife. Wife is in Dubai. And he says the wife has refused to sign the ID card. Wife was there and he refused to accept the summons.
Only the second wife.
My lord, completely from different community. 2% came up from different community, my lord.
Maybe. Yes. Next. 9, who is a... Yes, Mr. Paul. Section 5.
Section 5 is there,
But the
there
first
is a-
time, then you have to serve and come back.
there's a mistake is there in section 5. I have stated that is a 55 days delay, but after
Yes.
checking, I find it is a delay about 22 or 23 days.
Less.
Yes.
You have explained more, no
Calculated
difference.
on 30 days. It should be 60 days.
Oh, you have calculated the period of appeal period also. No difficulty on that. There is no interim application.
No, that's not a file because section 5
To dismissed.
took
You-
dismissed.
Your divorce should dismissed. There is no scope of interim order. So section 5, let us.
There is scope of interim order that will come up thereafter.
There is scope.
I have not filed it, but I will file it.
Ask for it. You are the wife.
I am the husband.
What interim order?
Husband has interim order and in the petition in the marriage matrimonial suit. I have shown that how they have coming regularly and threatening us. That is
So they will, when you file that injunction application, the appellant shall serve a copy of the application of Can 1 of 2025 on the respondent, indicating that the application shall be listed in listed on September 15, 2025, when an affidavit of service to that effect shall be filed by the appellant. 15.
এটা আগে section 5 ভালো হবে।
সার্ভিসটা দেখি আগে।
Yes, it is doubtful.
Doubtful service.
You have settled the affidavit of service. Good service effect. You are for only one respondent. You are for the state. State, private respondent.
Both are appearing, তাই তো?
You have managed them.
Unable to, up till now unable.
No, not you. I mean, your client.
No, I have informed over telephone.
So you have managed them. Yes, sir.
Already
No,
happened.
no.
আরে বাবা, ইয়ার কি বোঝ?
Yeah, what is the matter?
Well, kindly come to page 34. When I was going to place that, my lord, this
Oh, that. You're
35,
35 years.
clause 2.
Yes.
In terms of the existing government policy, freehold right and title may be executed only in favor of displaced person from Israel, Pakistan, who is in effective possession. But I was in effective possession of a particular land. I applied for registering on the basis of this document. I moved your lordship's call. Your lordship dedicated the matter to the authority. Authority passed an order saying that my landed friend is the private respondent who is not in possession of the property. In his favor, a deed of allotment has been executed. So you are debarred.
That deed has to be challenged then.
But deed I cannot challenge in suit proceeding because deed.
Why not?
Why I am saying, my lord? Deed is correct. This is the view of the honorable single judge. Deed is correct, but the first allotment will be there on the basis of this document. If the allotment goes, deed will automatically go.
So you're trying to hit at the root, the allotment. You have challenged the allotment now.
Problem is there is a problem in the prayer. Cancellation of deed also prayed for. But Kali, that
So
can
that
be modified.
Yes, that can be modified. The learned trial judge refused it.
You relegated. You have challenged the deed, so you go to the suit court and before that, my lord, let us show to your lordship, my lord, how the possession is there. My lord, appellant's possession, my lord, will get at page 17. Kindly come 17. Gautam Kaur, 11H, NN Ghosh. Then my lord, kindly turn over the Taligarh Assembly constituencies voter list that is there.
Yes.
Then kindly turn over page 20. Kindly come to third column, left hand side. Gautam Kaur, Pitanda Manoranjan, body number 11H.
So prima facie there is evidence.
Prima facie, I can able to show that I am in possession of this property. But the private respondent's possession is, my lord, kindly come to 21. I have also shown this, my lord. Kindly come to page 21, item number, premises number 132, 67. Somewhere else.
What is the name of the private respondent?
Milan Datta, Sumita
So
Datta.
their names are recorded.
Yes, my lord, the name is.
132 is the premises.
That is separate premises.
No. What is this premise?
11H.
11H.
H.
That is where I am in position.
A deed is in respect and the allotment is in respect of
11 each, part of the 11 each. So today my lord will be rising.
his lordship has a different bench with Justice Shen.
My lord is also sitting singly, I have been told.
I'll be coming back singly.
Let us come tomorrow.
Yes. Affidavit of service filed today be kept on record. Full stop.
Your lordship can fix it for hearing, not allowed to somebody else. No interim order I can pray today.
No, we'll take up the appeal along with the application.
That will be
What
better.
is there in the appeal?
This is the all. These are all.
We'll take up the appeal tomorrow along with the application. Because the question involved is the same. Affidavit of service filed today be kept on record. Full stop. In view of the in view of the short conspectus of the appeal, comma, the appeal along with the application shall be taken up for hearing tomorrow when the matter shall be listed under the same heading. Same heading দিয়ে দেবেন কাল। Thanks. Matter stand adjourned for the day. একটা line add করে দাও. The matter appeared on being mentioned by the petitioner. However, comma, at the time of call, none appears for the parties. Let the matter stand adjourned for the day. Next.
No, this
What
has
correction?
come up at my instance. Will
Yes.
kindly takes page 2, paragraph number 2.
Page 2, para 2?
Yes.
Yes.
Lord takes the second sentence.
Yes.
Was passed by CA on, this will be Milord 3rd of August 2022.
Oh, that is the only change.
No. The second one is Milord at page 3, paragraph 6, fourth line from the bottom. It should be Milord completion instead of compliance. And Milord, just the sentence before, completion certificate by the municipality, not Milord the C. These Milord the articles.
That will be August
3rd August 2020.
2022. In the judgment dated August 22, 2025, comma, certain errors had crept in. Full stop in paragraph number 2, comma, the second line, comma, the date erroneously transcribed as March 9, 2023 shall be read as August 3, 2022. Full stop, next para. In paragraph number 6, comma, at the third page, comma, in the
8th sentence,
fourth line from the bottom, comma, instead of double inverted মধ্যে CC capital, completion certificate by the CA, double inverted close, comma, it should read as completion certificate by the municipality.
or Milord the municipal corporation.
Completion certificate by the municipal corporation, double inverted close, full stop. Also, comma, in the same line, comma, the expression double inverted compliance, C capital, double inverted close, shall be read as completion, double inverted close. Full stop. Let the judgment dated August 22, 2025 be deemed to stand corrected accordingly.
Obliged.
Next.
My lord, I am appearing on behalf of CBI led by Mr. Chakraborty, the learned ASG, my lord.
Yes.
The matter has come up. My lord, it is taken by your lordship normally on Friday. So if your lordship kindly fix any date, my lord, convenient to your lordship.
So then Friday week, next Friday is a holiday.
Next Friday is holiday.
Friday week. We also have our counsel Milord from
Obviously, it will be difficult for you. Suddenly it was notified. Because Justice Kumar had a bench, I had to put this
Your
one.
lordship, my lord, once the matter may be decided this side of the vacation, my lord.
It is outside after the
My lord, I
vacation
have no
also,
difficulty, whichever date.
Whatever you choose, both of you.
If post vacation, then Milord the interim order has to be
Full
extended.
party autonomy on that.
Yes.
Then Milord
My lord,
keep it
after vacation?
After the vacation.
We'll request for after vacation.
Very well.
Because when this side of the vacation, we don't want to trouble your lordship, to be very honest.
No, I want to be troubled. No,
We'll do that after vacation.
no matter. Either is a trouble or a.
No, actually, my lord, even if we start, my lord, it will be little difficult for us to finish. It will take some time. my lord.
On the prayer of the parties, the matter be adjourned and shall next be listed under the same heading on Friday.
Will it be possible on 14th, Milord?
14th. Very good.
November.
This Friday, that's a Friday. my
On
lord.
November 14, 2025. At the top of the list.
Obliged.
Grateful.
My lord, the interim order to continue.
Interim order granted earlier shall continue till December 15, 2025 or until further order, whichever is earlier.
Most of it. My lord has passed a common order, my lord.
4, 5, 6.
But I think earlier also there was a common order.
Passed.
All are tagged, my lord.
Plural. Yes.
Already tagged.
Yes. In all the matters. Yes.
Appearance. Grateful. Item number 7.
I am for the petitioner, lordship. Lordship, in this matter, there was opposition was filed by the CSC. On the last occasion, I took time to file the reply, Lordship. But on this occasion, Lordship, I could not file. Petitioner is seriously ill. Lordship, what I am praying, Lordship, in the writ petition, there was a direction. Lordship, kindly sees the order in the writ petition once. The
Page
matter
11.
can be disposed of, Lordship.
It is at page 11 of the contempt application.
Yes. In view of the Lordship, the
In view of the
submissions made by the learned counsel for the parties is disposed of by granting liberty to apply for a separate new metered electricity connection in the petitioner's name at premises number 68 Thakurpukur Road, Kolkata.
What is the contempt?
Lordship, petitioner applied, security bill deposited, connection has not been given. What I am praying, Lordship, kindly disposes of this contempt application by observing that the connection only be given to 68 Thakurpukur.
Can this be done, Manoj? Kindly see.
Order is that, Lordship.
For that, he has to file a fresh writ petition. This is a contempt application. Manoj.
If so applied for, CAC shall hold an inspection to scrutinize.
and
You have held an inspection.
Kindly come to
They
my
have
opposition.
given the security bill, Lordship. I have paid.
Manoj, kindly come to my opposition, page 3 onwards, my lord. Subpara A, B, C, my lord. We have tried to hold inspection, my lord. We have been obstructed. We have given 3 to 4 letters stating that we could not, and there is no direction for police help, my lord, in the order impugned. If they want, they have to file a fresh writ petition.
No, only 68 we cannot do. They have filed an application, they have tried to hold inspection, there is no contempt.
Thereafter, kindly see the page 15 of the contempt application.
But I have given everything in the opposition.
They have, after inspection, they have given the security bill. We have deposited, complied with all the formalities. Lordship, kindly see page 15.
Kindly see.
Then you have to give the connection.
Kindly see.
They have taken the money.
No, Mr. Mukherjee, you went there for the purpose of giving the connection now.
We went there, kindly see paragraph B at page.
So tell us what is there. For inspection or for giving connection?
Well, they have made necessary plans subsequent to compliance of all formalities duty deployment for installation of the meter.
So you want to install the meter?
Yes.
So we'll read into this order that that you may seek police help.
Lordship, but connection be given only 68 Thakur.
Only will not add because that is will be modifying my order.
Yes.
You are entitled to apply for 68.
Yes, I have applied. Lordship, kindly see page 15 of the contempt.
So they'll give the connection in terms of your application.
68 Thakurpukur Road, Kolkata.
They'll give the connection in terms of your application. That will suffice.
They have already given the security bill. I have paid, complied with all the.
So why only? You are apprehending something.
Yes.
Yes, this is there is a dispute in respect of the address. Kindly, my lord, will peruse.
No, the direction was if their application
was for 68, my lord.
So give it at 68.
Yes.
So in respect of the application they have made, we'll give.
Yes. 68, they will give the connection.
Learned counsel for the petitioner submits that due to the illness of the petitioner, the affidavit in reply could not be prepared. However, learned counsel for the petitioner contends further that the contempt application may be disposed of by directing the electricity connection to be given to the petitioner at premises number 68, Thakurpukur Road, Kolkata 7,63,000. Next para, learned counsel appearing for the respondent alleged contemner submits, by placing reliance on the affidavit in opposition filed by the alleged contemner, that despite repeated attempts, the connection could not be given due to resistance. Next para, learned counsel for the petitioner also relies on a communication dated September 7, 2022, annexed at page 16 of the contempt application, wherefrom it transpires that the electricity that upon the petitioner making an application, the the CSC Limited raised a bill, the amount of which was deposited by the petitioner.
Yes.
Next para, learned counsel for the alleged contemner raises a question and raises an impediment to the effect that due to the parent order not containing specifically any direction for police help, the resistance offered by third parties at the site could not be overcome. Next para, however, there cannot be any impediment in that regard, since it is the bounden duty of the police authorities to ensure that an order of this court is complied with. Hence, the liberty of the CSC Limited to approach the local police station for adequate police assistance at the cost of the petitioner in the event any obstruction is faced in giving such connection in terms of the application by the petitioner, should be automatically read into the parent order dated June 21, 2022, passed in WPA 10773 of 2022. Full stop. Next para. However, comma, from the circumstances of the case, comma, this court does not find any contumacious violation of the order of this court on the part of the CSC Limited. Full stop. Next para. Accordingly, CPAN 990 of 2022 is dismissed with the observation that that it will be open to the CSC Limited personnel to approach the concerned police station, the local police station, for adequate police assistance for the purpose of implementation of the order of this court dated June 21, 2022, by giving connection to the petitioner in terms of the petitioner's application at the concerned premises. Full stop. If so approached, comma, the local police station shall grant police assistance in that regard at the cost of the petition.
Only
No arrest to
two things, Madam. With a direction to break open padlock, if any.
If necessary, comma, the police personnel will be at liberty to break open any padlock or other hindrance to get access to the place where the connection is to be given.
And one more thing, Madam, instead of CSC Limited, it will be the contemners because the official has been made a part by name.
No, we have said CSC Limited. Contemner himself cannot do it. CSC Limited, because we have to read it into the order. Parent order does not direct the alleged contemner. It directs the CSC Limited.
As you lordship, please. I'm grateful, Madam.
Thank you. Yes, Mr. Bandhavade, what is your case?
Your Lordship, kindly see the order, Madam, page 16, contempt application, to consider the representation dated 14 November 2022.
Consider, not considered.
But they have not considered based past order without mentioning that they.
Yes, Mr. Rai, why are you not considering?
Not my
We have considered, and this is the order in my affidavit in opposition. I have annexed that order, page 6.
Page 6.
Affidavit in compliance.
Yes, affidavit in compliance. Page 6.
What was the representation regarding?
Representation, he is enlisted contractor. He has asked for work, but he has not given work because he has himself engaged in a theft. Therefore, my lord, in this order,
Himself engaged in a theft.
It was already posed, my lord.
And
I have submitted.
That's a different cause of action, Mr. Bandhavade. The direction was to consider representation. They have considered.
But not mentioned, my lord. You new facts, my lord. They have.
That's why it's a new cause of action. You
not consider.
If you are agreed with their refusal to concede to your prayer, then you take out a new petition.
No,
Contempt. The direction was to consider your representation. They have considered, given you a reply, so no contempt lies. We'll give you liberty to file a case. The present contempt, the affidavit in reply filed today be kept. The reply to the affidavit in compliance filed by the petitioner today be kept on record. Full stop. Learned counsel for the petitioner argues that the alleged contemner has flouted the direction of this court to consider the representation of the petitioner to be given work as a listed contractor of the WBSC-DCL. For the next para, learned counsel for the WBSC-DCL alleged contemner. Learned counsel for the alleged contemner places reliance on annexure R1 at page 6 of the affidavit in opposition filed by the alleged contemner and contends that the representation of the petitioner has been duly considered and disposed of by giving a reasoned order in writing. Full stop. Next para. It is also alleged that the petitioner himself was guilty of theft for which he was not given any work. Full stop. Next para. Learned counsel for the petitioner disputes the said allegation and submits that the case lodged against the petitioner on the ground of theft has since been closed. Full stop. Next para. Be that as it may, comma, insofar as the contempt application is concerned, comma, since the alleged contemner has duly complied with the order of this court by considering the representation of the petitioner and disposing of the same by speaking order in writing, comma, no contumacious act has occurred. Full stop. Accordingly, CPAN 628 of 2023 is dismissed. Full stop. It is made clear that nothing in this order shall prevent the petitioners from challenging the refusal on the part of the WBSCDCL to award further work to the petitioners on merit on the basis of the subsequent cause of action which has arisen out of the refusal of such prayer of the petitioner, refusal of such request of the petitioner by virtue of the speaking order dated March 21, 2023. No rest course. Thank you. Next.
Grant liberty, madam.
Thank you. Next.
Item number 9.
May I please?
Yes.
And on the last question, my lord, I had submitted this is a change brief, my lord. I have
no Vokalatnam had been filed.
Now it has been filed, my lord.
Filed. There is no revised report.
There is no report, my lord.
This is appearing for the first time.
My lord, it had appeared, but it was not heard because the other side also.
Did you direct you to serve copy?
No, my lord.
Acha. Learned counsel for the petitioner submits that in the interregnum, Vokalatnama has been filed by the current learned advocate for the petitioner. Full stop, next para. Accordingly, the office shall furnish a revised report in that regard. What is the act of contempt?
My lord, I was seeking remission, my lord. It is.
What was the direction of the court? Yes.
Below 60 years, my lord. It was actually sent for consideration, but
we directed them to consider it.
Yes, but
nothing. A prima facie case, next para, a prima facie case of contempt has been made out inasmuch as it is alleged that the alleged contemners have not complied with the direction of this court dated October 5, 2023, passed in WPA 20532 of 2023, to the effect that the representation of the petitioner number 1 for remission of the
petition number 1, my lord.
Remission of the petitioner number 1, early remission of the petitioner number 1 was to be considered, taking into consideration the extant law and governing circulars stroke notifications, as well as the established principles of law as laid down in several judgments of this court and the Honorable Supreme Court. Full stop. Hence, the petitioners shall serve copies of the contempt application on the alleged contemners, indicating that the application shall be listed for hearing next on September 19, 2025, when an affidavit of service to that effect shall be filed by the petitioner.
Deeply office.
Thank you. It office is office about revised report. You please cooperate with the office. Give your meet whoever is there in the office and just give your filing number of the vakalat.
I beg to appear on behalf of the petitioner. My lord, they are the legal heir of an ambulance driver. And my lord, Honorable Court was kind enough to direct, my lord, the Hill Department, my lord, by applying the presumption theory and burden of proof theory, direct the appropriate authority, my lord, to release the terminal benefit. They have challenged it, and finally, my lord, this was adjudicated by the Honorable Division Bench and affirmed the order passed by this Honorable Court. Now, my lord, in the name of compliance, my lord, what they are doing, my lord, they are passing new order, they are bypassing the spirit of the order, trying to frustrate it. My lord, how, my lord? Our objection is this, my lord. Lordship, kindly see. First, my lord, kindly examine their compliance report. Lordship, kindly come.
I had directed them, this court had directed them to consider as to whether either of the petitioners is entitled to family pension on demise of late Shochipati.
Yes.
And upon deciding such issue, communication in that regard to be made to you.
That is paragraph 30. Before that, my lord, I am showing, my lord. Kindly
it will be open to you if you agree by the decision to prefer a fresh challenge.
No, my lord, the direction was not complied. Lordship directed them to, my lord, release the entire pensionary benefit, but they are not. Lordship, kindly come to, my lord. Paragraph
first, your lordship,
of the order of this Honorable Court, para 21, 19 may kindly be looked into. Of the order.
Para
19.
Yes.
Kindly see, my lord, I am reading. There are two indicators in the material on record which favor the petitioner claim that Shochipati's service had continued and he had died in harness. The first is the communication by the Director of Department of Health so-and-so, Bardhaman, which indicated that Didi Shochipati, an ambulance driver, Katwa SD Hospital, had indeed died in harness. And, my lord, secondly, in a reply of a member secretary of the West Bengal Women Commission of the Joint Director of Health Service, West Bengal wrote a letter dated so-and-so that compassionate Appointment prayer of the petitioner was rejected in view of the delay in filing the same. In the, my lord, next, turn to my lord, the next page, my lord. And then, my lord, kindly see, in so far as burden of proof is concerned, my lord, it is upon the employer. Lordship was kind enough. Then kindly come to paragraph 28. In the context of the above discussion, it was for the respondent authority to produce the record either to show that Shochipati's service was continuing or that the same was terminated prior to his natural tenure. Having failed to do so, adverse inference has to be drawn against the respondent authority. Accordingly, it is presumed that if the records are produced, the same would operate to the detriment of the employer interest. Then, my lord, 29. Hence, in the absence of any material to show Shochipati was ever suspended, retrenched, dismissed, retired from the service before his death, the petitioner is definitely entitled to the entire pensionary benefit and retirement benefit due to his demise of their father, late Shochipati Ghatok, an ex-employee of the ambulance driver. So next paragraph, my lord, also, once again, this honorable court reiterated, accordingly, WPA number is allowed on contest, directing the respondent number 7 of Special Officer, Government of West Bengal, to disburse the entire retirement and pensionary benefit of the Shochipati Ghatok, an ex-employee of the Katwa Subdivisional Hospital, Paschim Bardhaman, so. Only question, my lord, since one of the petitioner is a widow daughter, last paragraph, lordship was kind enough to direct them whether she is entitled or not, that to be decided by hearing. Now, my lord, they have heard is once again in our absence. Lordship, kindly see, my lord, their compliance report for a while.
My lord, let me file the compliance first. It has not been taken on record. Because in the earlier occasion.
File it.
Yes.
What's the difficulty?
Lordship, kindly come to, my lord, page 5 of their compliance report. Very interesting remark against the judgment of the, my lord, division bench. My lord, paragraph 5. Page 5, para 5.
Yes.
During the course of appeal hearing, the learned state advocate brought to the attention of the honorable division bench that the petitioner had failed to produce valid service record of late Shochipati Ghatok, including documents such as appointment letter, date of joining, pay scale, last paid run, and date of cessation of service. Notwithstanding such non-submission, the honorable division bench dismissed the appeal. This is one aspect. Then, my lord, kindly come to the bottom, 6 Roman A, my lord, 6A. As a special case, the unauthorized absence of late Shochipati Ghatok, an ex-ambulance driver, so and so, my lord, till his demise shall be regularized in the following manner. Lordship is of the opinion, my lord, he was in service, died in harness. That is why compassionate appointment issue was taken into consideration.
It was a plain dismissal by the appellate authority, or certain modifications were made?
No modification, nothing of this sort. Upheld the judgment passed by this honorable court. Then, my lord, kindly see, the period from Roman 1 shall be treated as an early 134 days with the relaxation of the relevant provisions, so and so. Then, my lord, the remaining period shall be treated as dies non. Lordship was of the opinion, entire, my lord, the benefit to be given. Then they are considering my 4-year service. At the same time, the same authority consider my compassionate appointment of my son. That being the situation.
What is the logic of this, the rest of the period being dies non?
My lord, because, my lord, that unauthorized leave, they are sticking on the same point. Lordship was kind enough to come to a conclusion, since they failed to produce any document, presumption will be that he was in service. And since they considered my compassionate appointment issue, it is to be considered he was in service, died in harness. That was the observation made by this honorable court. Kindly turn to, my lord, page 6, second paragraph. The matter regarding regularization of the unauthorized absence, once again, my lord, and the entitlement to retirement benefits, so and so. Then, my lord, I am drawing lordship attention, page 7 at the bottom.
Yes.
My lord, after just basic pay, my lord, thereafter, my lord, lordship will find died on so and so date, net qualifying period of service 4 years, 10 months, 3 days. Is a qualifying service. If that be so, how, my lord, they considered my compassionate appointment issue? And honorable court was kind enough to, my lord, to observe entire pensionary benefit to be given. Then, my lord, kindly see last paragraph. As per available attached court paper, it has come to the notice of late Bhakti Rani Ghatok, late so and so, was entitled to get death cum pensionary benefit of a family pension with effect from so and so without any death gratuity. Whether, my lord, gratuity is not inclusive of, my lord, the entire pensionary benefit as directed by this honorable court as per DCRB. They are trying to champion their DCRB. As qualifying service period is less than 5 years, enhanced pension cannot be sanctioned as the incumbent has not fulfilled 7-year continuous service. Bhakti Rani Ghatok was entitled to get family pension till her death, so and so, so and so. But our humble submission, my lord, it was adjudicated upon by this honorable court. Direction was issued, very specific direction. Lordship at least used 3 times entire pensionary benefit. And my lord, they are trying to interpret it. And my lord, they are accusing the division bench in spite of our submission made before the division bench. No papers are there. Yet division bench was of the opinion the judgment passed by the honorable writ court is, my lord, correctly passed, upheld. That being the situation, my lord, there was no scope for taking further hearing. Only hearing is required to be taken. Last paragraph of, my lord, the impugned judgment. Lordship, kindly see here, lordship, paragraph 32, my lord, of the honorable court's judgment. The respondent authority are also directed to consider as to whether the either of the petitioner is entitled to family pension. That issue to be adjudicated.
That's it.
Yes, my lord. So far, that other direction, entire pensionary benefits.
Why shouldn't you issue a rule?
My lord,
What the alleged contemners?
my lord, the
Big
director,
officials.
director health service.
My lord,
Let them come and explain.
Yes,
only one thing, my lord.
They are interpreting their appellate authorities over the division bench of this court.
Yes.
My lord, kindly
Since when?
for once, twofold of direction, my lord, has passed. With one is with regard to the, my lord,
We'll unfold the folds.
No, my lord,
We
kindly.
know how to unfold the folds.
My lord, only one prayer, my lord.
Yes, you are a nobody to sit in judgment over the division bench judgment.
No, my lord.
This order was confirmed by the division bench. Order is specific. There is no, you are educated people, otherwise you should leave your service.
My lord,
We'll attach your pension and the entire amount will be
only
paid.
one.
No, your pension will be, your salary will be attached.
My lord, for
Let us do that and let your person come and
my lord, only one thing, my lord.
big officials, big shots.
My lord, only one thing, my lord. I'm making what submission I'm making, my lord. Regarding, my lord,
What sort of an adjudication is this? Only scope was to just to consider whether they are entitled. They have said they are entitled.
My lord,
And what sort of an observation is this? Notwithstanding such non-submission,
Yes.
honorable court, who are you to say that?
No, my lord, page 7, there are, my lord, the latest.
And why dies none for this period? Entire period was to be given. You produced to show anything before the writ court. That's why the direction was passed. Nothing was produced. Till date, nothing has been produced.
My lord,
We drew adverse inference and directed you to pay the entire ex-ambulance employee. And in your order, we have also seen that we have recorded the ground of delay cannot be relevant since a similar
My lord,
stand has been taken by the employer from 1983 when the poor wife of the deceased employee,
Yes.
they are running from pillar to post since 1983.
my lord, my
You
lord,
just sit with a begging bowl on the streets.
only one thing, my lord.
And your official is enjoying a red carpet and sitting in good chairs.
My lord, only
No.
one thing, my lord. Kindly,
No.
for once,
Nothing.
kindly consider one submission, my lord. My lord, my lord, judgment is very clear on the issue. My lord, I have seen, my lord, I have sent the exception also. This is the point that.
Suppose this is not for you, for your client.
Yes, my lord, what I am, my lord, on. I have specifically, my lord, I have sent the exception where they have taken the point that this cannot be. Because my lord's order is.
You are advising them, but they don't heed that advice.
My lord,
unless they are brought to court,
my lord,
asked to apologize before the court,
my lord,
or sent to jail.
my lord, only one thing, my lord, when we have filed this.
Let them go without salary for 2-3 months, Mr. Prasad. They'll understand the plight of this lady who is running from pillar to post since 1983.
My lord,
1983.
I cannot, my lord.
In which class we are studying in, Mr. Prasad? And this lady is running from pillar to post since 1983.
My lord, I
in which class I was studying in fact?
My lord, I was not there. I was not there. My date of birth is 1985.
You are minus 2 years old then.
Yes, my lord.
So this lady is running from then.
My lord, only one prayer I am making.
There's a limit to everything.
Only one prayer I am making, my lord. When this compliance was circulated,
Who is this person?
They have given the exception.
Yes.
My lord, we have given the exception. We have sent the exception to the alleged contemptor. My lord, give us some more time so.
No, why more time?
My lord,
till then it will be paid from your salary.
My lord, only one.
Till then it will be paid
one
from your salary.
opportunity
From
to
this month onward, your salary will be attached.
1 month.
They'll be paid
My lord,
till it is over.
My lord,
You don't have to pay.
My lord,
You will be disbursed by your authority from this their
My lord,
dues.
My lord, 7 days time to be given. My lord, we are coming with the face.
Pay it within a week. We'll keep it next week.
My lord,
We'll give you 2 weeks because we don't have next Friday.
My lord, yes.
That is
Kindly
the,
give
not even that. We'll keep it next week actually. Wednesday, we'll keep it Friday week.
Yes, my lord. And kindly, my lord, what has fallen from your lordship, kindly, my lord, give that observation so that we can.
Yes, we'll give.
Once again, clarification needed, my lord.
Right.
No.
The affidavit, the purported affidavit of compliance filed by the alleged contemptors and the exception thereto are kept on record. Full stop. Next para. This case is a burning example of utter callousness and apathy on the part of the administration, comma, to be particular, comma, the present alleged contemners, comma, who are respectively naam diye din order. Dr. Ajay Kumar Chakraborty, comma,
They have demitted the office. Now the new
Siddhartha
one,
Niyogi.
Yes,
my lord, one is
Sapon Soren, my lord. We have, my lord, made the necessary
Krishna
correction.
Pramani Gupta,
Swapun Soren is the present person.
by present person, Director of Health Service.
Particularly Dr. Swapun, SWAPAN, Soren,
SAREN.
SAREN,
Lordship.
comma, Director of Health Services, comma, Department of Health, comma, Government of West Bengal. Full stop. Next para. By an order dated, by a judgment dated August 21, 2023, passed in WPA 21887 of 2022, comma, passed by the present petitioners, comma, the unfortunate heirs of late Shochipati, comma, who was an ambulance driver engaged with the respondents in the writ petition, comma, it was observed that the poor wife of the deceased employee had been started a family had started a family marathon from pillar to post from the year 1983, comma, seeking first, comma, compassionate appointment and then the death benefits of the said employee. Full stop. Next para. It was held by this court in the said judgment categorically that it was for the respondent authorities to produce the records either to show that Shochipati apostrophe S within bracket the ex-employee bracket closed service was continuing or that the same was terminated prior to its natural tenure. Full stop. Having failed to do so, comma, adverse inference was drawn against the respondent authorities, comma, since it was presumed that if the records were produced, comma, the same would operate to the detriment of the employer apostrophe's interest. Full stop. Next para. It was further observed that in the absence of any material to show that late Shochipati was ever suspended, comma, retrenched, comma, dismissed or retired from service before his death, comma, the petitioners are definitely entitled to the entire italics se diye deben, pensionary stroke retirement benefits due on the demise of their father, comma, late Shochipati Ghatok, comma, the ex-employee and ambulance driver with the Katwa SD Hospital, comma, Bardwan, on his demise on December 28, 1981. Full stop. Para. Accordingly, comma, the writ petition was allowed on contest, comma, directing the respondent number 7, comma, special officer within bracket pension bracket close, Government of West Bengal to disburse the entire retiral stroke pensionary benefits of late Shochipati Ghatok, comma, an ex-employee of Katwa Subdivisional Hospital, comma, Paschim Bardhaman, comma, calculating such pensionary benefits, যেখানে entire আছে italics করে দেবেন, calculating such pensionary benefits by applying the appropriate scales for the our entire period till the demise of late Shochipati on December 28, 1981. Full stop. Such disbursal was directed to be effected within 2 months from the date of communication of the order to the respondent number 7. Full stop. Next para. Apart from other observations, comma, it was also mentioned in the said order that the respondent authorities shall consider as to whether either of the petitioners is entitled to family pension on the demise of late Shochipati on December 28, 1981. Full stop. Upon deciding such issue, comma, a communication in that regard was to be made to the petitioners by the respondent authorities within a month from the date of the judgment. Full stop. Next para. By an order dated August 1, 2025, comma, although it has been held by the concerned authority by an order dated August 5, 2025, comma, although it was held by the concerned authority that the petitioners are entitled to get death compensatory benefit, that is family pension, with effect from December 29, 1981, comma, for some unknown reason, comma, the death gratuity due to the petitioners as per DCRB-1971 rule number 98 was deducted. Full stop. Next para. By a previous order dated August 1, 2025, comma, the Senior Special Secretary to the H&FW Department, comma, Government of West Bengal had the audacity to observe that during the course of the hearing of the appeal preferred against the order of this court, comma, the learned state advocates had brought to the attention of the division bench that the writ petitioners had failed to produce certain documents, and that notwithstanding such non-submission, notwithstanding such non-submission, comma, the honorable division bench dismissed the appeal. Full stop. Next para. Thus, comma, there is an insinuation in the order dated August 1, 2025 that the Senior Special Secretary was appraising the order of the division bench, comma, akin to an appellate authority. Full stop. Not stopping there, comma, it was mentioned in the order that as a special case, comma, the unauthorized absence of late Shochipati Ghatak, comma, ex-ambulance driver from 19.05.1965 till his demise on 28.12.1981 shall be regularized in the following manner. Full stop. Next para. In the subsequent subparagraph number II bracketer moddhe, comma, the remaining period apart from the period between May 19, 1965 and September 29, 1965, comma, that is from September 30, 1965 to December 28, 1981, was treated as double inverted moddhe, single inverted moddhe, dies, DIES hyphen non, single inverted close, for all purposes without forfeiture of his past service. Full stop. Next para. First, comma, the observation that the benefits were given to the heirs of late Shochipati Ghatak as a special case by regularizing his absence was contrary to the spirit of the order of this court, comma, since this court had directed categorically for the this court had drawn an adverse inference for non-production of necessary documents by the respondent authorities to the effect that the ex-employee, comma, since deceased, comma, was entitled to his entire pensionary benefits. Secondly, comma, the treatment of the period between September 30, 1965 and December 28, 1981 as dies non was palpably contrary to the direction of this court, comma, by which the respondent's authorities were to disburse within 2 months from the communication of the order the entire pensionary benefits due to the to the heirs of the employee, that is the writ petitioners, comma, by considering his entire tenure of service. Full stop. Next para. In paragraph number 30 of the judgment of this court, comma, the respond number 7 in the writ petition, that is the special officer bracket pension bracket closed Government of West Bengal, was directed to disburse the entire retirement stroke pensionary benefits of late Shochipati Ghatak, comma, calculating such pensionary benefits by applying the appropriate scales for the entire period till the demise of late Shochipati on December 28, 1981. Full stop. Next para. Thus, comma, there was no scope in the teeth of the said order, comma, which was affirmed in an unqualified manner by the division bench in appeal, comma, for the alleged contemner to withhold the benefits to the ex-employee, comma, by treating the period of service between September 30, 1965 to December 28, 1981 as dice non. Full stop, next para. Hence, comma, upon perusal of the purported affidavit of compliance and the exception thereto, comma, this court is convinced that the alleged contemner is palpably guilty of contempt. Full stop, next para. However, comma, at the juncture when this court was about to issue a rule calling upon the alleged contemner to show cause as to why he should not be punished for contempt of court, comma, learned counsel for the alleged contemner submits that the alleged contemner shall purge the contempt by paying the entire dues of the petitioners in terms of the order of this court, comma, by calculating the pensionary benefits on the basis of the entire period of service of late Shochipati till his demise on December 28, 1981, comma, without treating the period between September 30, 1965 and December 28, 1981 as dice non. Full stop, next para. In view of such submission of learned counsel for the alleged contemner, comma, as a last chance to the alleged contemner to purge the contempt, comma, the contempt application is adjourned till September. We are giving you some more time. September 19, 2025. Full stop, next para. The application shall be listed on such returnable date at the top of the list of the contempt applications. Full stop. It is made abundantly clear that in the event the contempt is not purged in the meantime, comma, appropriate rule will be issued against the alleged contemner. The parties and all concerned shall act on the server copy of this order without insisting upon prior production of certified copy for the purpose of compliance.
Deeply obliged.
Thank you. Next.
Okay.
11, yes.
Lordship, I am for the petitioner. May I, before my learned friend?
Yes, Mr. Bose.
We had preferred an appeal.
What is it?
This is the appeal court order disposing of the appeal.
Yes.
Kindly have a look at paragraph 6, paragraph 12.
What was the nature of the order?
The nature of the order was your lordship had struck down a communication holding that to be blacklisting. The appeal court has recorded my submission that we have never blacklisted him. That did not amount to a blacklisting, and he is free to participate, modified your lordship's order and disposed of the appeal. Now, technically, after the modification, the content should not survive. But even beyond that,
what is the allegation of contempt?
Allegation is that even after the striking down by your lordship, I have not allotted any orders to him.
Okay.
Now, I just want to clarify two things. Order copy division bench order. The impugned order is dated February 14th, 16th February 2024. Now, if your lordship kindly takes my compliance affidavit, which was filed on the last occasion.
Compliance affidavit.
I think it is the last document in your lordship's file, the fact. তাই তো affidavit ফাইল করেছি লাস্টের ডকুমেন্ট একদম লাস্ট ডকুমেন্টটা ওই থিকনেস দেখে বলে দিচ্ছি এটাও না মানে found on 6th May 2025.
Was it filed, Mr. Bose, just check up?
Yes. Yes. Contempted order গুলো আছে
তুমি দেখতেই পারো দাও হয় নামিয়ে দেখো না তুমি ওর ডিং মেরে কি করে দেখবি
order received court
না এরকম মোটা একটা জিনিস আছে কিন্তু ওখানে লাস্ট the size of the pleading should not be commensurate with the.
He is responsible for that.
But he looked up to his counsel.
He looks down at me.
He only looks. Where will we look into this? Yes. So what does it say?
Filing number.
So it was affidavit in opposition. Caption is affidavit in opposition. That's why they could not find out. It's there. Opposition is there.
I'm sorry, my lord.
You said affidavit of compliance. That's right. এটা ফেরত দিয়ে দিন আছে আমার এই তো উল্টা ফেরত এটা না Yes, which page, Mr. Bose?
Yes. Kindly come to paragraph 5, page 6, subparagraph B. I'll tell you, Lordship, in nutshell, the fact is this. 16th February, the order was passed.
Right.
His empanelment was up to 31st March 2023. Between 1st April
He was impaneled as what?
as an agent for the facts were I get orders from the hospital. Contractor.
That's very
Subcontractor. He was basically
yes.
a contractor. I say my agent.
Right.
His empanelment was up to 31st March 2023. That communication was struck down on 16th February. For that year, anyways, I could not give him. For the subsequent years, I have disclosed those documents. There were two tenders, 24-25, 25-26 for empanelment of agents. Both times he did not participate. So even if I had not preferred an appeal to against your lordship's order, there was no scope for making any empanel order to him because he had not applied in the tender. And I can't proceed beyond those who have been selected by the tender. Kindly, my lord, I'll just show your lordship the page 209.
So after the division bench order, he is entitled to participate in your tenders.
Yes.
If you prevent him, then he can come up.
Then he can come, not now.
That occasion has not arisen at all. We'll drop the content. If you had to agree, why didn't you agree at the outset?
Actually, I'm not having the documents with me. That's the reason I'm
Oh,
not.
fair enough. Learned counsel appearing for the alleged contemner hands over a copy of a judgment and order dated July 28, 2025, passed in FMA 569 of 2024, which was preferred by the respondent in the writ petition against the parent order, comma, in respect of which contempt has been alleged. Full stop. The division bench, comma, while disposing of the appeal, comma, modified the impugned order and observed that the present petitioner, comma, the respondent number 1 before the appellate court, comma, is free to participate in the tender process of the appellants. Full stop. Next para. Learned counsel for the alleged contemner submits that after the order under contempt, comma, there were 2 tenders floated by the respondents in the writ petition. Full stop. However, comma, the present petitioner did not participate in either of the 2. Full stop. As such, comma, there is no scope of the alleged contemner preventing the petitioner from participating in the tenders floated by the respondent in the writ petition. Full stop. Next para. Upon hearing learned counsel for the parties, comma, this court is convinced that there is substance in the contention of the alleged contemners to the effect that it would be premature to assume that the alleged contemner would prevent the petitioner from participating in its tenders. Full stop. Next para. Accordingly, this court is of the opinion that no case for contempt has been made out, no case of contempt has been made out. Accordingly, CPN 781 of 2024 is dismissed without any orders to cost. No rule was issued. Thank you.
Obliged.
Yes.
Petitioner, my lord.
Answer
responded Mr. Rajesh Singh, my lord. The answer.
Affidavit reply was to be filed by you.
Yes, ma'am.
You have given copy?
Yes, ma'am.
You are for the
Alleged contemner number 1, my lord. The bank. IDBI Bank.
What was the nature of alleged contempt?
My lord passed the order, bank as well as the insurance company
This is that series of matters.
Yes, my lord. Crop insurance.
The response have to be there.
Yes, my lord.
So because this is not the regular day, probably they are not aware. We will keep it the Friday week, on Friday week, the next Friday which is available. Although the petitioner is represented through counsel,
আমি শুধু 12 এ আছি।
common, only the, you are for which bank?
IDBI Bank, my lord.
Only learned counsel for the IDBI bank appears for the alleged contemners. Full stop, next para. In view of the absence of the learned advocates for the other alleged contemners, comma, let the matter stand adjourned till September 12, 2025, when it will be listed under the same heading. Affidavit, this is what? Opposition to recall application?
Yes, my lord.
The affidavit in opposition to the recall application, comma, filed today by the petitioner be kept on record. The petitioner in WPA 13398 of 2021 be kept on record.
Grateful to your lordship.
Thank you. Next. All matters contemners are present, but the
I am for 12 to 20.
oh, this also similar.
Yes, your lordship.
You are for
I'm
Punjab
on
National.
Punjab National Bank, item number 13 to 22.
So same ground except IDBI, it will be PNB.
Yes. আপনি reply file করছেন?
আমি করিনি।
My lord, he has not filed his reply.
I filed opposition for the.
এই আগের অর্ডারটা যেটা হবে না, ঠিক সেম অর্ডারটা এটা রিপিট হবে। সবকটা ম্যাটারে শুধু দুটো চেঞ্জ হবে। আগেরটা IDBI ব্যাংক বলেছি, ওখানে পাঞ্জাব ন্যাশনাল ব্যাংক হবে। আর যেখানে বলেছি ওই অ্যাফিডেভিট অপোজিশন অ্যাফিডেভিট না অপোজিশন টু দ্য ফাইল বি কেপ্ট অন রেকর্ড, ওটা হবে না, উনি কিছু ফাইল করছেন না। আগেরটা তুমি নিলে না তন্ময়, কে নিল? তুমি তো নিলে আগেরটা। আগেরটা দেখো, লাস্ট লাইনটা দেখো, আগের
অপোজিশন দিয়েছি।
অ্যাফিডেভিট একটা বললাম, ফাইল টু বি কেপ্ট অন রেকর্ড।
My lord, I filed the opposition of recalling.
Yes, you are not filing today. এই পুরো সেন্টেন্সটাই বাদ চলে যাবে সেকেন্ডটায় প্রথমটা যা আছে থাকে, পুরো অ্যাফিডেভিট অপোজিশন ফাইলটা আজকে কিছু ফাইল করছেন না উনি, আর ওটা শুধু পিএনবি।
Lordship.
থ্যাংক ইউ।
Grateful, your lordship.
You are appearing?
Short passover, my lord, short.
Short password means it will be called on soon, maybe very well. Password.
5 minutes password.
Password.
Regarding item number 23.
23.
23, my lord.
This matter?
My lord.
Password হচ্ছে ঠিক আছে 23 টাই আবার
My
ঠিক
lord,
আছে।
what happened?
Is your leader or other side?
Other side.
I am for the board of.
Your
I am for the board of.
he asked for a short passover. His senior is coming.
আচ্ছা আচ্ছা।
They've given a short passover. So 24 who is appearing? Board দেখিয়ে দিন, হ্যাঁ 24. This is the second occasion when none appears for the petitioners at the time of call. Who serve as the last chance to the petitioners to move the contempt application. Let the same stand adjourned till September 12, 2025.
Regarding item number 25, Mr. Rita Patro is appearing
Miss
on
Rita
behalf of the contemptor. He is
Not
engaged
Mr.
in court number 33, my lord.
So we'll
As
make it
as
not
per
today?
request of his.
Not today, very well. On the prayer of your name has to be recorded then for the petitioner.
May it pass.
Passover.
Passover, my
Very
lord.
well, Passover.
He will come and do this.
Passover করে দাও।
23 has been passed over. I believe my learned friend is appearing for the contempt.
এটা Passover হলো, 23 টা আবার কল করুন। Oh, I seek adjournment. Yes, 23.
I appear for the petitioner. Madam.
You are for?
There was a direction on the last occasion to serve on the board of work of.
Order has
for the board?
already been complied, my lord.
No, it has not been complied.
Order has already been
You are
complied.
for the board of work of?
My lord, I led by Mr. Salahuddin in this matter.
Yes.
The board of work.
What was the order? Mr. Ali, what was the order?
Lordship, the order was with respect to, there were several directions. Lordship will see page. The second volume, Lordship will take. There was a direction on the board of Waqf to dispose of the applications filed by us.
Page. Applications of what nature, Mr. Ali?
And against the allegations with against the Motwalis.
Oh, you had made allegations against the Matwali that those were to be disposed of.
Those were to be disposed of. They had not been disposed of yet.
That is the allegation.
And that was, Lordship, we had made several letters, but
Yes, why didn't you?
Well, what happened? My file just is engaged in court number.
Your file is engaged in court number.
No, my lord. My lord,
but
Mr.
you are
Salahuddin
here.
is appearing for the 42. I come from
Mr.
the
Mukherjee is for
42.
whom? Another contempt?
Order has annually been complied, my lord.
The contempt, my lord, I have taken out.
Where did you go to? Some seashore?
But I was, my lord.
Why are you so tanned?
Yes. Puri.
Puri.
Last week, my lord.
So, you are appearing for whom?
I was the opposite party number 10.
You are the Matwali against whom the allegations
But
are.
I was the, my lord, promoter who has been engaged, my lord, for the purpose of this development work to be done. Ultimately, the resolution of the court your lordship has set aside. Pursuant thereto, your lordship also set aside the whatsoever agreement for development that has been executed between the Mutwali. But the other part is that your lordship directed that yes, the amount which has been handed over by me, that amount should be refunded. That amount is, my lord has specified in the order which I prayed for, my lord, modification, or 25,000, that is, my lord, the earnest. 25 lakhs. But, my lord, admittedly, that agreement contains a clause that I will have to pay, my lord, the all area taxes on behalf of the, my lord.
That is beyond the contempt.
Yes.
That is beyond the contempt. That's why, my lord, my application is for recalling in connection with the civil revision.
Oh, there's a recall application today.
Yes. Can 1 of 2025, which acknowledged that on behalf of the, my lord, Waqaf estate, I pay.
We have not received any copy, my lord.
No, I wish, my lord.
Nobody has received.
No, my lord. By hot haste, it
The
has been
petitioner and the alleged contempt are equally intrigued.
by today, my lord, I will serve all. So that amount is
Their
admitted.
application of modification of an order, can it be filed? I'm asking this to myself in a contempt proceeding.
No, I have not filed.
No. It's an independent application.
It's an independent application. In
So that does not, you have not sought for a modification of that portion of the order by which they were directed.
No, I am
so
not.
that remains. What is your answer?
Yes.
This is my instruction from the Board of Work, my lord. I have already complied with
You
lordship
kindly read
direction.
page 367, which contains the direction.
So they say they have passed a resolution.
For refund. The resolution is only with respect to refund.
Which page?
Like page 367. It is the third volume.
No, second volume. The second volume. I'm sorry. Page 367.
The Board of Work
is allowed on cause thereby setting aside the judgment and decree dated such and such passed by the Waqf tribunal, the impugned resolution of the Board of Waqf dated, then the consequential acceptance of scheme offered by the Motwali and resultant transfer deeds and development as well as other
Into
documents.
the alleged irregularities and illegalities.
Now, my lord, 108.
Yes.
The Board of Waqf shall immediately look into the alleged irregularities, lordship. That
you have not looked into that.
No, my lord.
Salahuddin, your gentle behavior won't help your client.
I have nothing to see.
Yes, you do that every time to the court.
No, I have nothing to see.
Now we are not to be duped.
But already.
You be gentle in your own field, in your advocacy, but your client should suffer the consequences.
No, my lord, already.
You have done nothing. Why are you giving protection to this Motwali?
No. Already, my lord, meeting was held on 27th August. Notice was issued.
Let's see when the order was passed.
If your lordship kindly.
Page 329 is the date of the
The order was passed on September 21, 2021. You are directed to take immediate steps and inquire into the irregularities and illegalities committed by the Motwali. What did you do in that regard for these long 4 years?
I have no clarity.
Then we should issue a rule of contempt.
Already taken resolution and the check.
This take resolution for refund of their money.
Refund of money.
Refund of money as well as they have also.
What steps have you taken against the Motwali?
Next meeting, they have not appeared.
No, you are in contempt.
No, 27 August meeting was called for lordship.
27th August which year?
This.
2021 September this order was passed. What were you doing for so long?
No, my lord, I am extremely sorry. This is the new incumbent has come. Incumbent has come. Your lordship's direction was.
Then we can haul up the previous incumbent. Both of you are in contempt.
That was
New incumbent, we understand, but this practice of substituting the new incumbent, this will not be in my contempt applications. No, the previous incumbent was guilty of. He is also equally guilty of contempt.
Both are on record.
Because both are on the record. Yes. What about the first one? You are not appearing for the first incumbent, previous incumbent.
My lord,
If you are not appearing for the first incumbent, then you will issue a rule.
I am appearing on behalf of the new incumbent.
I must say, my lord, I have
not
served
in the
it,
writ
but it has
petition.
come back.
Refused or
Because
what?
the address is left.
You disclose the new current incumbent shall disclose the address of the previous incumbent.
Lordship.
Do that immediately. We'll keep it Friday week.
Lordship.
Not only for this, we have
My
copies of the,
application by course of the day, my lord, I will serve
Very
both of you. একটা Xerox করে আছে।
you are for which respondent in the
I
petition?
was, my lord, the opposite party number 10 in the revisional application.
Or revision. At the outset, learned counsel for the opposite party number 10 in CO number 200 of 2021 submits that the said opposite party has filed an application for recall of the order under contempt to a limited extent. Full stop, next para. Copies of such applications shall be served on the other parties by the learned advocate in record for the recall applicant by tomorrow. Full stop. Try to do it today, but by tomorrow. Full stop, next para. Receipts in that regard shall be filed on the returnable date. Full stop, the said application be listed along with the contempt application on September 12, 2025. Full stop, next para. Learned counsel appearing on behalf of the alleged contemner, newly added alleged contemner, comma, who is the present incumbent in the post of the contemner, comma, submits that after coming to office, comma, and learning about, after coming to office and learning, after assuming office and learning about the order of this court, comma, steps have been taken, steps are being taken for taking a decision on the alleged irregularities committed by the Mutwali in terms of the order of this court. Full stop. However, comma, on the query of court, comma, learned senior advocate appearing for the current incumbent submits that he has no instruction to appear for the first alleged contemner, comma, who was in office during the relevant period of where the order under contempt was flouted. Full stop. It is evident from the records that the impugned order, that the order under contempt was passed as long back as on September 21, 2021, whereby the Board of Awqaf was directed to immediately look into the alleged irregularities and illegalities committed by the present Matwalis in respect of the estate in question, and to take appropriate steps in that regard accordingly, comma, upon giving a right of audience to the complainants, comma, including the writ petitioners, including the revisionist petitioners, comma, the Matwalis concerned, and all persons having any interest in the Waqf estate. Push up. It is totally unanswered as to why during this long period of 3 years, no steps was taken by the then incumbent in the post of the alleged contemner. First up, be that as it may, comma, since the original alleged contemner could not be served, since he has shifted office, comma, the learned senior advocate appearing for the alleged contemner number 2, comma, the present incumbent is directed to furnish the particulars of the address, current address of the original contempt, alleged contemner, who was in office at the relevant juncture when the order under contempt was passed, comma, to the learned advocate on record for the petitioner in writing by tomorrow. Full stop. Next para. The petitioners shall serve afresh a copy of the contempt application on the said alleged original contemner at the earliest, and file an affidavit of service to that effect on the returnable date. Full stop. Next para. আগে একটা জায়গায় বলেছি সেপ্টেম্বর 12 বলেছি, ওটা সেপ্টেম্বর 12 হবে না, সেপ্টেম্বর 19 হয়ে যাবে, যেখানে 12 আছে 19 হয়। Accordingly, the contempt application shall next be listed on September 19, 2025. ওই ওনার রিকল অ্যাপ্লিকেশনটা যেখানে বলেছি 12th অ্যাপিয়ার করবে ওটা 19th হয়ে যাবে।
I'm grateful.
19th
In
all-
read petition, I was not there.
No, you are not there. Sir.
I am only contempt application in for new incumbent.
What can be
Already
done?
check has already been handed over. They received
Not
the check
No,
and
no.
they will take.
We are speaking about the check which was handed over to
No.
the Mothuali.
This is the notice issued by
Those
the.
we are speaking about those checks. You এটা ফেরত দিন। You keep it on record if necessary. You just prefer file an affidavit. We have not directed you to. But please ensure that something is done regarding this irregularity.
Lordship, grateful Lordship.
Thank you. Pass over আরেকটা যেটা ছিল ওটা। এবার পর
My lord, my lord, am I audible?
25 year appearing.
Yes, Lord. No, I am 24, my lord.
24 is over long back.
My lord, I am in circuit bench of Jalpaiguri, my lord. That's why I am unable to make hearing, my lord.
Yes.
And I do not have
আচ্ছা
brief
ওটা
also.
please. We are taking up to 25. Don't disturb the court. Yes. Yes.
Lordship 25, I have filed the affidavit of service, Lordship. As per your Lordship's direction, Lordship, I have served the copy of contempt application along with the order server copy to the contemptor, Lordship.
Item bagged. They received.
Yes, Lordship. That was served, Lordship, on 18th August.
Yes. Right. What is the nature of the contempt? Let us see.
Lordship, for removal of illegal encroachment made by the private respondent that was not removed till now, Lordship, by the respondent number 4.
Just let
Lordship.
me
That
check
is
up the
item
order.
number
What order
1,
was first?
at page 13, Lordship, of contempt application.
Directing the respondent authorities to consider the representation of the petitioner as annexed. That representation was considered.
Subsequently, Lordship, your Lordship further hold that
No, representation was considered.
is for within 6 weeks from date of communication of the order to the respondent authorities, and if prima facie satisfied that there is an illegal encroachment,
To initiate necessary action.
the necessary
What,
action.
they have not initiated any action.
Nothing, Lordship.
Affidavit of service filed today be kept on record. So despite service, comma, the alleged contender is unrepresented in court today. Full stop, next para. By the order dated April 26, 2023, passed in WPA 2373 of 2022, comma, this court had directed the respondents therein, respondents in the writ petition to consider the representation of the petitioner regarding illegal encroachment of the property in question, and if prima facie satisfied that there is an illegal encroachment, comma, to initiate necessary action in due course of law on such score. They have held that there is an illegal encroachment.
Yes, Lordship.
Where is that?
Lordship, they have made a joint inquiry, Lordship. After that, nothing, Lordship, done by the contemptor, Lordship, for removal of the illegal encroachment, Lordship. At per my representation at page 11 of the writ petition, Lordship, for removal of.
From the annexure at page 20 of the contempt application, comma, it transpires that pursuant to the order of this court, comma, a joint inquiry, a notice was given to the parties to the effect that a joint inquiry to ascertain the government land in question was to be conducted on August 20, 2024 at 12 noon. Full stop. However, comma, there is nothing on record to indicate that after the said notice dated August 7, 2024, comma, any further steps have been taken in terms of the order of this court to remove the illegal encroachment. Full stop, next para. Since the alleged contender chooses to abstain despite service, comma, there is no option for the court but to issue a rule, comma, since the prima facie case of contempt of this court's order has been made out. Full stop. Accordingly, a rule do issue calling upon the alleged contender to show cause as to why the alleged contender should not be penalized in terms of the prayers made in the contempt application for willfully and deliberately violating the order dated April 26, 2023, passed in WPA 2373 of 2022 by not initiating necessary action in due course of law in respect of illegal encroachment on the property in question. Full stop. The rule is made returnable on after the vacation. Before that, it won't be possible. On November 7, 2025, at 2 p.m.
Lordship, one thing to be added, Lordship. After that notice, joint inquiry hold on 28th August 24. Thereafter, nothing.
But
said.
you have
No
not
said.
annexed anything.
Lordship, they have issued the notice. They have
Contempt
made the
application,
joint.
nothing is there.
They have. I have stated in my petition, Lordship, in contempt application.
Anyway, whatever is. Yes. আচ্ছা একটা লাইন অ্যাড করে দিও জয়েন্ট ইনকোয়ারি যেখানে বললাম না প্যারাগ্রাফটা বোল্ডে করে দিও আমি ঢুকিয়ে দেবো it is submitted by learned counsel for the petitioner that a joint inquiry was also held but subsequently no action was taken for removal of the illegal encroachment এটা ঢুকিয়ে দাও yes
my petition Milad, I had Milad initially come before Lordship Milad challenging a banning order. Now Milad on 24th November 2023, Milad had passed an order of injunction restraining Milad from not to take any steps against me, the railways. Now Milad, that was confirmed by your Lordship's order of 10th of January 2024. Now Milad, suddenly Milad, on 26 June 2025, a banning order was published Milad by the railways Milad, despite there being a pendency of Milad of this writ petition, and Milad the orders Milad are being subsisting. Now, Milad, on the if Milad kindly takes 976 once, one volume, last volume 976. To last one 976. Only one page I will show Milad.
976.
976. Yes.
Yes. What is the?
Yes. Milad, kindly see the last paragraph. Therefore, the banning will be effective for 2 years from the date of issue of the banning letter of 26 June 2025. Milad, despite there being specific order of injunction by your Lordship, Milad. Milad, now Milad, on the last day.
No, I had granted stay of what?
Stay of Milad not to take any steps against me.
You had challenged the show cause notice?
Banning, yes, banning order.
This show cause notice was dated 27 September 2023.
Yes, same. Now, Milad, two orders were passed. Milad, one Milad, the first order of injunction confirming it of 10th of January.
Yes.
Now, Milad, in the teeth of that, Milad, 26 June 2025, this banning order was passed.
Who is the alleged contemptor?
Milad, my learned senior is appearing.
Yes,
now, Milad,
no.
see, Milad,
who is the alleged contemptor? We are asking. I am asking.
Milad, it's Milad designation is Executive Director, Goti Shakti, Electric.
এই কন্টেম্পট অ্যাপ্লিকেশনের প্রথম ভলিউমটা কোথায়? এটা ঠিক আছে।
Now my lord had directed my learned friend Milad, senior Milad, to just Milad to substantiate what was the reason for violating my lord's order by the last day. Now Milad, they have filed an affidavit. Now Milad,
affidavit is of equal size.
Affidavit is Milad, no Milad.
Affidavit?
No Milad, it's not of equal size.
When we are
He wins.
Milad, when I'm cutting a sorry figure, Milad, the less I speak.
Thinner affidavit, the better chance of winning.
No, Milad, not winning, Milad. When I'm cutting a sorry figure, Milad.
No, Milad,
human error, Milad.
No,
human error, Milad. I will not speak more.
Milad, kindly see paragraph 3. He admits that there is a non-compliance.
Non-compliance, Milad. There is an error of violation. Milad.
Kindly see paragraph 3, page 2.
Milad, we are recalled also, Milad.
What is the mistake? What is the reason for?
Milad, the banning order was passed.
Milad. Yeah.
Tomorrow you will kill somebody and say they bona fide a mistake and.
Milad, that I will never do, Milad.
Not
Milad,
only that.
Give me 30 seconds, Milad. If Milad, I am satisfied.
Provided Mr. Dasgupta lets you speak.
No, Milad, 5 seconds. 7.
Provided he lets me speak.
In paragraph 3, accept there is a non-compliance. He says human error. Very good. 7.1, he gives the entire burden is being shifted by him on the vigilance department. That vigilance department has given me a wrong report.
Yes.
7.1. This was unfair.
Impede everybody, vigilance department, everybody. Let the courtroom be filled. We'll hear this matter throughout the day.
Milad, seeking Milad, as Milad saying sorry in court or milad, so sorry, milad, the human error, milad, does not make him, milad,
You're right.
justify. Milad, now, milad, I leave it to milad, my understanding.
Milord, may I?
You take your seat.
Yes.
Yes.
Milord, 2 points, Milord. I am, first of all, Milord.
What is this human error thing, Mr. Trivedi?
Milord, what happened?
It's a new
Milord?
concept. Human error, inhuman error, artificial intelligence error.
No, Milord, it is just a word which I.
What is the error here?
Milord, what happened, Milord? This matter, interim order was passed by my lord. It was confirmed till the disposal of the writ petition, Milord. Affidavits had been exchanged, Milord. Now, Milord, what had happened is initial order, which was, Milord, stayed by my lord, was passed by Chief Electrical Engineer MP Central Organization Railway Electrification Prayagraj, who was a party to the main petition, but the contemner herein, who has issued this notice due to error, was not a party to the main writ petition. One, my lord, but I am not saying that that is, my lord, will kindly let me complete, my lord. Now, my lord, what has happened is, my lord, this particular letter was my lord, it came, my lord, and a note was not there that there is a prevailing order passed by this honorable court, my lord. So, my lord, because that note was not there, as a matter of human error, my lord, it was issued. But then, as soon as we realized, my lord, we rectified it and we recalled it, my lord, before, my lord, this contempt matter could come before my lord.
Sir,
and that is
milad, not before that. Milad, when my client flew to Delhi on the morning flight, served the this matter, when I mentioned before the lordship that it has been served, then when the matter was listed, they withdrew.
Yes, my lord.
To save their skin. This is this is incorrect.
Yes, I'm not saying, my lord. Yes, my lord.
Under
I
rule
am
should be-
saying, my lord, it is with deepest of respect, my lord, we are rendering unqualified apology, my lord, in our affidavit, my lord. This has been a mistake on our part. Lordship will kindly.
How did you rectify?
My lord, we said that that was due to, my lord, which we have on.
This is uploaded on your websites also.
No.
Any other authorities? Not?
No. No, my lord, nothing, my lord. It happened and we recalled it, my lord.
When did you recall?
After it was contempt was served.
My lord,
After the-
7.5.3 of my affidavit, my lord, will kindly take it.
Yes.
Page 10, my lord. My lord, it starts at page 9.
Right.
My lord, may I read it, my lord?
Yes.
Paragraph 7, that when the facts came to the notice on 2/7/2025, it emerged that the banning order of 26/5/2025 had been issued due to inadvertent and bona fide mistake because of non-linking of the solemn interim order dated 24/11/23 passed by the Honorable. Accordingly, immediate corrective action was taken by withdrawing the banning order and ensuring due compliance with the Honorable Court's direction was ensured without delay immediately on 3/7/2025. The banning order on the present writ petitioners was withdrawn in the evening of 3/7/2025, and withdrawal of the letter dated 26/6/2025 was communicated by the Gati Sakti Directorate in late evening of 3/7/2025 to all concerned, including the present writ petitioner. This was also conveyed on 4/7/2025 to their learned advocate on record. My lord, we rectified it. My lord, as soon as, my lord, it was because the departments, my lord, inter-department, my lord, there was lack of communication, my lord, and this incumbent, my lord, was not there, my lord. Therefore, I started it, my lord, and he did not have knowledge, my lord. My lord, I beseech, my lord, to give us this, my lord. My lord,
Yes,
it was served on 2nd of July.
My lord,
They are saying that after service they looked into the matter and saw this, and this was a different officer. Banning notice was initially issued by some other officer, some other department.
Milad, my company is a listed company. Immediately, banning Milad order was passed. Milad, I lost my prices in the Milad, I pleaded those. And Milad, because of 2nd of July, when I served Milad physically, thereafter 3rd of July, it was recalled because I have written
penalty for contempt, you cannot impose more than 2,000.
Milad, kindly Milad issues a rule. I don't want anything. I don't want anything. It Milad, this is Milad the conduct.
Not malafide.
Milad, if
This is
this
not
is
malafide.
Milad, this
May
Milad
happen.
2023.
If there's an iota of doubt, benefit should go to the
2023, Milad.
They have since purged. They have withdrawn the letter immediately after coming to know.
No.
Of the
Milad, withdrawn this letter. When? Kindly see my affidavit of service.
You don't have a right of hearing in any event. It's between us.
Only Milad, I'm assisting your lordship with the
We are
documents.
not seeking your assistance.
Milad, kindly see the affidavit of service once.
No, they're admitting after getting notice of contempt, they have done it.
After serving, yes.
They're admitting that.
Yes.
On oath.
That matter was fixed on 4th. On 3rd, they have withdrawn.
Yes.
23 তে order হলো কেন
The
কেন notice issue করলো কিছু বলবেন না?
present application for contempt.
May I seek only one indulgence, Milord?
Yes.
Milord, subject to correction, Milord, I leave it to your lordship completely, Milord. If last order says that they have to explain and what prompted them. Perhaps, Milord, this affidavit does not consist that. Perhaps, Milord.
What prompted them?
The present out of an order dated November 24, 2023, passed in WPA 26136 of 2023, whereby it was observed that since a strong prima facie case has been made out by the writ petitioners, the writ petition should be heard on merits. Simultaneously, the railway authorities were restrained by an order of injunction from precluding the petitioners from participating in any of the tenders floated by the railway authorities. In the meantime, on the basis of the impugned suspension, subject of course to the petitioners otherwise meeting the eligibility criteria. Despite such order and in the teeth of the same, on June 26, 2025, the alleged contemner made a communication banning the petitioner for 2 years from the date of issuance of the banning letter, from participating in any tender process of the railways. Learned counsel for the petitioner is justified in arguing that prima facie, that the said order, the said banning order, in the teeth of the restraint order of this court is outright violative of the order of this court. The question which arises is whether the said act was done in willful and deliberate violation of the order of this court. Next para. On the last occasion, an opportunity was given to the alleged contemner to explain as to why the said act was done by banning the petitioner despite the order of this court. In the affidavit of compliance filed today, it transpires that the alleged contemner has cited a communication gap inter-department, the railways. It has been stated that the case was received from the Vigilance Directorate on June 3, 2025. Next para. The Gati Shakti Directorate of Railway Board, of which the alleged contemner is the executive director, took action on the basis of the said report of the vigilance and processed the case, and a file note was put up by the office of the Gati Shakti Directorate proposing banning of business of railways. Thereafter, following due process, the banning order, the incriminating banning order dated June 26, 2025 was passed. It is further stated in the affidavit of compliance that in the afternoon of July 2, 2025, a contempt notice dated July 1, 2025 was received from the learned advocate on record of the present writ petitioners. Next para. After receiving the contempt notice, the matter was examined in detail with reference to the order of this court, and it came to light that while the inquiry arising out of the vigilance investigation into the alleged misconduct by the writ petitioner was ongoing, CORE CAPSE had issued a suspension order for banning of business of railways with the writ petitioners with the order dated November 8, 2023. It is also stated that when these facts came to the notice of the alleged contemner on July 2, 2025, it emerged that the banning order of June 26, 2025 had been issued due to inadvertent and bona fide mistake because of non-linking of the order of this court dated November 24, 2023, and accordingly immediate corrective action was taken by withdrawing the banning order and ensuring that due compliance with the court's direction was ensured without delay, immediately on July 3, 2025. Full stop. In the evening of July 3, 2025 itself, that is a day after coming to know of the order of this court, and a letter of withdrawal was a letter of withdrawal of the banning order dated June 26, 2025 was communicated by the Gati Shakti Directorate to all concerned, including the present petitioners. Full stop. This was also conveyed on July 4, 2025 to the learned advocate on record of the petitioners. Full stop. In the affidavit of compliance, the alleged contender has also tendered unconditional and unqualified apology for the omission. Full stop. Next para. Upon a consideration of the submissions of parties and going through the materials before the court, including the averments made in the affidavit of compliance, this court is satisfied that there was no malafide or deliberate or willful intent behind the act of issuing a further banning letter on June 26, 2025 in violation of the order of injunction passed by this court. Full stop. Apparently, there was a inter-department communication gap, which led to the said letter being issued by the alleged contender, who was not the same official who had issued the initial order of suspension, which has been challenged in the writ petition. Full stop. That apart, since apology has been duly tendered, which does not transpire merely to be a facade to cover up the malicious intent of the alleged contender, I am of the opinion that the benefit of doubt should go to the alleged contender. Full stop. Particularly in view of the perceived contumacious act having been purged by issuing a withdrawal letter on July 3, 2025, that is within a day from the alleged contender coming to know of the order of this court, and the contempt issued in connection and the contempt application filed in connection therewith, the alleged contender should not be further penalized penalized for contempt. Full stop. In view of the above observations, CPN 1162 of 2025 is disposed of as infructuous. Full stop.
I'm grateful.
Thank you. You're becoming sadistic.
No, what?
In every matter.
Instead of
Dispose of. Should I dismissed?
No, only disposed of infructuous.
Disposed of.
Dispose of. In the light of the above observations.
Grateful.
I'm grateful.